Hello and welcome to Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are continuing our coverage of Florida versus Mario Fernandez Saldana. We are in day 5, the end of week 1, and should be an interesting day, a full day. Trial went late yesterday. They went an extra hour, about an extra hour and 5 minutes. So I'm not exactly sure what's going to happen today, but it should be a good day. So let's get comfortable, let's settle in, let's get started. All right, good morning, everybody. How's everybody doing today? I have something special to show to you guys, so I want to get right to it. Don't want to show you that. That's not special. That's just that all over again. That's just the disclaimer. All right, here, check this out, you guys. So here's Mario's YouTube page. So here's his YouTube page. Remember, he's a gamer. So we found out that he is a gamer. So these are the games that he goes and plays. Let's see. Why can I... So here's some videos that he has.
I'm ready. You ready?
This is all right, so this is what he does. So he basically just plays this is what he does. So he's a gamer. He has 2 subscribers, another chicken run, but he's at 50%. So this is what he does. So I thought you guys would want to see this. There, he's got a big old dog. He's got 2 subscribers, 26 videos. So thought you guys might appreciate that. A little peek behind the curtain there of Mario Fernandez Saldana. And in the meantime, oops, we do have a feed here, so we'll just get over here. So yeah, so there you go. That's what he does. Well, among other things, but in his free time, spare time, that's what he does. Or at least that's what he used to do. Not sure if he does it anymore. I guess he doesn't do it anymore. He doesn't play in jail. All right, who's with us while we watch Mario come in? We've got William. Welcome in and good morning to you. Camilla and Dina, hello. How are you guys? Hell Rider. I was going to say, hey, Hell Rider. Horse Welfare, hello. Welcome in. We got Kimbers, my cat's mom. How are you guys doing today? Iowa Backyard Cam, good morning. Tammy and KS, hey, Shirley. Good to see you. Hope you're feeling better. Sherry, good morning to you. Great to see you. Tao Tao, good morning. Good morning. Green Eye Cat saying happy Friday to everybody. Pizza Friday and Friday. Great to see you guys. Linda, good morning. Thank you for joining us. We've got Brenda coming on in. Debbie, good morning. I did sleep well. Shirley, I hope you get home soon. Kimbers, good morning, good morning. Welcome in. Hey Sharon, how are you? Great to see you. Camilla saying good morning to everybody. Let's see here. Who else do we have? Kaylee, good morning to you. Welcome in. Seashell, how are you doing? Shirley Knott, good morning from Idaho. Christine and Henrietta coming in. Beginner Crafter, good afternoon from Poland. How's your day going? Carlite Angel, good morning and have a great day and a happy weekend. You as well. Let's see here. Christine saying hello from Scotland. Hey Ruth Ann, how are you doing? Great to see you. Grizzly Trial TV Live Grandma, good morning, good morning, good morning. Hey Ruth Ann. Let's see. Oh, we got Joy Ashley coming in. Angela Wright, good morning to you. Hey Shannon, welcome in. Lazy Boys, you're playing MMO right now? Nice. All right, hey Treasure Hog, how are you doing? Texas Law Cat, great to see you. Thank you for joining us. Beach Mom, welcome in. Yes, Seashell, TGIF. Indeed, indeed. Hey Grampy, how are you doing? Michelle, good morning. Welcome in. What the Healer, great to see you. Jax Cooks, good morning. What do you cook? I'm assuming that you're a chef somewhere, or do you just like to cook? Hey Rev Ben, good morning. Still off today, still watching? Thank you for being here. All right, I think I got everybody. Oh, there's Janice, good morning. Liz, good morning to you. Great to see you. Tumwater Troy, good morning to you. Yes. May you live long and prosper. All right. Hey, Richard, good morning from Jax. Great to see you. Thank you for joining us. Got a local in the house. You cook nothing. Oh, you married into the last name. Gotcha. I gotcha. Thank you for correcting my assumption. Appreciate that. All right. So yesterday, here comes Mario. Yesterday we left off with Agent Bobby Blythe. He was the cell phone data guy. And here I thought I was way wrong on that. I thought, well, everybody knows Henry did it. Everybody knows that Mario and Henry, landlord, tenant. Everybody knows that John Biggerstaff and Mario knew each other. Everybody knew that Henry Tennant and John Biggerstaff knew each other. So everybody knew all this stuff. I'm like, what are they going to bring in with cell phone data? We all know that. We all know that they knew each other. We all know that their phones would probably be located with each other. Little did I know that on the night of, between like 7 and 10, both phones, actually Henry had two phones, but Mario's phone goes silent and Henry's phone goes silent. His two phones go silent. And don't you know that the incident took place at 7:52? So quite a coincidence. Is that enough for the jury to convict Mario? We shall see. But then Henry had two phones and his phones separated, but then they came back together and they were communicating with each other. So was that Mario on Henry's phone? He left his phone at home, put it into airplane mode, and or just turned it off completely. And then he was using Henry's phone. Did he have a burner phone? I mean, there's obviously all kinds of questions that we don't know the answers to. But I really thought that Mr. Blythe there, his testimony would be like, okay, all right, get it. But it ended up being, I thought, pretty significant. Kaylee, I love it when the evidence sneaks in. I agree. Little did I know that it would be like, wow, that's very interesting. Is that a coincidence? Or did it actually lead somewhere? Rev Ben, I'm not a big believer in coincidences in these situations. It seems so coincident. Debbie, thank you so much for the $4. Cup of coffee. Appreciate that. Let's see. William, this is good evidence. Yeah. It ended up being, what's the jury going to do with it? I mean, it's pretty much saying that, and they showed a couple graphs. Mr. Blythe there, or agent, I should say, right? Agent Blythe, right? He's a special agent, FBI agent. He showed a couple different graphs. So, even Ms. Stifler said, for those that are visual, I thought it was pretty interesting the way they charted Mario was very active during a specific time, and then all of a sudden there was no activity for that period of time on that Wednesday. So I'm sure the defense will spin it, and I talked about this yesterday. I'm sure the defense will say, well, there's nothing that says it's not a crime to turn off your phone, right? It's not a crime to not have activity on your phone. And that's true. That's true. It's very true. It's not a crime unless you're doing a crime and you're active before it and after it, but during it, you're not active. Is that a crime? No, but it does certainly throws suspicion onto you. So, Jax Cooks, thank you. What the Healer, awesome. What the Healer, welcome in. What the Healer, I think you're still with us. Are you still with us? What the Healer, thank you, Jax Cooks, appreciate that. And What the Healer received a gifted membership. I love it. I love it when people are in our chat that get gifted memberships. Shannon, thank you so much for that. Oh, I got an itchy nose. Sorry. Shannon, thank you for the 20 jewels. Appreciate that. Angelique, good morning to you. Liz says, what I did not understand was the March 2nd track. What was that about? The March 2nd. Is that when he went up to, that's when he left. All right, I believe that's when he went to Pittsburgh. That's when he left to go see his friend, yeah. Mario's phone travels north. That's when he went to go see his gaming buddy up in, I think, North Carolina. What was his name? Victor? I think Victor Quiroz. That was his gaming buddy. So he took his dog, I think he took his dog with him, I think. And then he went up to North Carolina to visit his buddy, and then he ended up in Pittsburgh, and then he came back down. So just him leaving town, basically. I think that's pretty much what that was about. Deb in Indiana, Shannon was like Wendy, distance herself. That worries me. It's going to be interesting, and she's got a good defense. She's got Jose Baez, so we all know what his deal is. So it's going to be very interesting, Shanna's trial. I will definitely be there for opening statements. I'm going to go to closing statements for Mario too. So I'll get you guys in the courtroom there. I'll give you some insider courtroom info. And if today was anything like yesterday was spicy. Super Ball just walked by and cat fur up my nose. If today is anything like yesterday, things got very spicy with Mr. Mizrahi and Mr. Hill. Aaron made a short and a video on that, so that got pretty dicey, pretty spicy. That's for sure. Let's see, Horse Welfare. How are you? Did I say hello to you already? If I didn't, hello, welcome in, Horse Welfare. How are you doing? Ruth Ann, all these videos the defense kept playing never showed Tennant doing the roof or landscaping. That is true. That is true. Although you wouldn't really see him doing roofing because of the trees. I don't think you would have seen him do that. Landscaping, you would have seen him mow. Yeah, you would have definitely seen him mow. You would have seen roofing, lumber, tile. He did bring in tile for the bathroom, but you would have seen Mario bringing in tile. If he was doing shingles, I should say. You would think he would be bringing in some kind of supplies for the roof. And you would have seen him mowing the grass. And yeah, you absolutely would have seen that. He would have absolutely seen that. I agree. Thank you, Jax Cooks. Appreciate you. Sherry, I changed my mind because we want to show day 2 afternoon of Dwayne Davis tonight, and I wouldn't have been able to do that if I was there today. So we made an executive decision to focus on Keefe D later today. I'm going to go. I'm going to because my nose is itchy. My initial plan was to do opening statements and closing statements. So I'm going to stick to that opening plan. And but with Shanna, I'm going to do openings and closings and possibly get over there maybe 1 or 2 more times. Liz, thank you for the sunshine. Really appreciate that. Thank you so much. Oh, Grampy. Wait, what's Grampy? 36 years? What's that? Grampy, what's your what are you celebrating? I don't want to guess. Sherry, I think I answered you. Yeah, I'm not going. Not going today. Shanna's attorney will throw Mario under the bus, back up, and run him over a second time. You know it. You absolutely know it, for sure. Hey, Ladybug's mom. How are you? Hope you listened to some Molly Hatchet last night. Sherry, yes. I decided not to for the Dwayne Davis. Rev Ben, lawyers had some feelings yesterday. That is for sure. That is for sure. That is no doubt about that. Shirley says he complained to his gaming buddy about how much a tree guy was estimating, but he pays out $10,000. Yeah, that's true. Kaylee, we need to start a fund to get a helicopter. That would be. Oh, here she comes. All right, we got court.
Good morning. All right, we're here on in the morning session. If the attorneys will place their appearances on the record.
Christina Stifler, Alan Mizrahi, and Steve Siegel on behalf of the state of Florida.
Good morning, Your Honor. My name is Jesse Dreiser. I'm here with our client, Mr. Fernandez, Mr. Hill, Ms. Nepsat, and Ms. Day. Good morning.
Thank you. Good morning. All right, is there anything we need to take up prior to bringing in the jury?
Ma'am.
All right, thank you. Let's bring in the jury.
Boy, Judge Kite looks like she's already running behind. She looks like she's already like something. I hope nothing happened. She just seems like she's already running behind. You know those days when you're just running behind, you can never catch up. Theresia, how are you?
My palms still get sweaty.
Is the witness close by? Yeah. Thank you.
Yeah, probably.
Your Honor, the Jews are entering the courtroom.
Thank you. All right, good morning, members of the jury. Welcome, and good morning. Everyone may be seated. All right, members of the jury, before we get started with today's portion of the trial, could you all please confirm and answer out loud that you follow the communication rules over the night's recess?
Yes.
Okay. To remind you where we are, I keep saying detective. Agent Blythe was on the witness stand. I'm going to ask that he be called back to the stand. Good morning, Agent.
Good morning.
Since the night's recess we're into a new day, if you please raise your right hand to be sworn in.
Agent, do you solemnly swear from the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right, this way. All right, Mr. Dreiser, you may proceed with cross-examination.
Thank you. Good morning, Agent Blythe. How are you?
Good morning. I'm well. You?
Fine. Thank you for asking, and thank you for being here, okay?
Absolutely.
Yesterday, we had a little bit of an opportunity to get to know you and your background. And of course, you are an agent with the FBI, right?
Yes, sir.
And you have a pretty impressive academic background. You have a degree in, I think, business.
Yes, in accounting.
And then you have some experience in the real world and experience in law enforcement, combining all those skills, right?
Yes, sir.
Okay. And I think we can agree that let me say the one thing you don't have, and I'm not knocking on you, but you're not an engineer, correct?
No, I'm not an engineer.
And you don't work for T-Mobile, correct?
No, I do not.
And a lot of what we're talking about is the engineering of cellular networks.
Yes.
Okay. So can we agree that the work that you do is important in cases like this?
Yes, very.
And can we agree that accuracy is important?
Yes.
And I don't know if you told the jury yesterday, but not only do you review these reports before they're submitted, you have a peer review. You have someone else look at the reports, right?
Yes, sir.
To make sure they're accurate, right?
Yes.
All right, let me just and I'm going to walk you through everything. I'm not going to cherry pick, but I want to show you slide 56. This is from March 5th between 9:12 and 9:50 p.m., correct?
Yes.
And yesterday you talked about the TA records associated with that, but if you look in the call box, those TA records seem to be from 2/17 of 2022, correct?
Yes, so there's a typographical mistake in the call-out box.
So that's a mistake that you made before you submitted this evidence to the government?
Yes.
And the peer review person, he didn't catch that either?
Apparently not.
And as you sit here today, is it a typographical error, or did you put the TA records from 2/17 inside of the PowerPoint?
I'm confident that it's a typo in the call-out box for the date. I didn't replace the date with March 5th. I apologize.
Okay. And while we're here, this is about a Pennsylvania trip that Mr. Fernandez took?
Yes.
Anybody ever tell you why it was important whether Mr. Fernandez went to Pennsylvania and came back?
I don't recall why that was important.
Important enough that you mapped it all and put it in your slides, right?
The investigative team thought that time frame was important to show the location of the target device, so I prepared a map as such.
Okay. Not your job to know or say why it's important, just map it if they tell you to.
So yeah, the investigative team it's their investigation. They're informing me about what times are pertinent that they need to show movement or a location for the device, and so that's what I'm looking to as far as guidance about what time frames I look at.
Simply put, you mapped that Mr. Fernandez went to Pennsylvania. Well, first he stopped in North Carolina, right?
Yes.
And are you aware that the jury has heard from a friend of his that he stopped at his house in North Carolina?
I am now.
You are now, because I told you?
Yes.
Okay. And on the same dates that you mapped, and then he, if I understand correctly, he went up to Pennsylvania, and I think your testimony, these are my words, but he sort of hauled ass back to Jacksonville.
He wasn't there a very long time and came back.
Came back pretty quick, right?
Sure. Some people move at different paces.
Yeah, but I mean, I think what you were saying to the jury yesterday was he was up in Pennsylvania and then he kind of moved back relatively quickly, like he didn't have a lot of stops, right?
Yeah, there was a 3-hour stop, was the biggest, most notable stop during the way back that I recall.
But just so I'm clear, Jacksonville is where this homicide occurred, right?
Yes.
And he came back to Jackson.
Correct.
Okay. All right, let's start at, well, I want to show you, did you notice yesterday when you were going through your slides, this is I think you did 5 drafts of these before you made a final?
At least.
At least 5 drafts, right? And every time you did a draft, you would provide it to the defense team through discovery, right?
So I provided to the state, and they provided the discovery to you.
Then they provide it. So through the course of this investigation, every time you did a draft, we would have to do, at least you would think it's fair that we would do an analysis of your draft, right?
I would hope you'd review it.
And if we had an expert, which I think you know that we do,
Yes.
He would have to review it, correct?
Sure.
So I assume at some point in time during this trial, when the state gets up and asks questions to my expert about why we had to pay him so much money, would you agree that every time you did a draft, you would expect it's fair that he would review your draft, right?
If you ask him to, sure.
Sure. And it would be reasonable for us to ask him to review your drafts, right?
It's something that, a layperson could easily misunderstand. So it's understandable you'd want to talk to somebody with knowledge of the profession.
Sure. And can we also agree that going back to you looking at these things and making sure that before it got submitted into evidence, it was up to speed? This is your final, correct?
It is.
Did you notice on about a third of the slides that are in evidence, they're still stamped draft?
A third?
Let's go to page 21. See draft? Can you see that, Agent?
I do.
Go to page 22. See that?
Yes.
23? 24? I mean, I'll let the jury, it's in evidence, but significant portion of your final is still submitted draft. Is that another mistake that should have been taken out?
In preparing over the past month or two, I noticed some things that we wanted to modify somewhat. Didn't change the conclusions or the overall locations or anything like that, but I had somebody take a second look at them after I made some changes, and I forgot to take the draft stamp off.
Okay. You go to January 5th, please. Start slide 8. This is January 5th. You would agree that this is at 10:56 to 11:51, and it shows that Mr. Fernandez is in the area of his house.
Yes, same geographic area.
Not unusual for a person to be in the same geographic area of their home, correct?
No.
This doesn't tell you anything about Henry Tenen or anything about Mr. Fernandez other than he may be home, right?
Correct.
Next slide. All right, now we jump hours later, right? This is like 5 hours later.
Yes, 5:24 p.m. is when this starts.
Okay, and this is Henry Tenen going to the area of Jack's Beach, correct?
Yes.
All right, so now you don't have any information as to where Mr. Fernandez is on January 5th, do you?
No, not during this time frame.
You have no idea whether Mr. Fernandez saw Mr. Tenen when he came near the Jack's Beach area, correct?
I don't have any independent knowledge of that.
Yeah, you have no communications between the two of them on January 5th, correct?
Not that I've been made privy to.
You can't tie Mr. Fernandez to Henry Tenen on January 5th in any way using technical data or records that you have obtained.
Not with these phone records, with cell site and Gmail records.
Okay, and most importantly, on this day, Henry Tenen goes in the area of Jack's Beach near the Pablo Hamlet area, the Fernandez residence, right?
Yes.
You need to see that, or you agree with me?
I recall that.
Okay. But do you recall that he doesn't go anywhere near the crime scene?
I think that not on this date and time, no.
Yeah, that's what I'm asking you. On this date and time, January 5th, he doesn't go anywhere near the crime scene, right? And you do know, even though you're not, I guess you're part of the investigative team, but you're more the mapping guy, right?
Yes.
But you do know that there is a connection between Mr. Fernandez and Henry Tenen, because Henry Tenen was his tenant at that time, right?
I've heard that at some point he was his tenant.
Sure. That's not like a secretive fact. And if I understand your slides, Mr. Tenen goes to the area of Jack's Beach, and you think that maybe, and can you go to the slide of the Marsh Inlet? He goes down, passes Pablo Hamlet, he passes Marsh Inlet, and he turns around and he comes back, correct?
Yes.
And if he is on the street, can you go to the one where it shows that he may be on...
Mr. Dreiser, if you would, just for record purposes, refer to what slide you're referring to.
I should have done that. I'm sorry. This all is composed of states 190, 182, and specifically, I'm asking Agent Blythe about page 12.
Thank you.
Page 12, this is where, different than many of your other slides, you don't have any confidence level on any of these slides.
No, not on these four.
This entire slide, which is the one that zoomed in the most, has no confidence on any one of Henry Tenen's factors, correct?
No.
But nonetheless, you decided to map that you think, without any confidence, that Mr. Tenen may have gone on the street of the Fernandez residence, correct?
That was the recorded location, and throughout the duration of the analysis, I was able to see that these locations, with or without a known source, followed in line, stayed along roadways. They weren't errant off in the middle of nowhere, or a place where there was no roadway, or a place where a person and a phone could be. So looking at them in their totality, they all seem to be very reliable locations.
Even if you're right, which you may be, he's on the street for what, 30 seconds at max? I mean, if you're exactly correct, and your totality of the circumstances all added up, you can't put him on that street for more than 30 seconds.
Correct.
So, and you have no reason to believe that Mr. Fernandez was home.
I don't know.
You have no idea, right?
No.
And you don't know if Mr. Tenen was dropping off rent money in the mailbox.
I don't know that.
You don't know if Mr. Tenen was scouting the area because he planned to kill Jared Bridegan. You don't know that.
No.
You just know that he's in the area. And the one thing we do know is that the Marsh Inlet and the area of interest does have evidentiary value in this case, correct? That area has interest, right?
Sure.
Mario, and we're going to talk a little bit about this, Mario Fernandez's home is close to Marsh Inlet, correct?
Yes.
And I'm sorry, I did not say that correctly. Mario Fernandez's home is close to Pablo Hamlet, correct?
Yes.
Okay. And it's so close that it's hard to make any sort of data location because it's so close. It goes within the area of the bands that make it to where the technology just isn't that precise, correct?
That's fair.
Okay, and we'll talk about that later. Let's keep going. Let's go to the next day. And that would be January 25th, correct?
Yes.
And on January 25th, I mean, this has so much data on it, but let's just break it down so simple so the jury knows what they're looking at. You believe on January 25th that Mario Fernandez went over to John Biggerstaff's house.
His phone moved to that area. He used the tower closest to his house and had a calculated distance, roughly the same distance from the tower as the house was, which is consistent with him being at the residence.
It's a great point. You don't track people, do you?
Well, phones don't move themselves, but people have their phones. Research shows that we keep our phones within arm's reach the vast majority of the day. But yes, technically I'm tracking phones.
So Mr. Hill in his opening statement told the jury just that. He said that studies show that people keep their cellular devices within arm's reach. That's what you guys rely on, correct?
Yes, that's how we find people all the time.
Exactly. I don't want to jump the gun, but on the 29th, you don't have Mr. Fernandez's device anywhere except for the Potomac address, correct?
That area, yes.
Yeah, I mean, he goes from his house to Potomac, but the phone never leaves Potomac, correct?
On the 29th?
Right.
Correct.
So by the studies and by what you're aware of and everything you're trained on and how you locate bodies and guns and all the things that you say that you've been so successful doing, it's because people are generally within arm's length of their devices, correct?
Usually, but sometimes people intentionally leave their devices behind in cases. Sometimes.
They do. And that's when you have to use what you said yesterday, which is other investigative efforts when you're doing historical cell site analysis to see if you can confirm whether people have done that, correct?
If you can.
All right, we'll get there. But on this day, Mr. Fernandez goes to what is known as an old friend of his, correct? You know
Biggerstaff?
Yeah.
And my understanding is they are associates of some kind.
Yeah, they've known each other for a long time.
Okay.
Okay. And on that day, you know that Mr. Fernandez called Mr. Biggerstaff on his way over there. Because in all that data, it actually shows a call from Mr. Fernandez to Mr. Biggerstaff, right?
Yes.
Before he gets there. Like, hey, I'm on my way, right? You don't know what it said, but that's not far-fetched that someone would call and say, I'm on the way to your home, correct?
No.
And then right when he gets to the house, there's a message or a call saying, well, you don't know what it says, but it's right when he gets there, not far-fetched to be like, hey, I'm here, man, right?
Yeah, I don't know why he called him, but
yeah.
Could be.
All right, so he's there for like an hour or so, and then he leaves, right?
I don't remember how long he's there. I think it might be the next slide. Yes.
All right. This is slide 16, Your Honor.
Thank you.
And you don't know why he was there?
No.
You have no evidence what he was doing there?
No, sir.
Someone just asked you to map whether Mario Fernandez was going to a guy's house that he knows for a long time. He left. That's what you know. That's what all of this information tells you, correct?
Yes.
All right. Let's go to January 29th. Okay, on this date, we're on slide 19. I want to talk about some ground information that I'm not sure that you said yesterday. Anytime the location of interest or the address of Potomac or anything on these slides, anytime, would you agree that your testimony, a golden rule, is it can never be farther than the bands?
Very rarely, and if it is, we're talking less than 2% of the time, it's usually explainable because, for example, if you had a huge building like this courthouse and the antennas for the cell site are on different corners of this rooftop, it's huge. So if the latitude, longitude for the tower is dead center in the middle of the building, the antennas are on different corners of the building, that timing advance band could look a little farther away than it really is, or closer, depending on that layout. So usually you can reconcile that if you actually find a phone outside of the band that was displayed. So
maybe not a golden rule, but a pretty good rule of thumb that
yeah.
It's never outside the bands, correct?
Yeah, it's very rare.
But on the inverse, when there's one band, it can be one or two bands inside.
Yes, that's possible.
Of course, that's not only possible, you know that to be the case, right?
Yes.
If I say that the Mario Fernandez residence is right on the border of a band in some of these slides,
yes,
you'll agree with me every single time that it's in the parameter of one or two bands, so it's in the timing advance bands.
Yes.
Okay. The other thing that I'm not so sure was clear yesterday, in these pink bands, and let's use slide 19 as an example, anytime you may have a dot inside the pink band, but you have no idea where in the pink band the device is.
So are we talking about these These dots are from Henry 10 and 53. These aren't timing advance estimated locations.
Glad you pointed that out. I want the jury to be very clear. I'm not talking, and I didn't say this, so thank you. For these golden rules and concepts I'm trying to iron out, I'm not talking about the GPS stuff. That's different than timing advance, right?
Right. These are two different people's devices on this slide.
And two different technologies, right?
Yes.
So because you don't have any GPS for Mr. Fernandez, let me make it clear. When Mr. Fernandez's devices are in any of these pink bands, you have no idea where in the pink band it is.
Yeah, so when Mr. Tennant's device is inside that band, it doesn't, just because it's inside the same band where Mario Fernandez's phone is, that they could be together, they may not be together. It's potential co-location. Is that what you're asking me?
I really wasn't. I'm not asking you anything about Mr. Tennant at the moment. I'm asking you for Mr. Fernandez. In all of these records, you're using TA analysis because you don't have GPS for Mr. Fernandez, correct?
Yes.
So what I'm trying to do is just get some global ground rules so the jury understands this. That device can be anywhere in a pink band, like at the very, very bottom of slide 19, where the pink bands end, or the very, very top. You don't know. The technology isn't that good.
Yes, in isolation, the phone could be anywhere in that band, from one side of the sector to the other, to answer your question. However, if you have an intersecting timing advance, that's not the case here. But when you do, if it's close in time, you would look at that area of intersection to narrow that area.
For example, in this one, most of the slides, it could be anywhere in the pink band.
Yes.
Right. And the other thing that I want to make sure is crystal clear, that if Mr. Fernandez's device is in his pocket, okay, and Mr. Fernandez is in his driveway and he's sweeping, you have no idea the movement of the device within the pink bands, correct?
No.
If Mr. Fernandez he walks from the kitchen to the end of the driveway to throw a bucket of water out, you cannot do, this technology doesn't work like that, correct?
Yes, no, it doesn't. It's not that precise. It's good enough to help us find people many times, but it's those bands are 78 meters wide. So that's the confidence of it.
So when you're showing all this information from January 29th and it's just like TA, it's not like you know that the device is stationary and not moving. You can't tell that.
So when maybe I say stationary, it's staying in the same area, defined area that we can define by those bands. It doesn't necessarily mean it's sitting still, perfectly still on one exact location.
That's exactly what I'm asking you. Can't do that, right?
Right.
Now, we'll get to some precise stuff in a question. The other thing that I just don't think I heard this word come out of your mouth one time yesterday, and you correct me if I'm wrong. Did you ever say the words Wi-Fi yesterday?
Yes.
You did? Okay, thank you. There's a caveat when there's Wi-Fi, isn't there?
What do you mean?
Meaning that if a phone is connected to Wi-Fi, then there can be calls and texts that this wouldn't catch.
So the calls generally make their way to the call detail records if they're over Wi-Fi, but if a phone can also use data over Wi-Fi, and that could carry the data sessions rather than the cellular network.
Right, so it's possible that a person could be making calls or text messages or doing video gaming, and you wouldn't have a record of it if they're connected to Wi-Fi.
So the data sessions would therefore be carried by the Wi-Fi, the internet service provider,
Sure.
And it wouldn't show data throughput with the cellular network. If they made calls or received calls, those would make their way to the records.
They may make their way to the records. They don't always make their way to the records.
They usually do, but it's possible.
It's possible that they don't, right?
Sure.
Okay. And you know, and we don't have to guess, even though we have photos, I'll show you in a second, that there is Wi-Fi at the Potomac address.
Maybe there is. I'm sure most people have home-based Wi-Fi.
Well, we don't have to say maybe, because you did the tracking of Henry Tennant's devices, and the data that you used at 2 o'clock for the geolocation of Mr. Tenen, and if you need your records to look, I'll be glad to, you used Wi-Fi. That was the source of the GPS at 2 o'clock.
I guess all I'm saying is I don't know if it connected to Mario Fernandez's Wi-Fi, but there's enough Wi-Fi access points around there that the phone was able to generate a Wi-Fi-based location.
All right, let me pause you for a moment. Members of the jury, I need you to go into the jury room, please.
Oh boy, what happened? That came out of nowhere. Yeah, uh-oh. What the heck happened? They were talking about a Wi-Fi and GPS. What just happened?
Agent Blythe, I'm going to ask you step outside the courtroom. Everyone may be seated.
Yes, ma'am.
Mr. Fernandez needs to go in the back. I need Miss Bridegan to step up, Mr. Clifton to step up, and get Kirsten Nelson on the phone. On Zoom, switch over. If the state would clear the way so they can have a seat.
I don't know what's going on, but they send Mario out. This has to do with Shanna. This has to do with Shanna because Kirsten's coming up, Clifton's coming up, her
Do you
lawyer.
want to call your appellate counsel? They can join via Zoom. Ms. Bridegan, you can sit down. It's okay.
All right, we don't
Print
know
a copy of the order of compliance.
All right, I don't want to talk over Judge Kite, but Kirsten, she brought Kirsten Bridegan up. She brought Doug Clifton up. That's her representative. She got Kirsten Nelson on via Zoom. She sent witness out. She sent Mario out. She sent the jury out. She was not happy coming into court either. Remember I said she looked flustered? She looked already, she was behind. So let's just watch together. Let's see what happens.
Okay, thank you.
Mr. Clifton is there. That's him standing up. Kirsten is sitting down with the white top, black blazer. Mr. Doug Clifton's just off there. They're trying to follow him. So that's Doug Clifton. They're trying to get Kirsten Nelson on Zoom. That's how she's been appearing. There was supposed to be a ruling based on Kirsten giving over her phone. She didn't want to give over her entire phone. That's against her constitutional rights. Judge has already had 7 hearings on this matter. Yeah, we've been following this the last couple of days. If you guys have been watching with us, we've been following this trial within a trial. Well, not really. This is all about Shanna. This is all about Shanna's defense wanting access to Kirsten's phone. And Kirsten and Mr. Clifton saying, we don't know what they want. They can't just take everything. Judge Kite has agreed with that. It would be against it would be against Kirsten's constitutional rights to just give her phone. It had to be very narrow. Like, what did Shanna's defense want? That's what they had to say. You have to tell us what exactly you want on her phone. So I assume right now they're waiting for Miss Nelson to come on. Yeah. Literally interrupt. Middle of testimony. They were talking about Wi-Fi and GPS, and then just boom. Yeah, I've never seen this before. Never seen this before. Unless there's like a outburst, or if somebody's like, doing hand signs or something, trying to intimidate a witness. I've never seen anything like this.
If you go into Zoom and put in that number, it should come up. That's the meeting number. Okay, appreciate it.
Yeah, there was something about 9. She had till 9 o'clock. They had till 9 o'clock to find a forensic analyst, or she had to turn her phone. Something with 9. I didn't quite catch that yesterday. It was something that they had until 9 to do. I don't know if that was everything had to be done by 9, like they had to hand over everything by 9, or I didn't quite catch that at the end of. That was at the end of. Well, it was lunchtime, and it was, it was around lunchtime, but it was at the end of this hearing. So, yeah, Judge Kite looked flustered coming in. I don't know if flustered's the right word, but she looked like she was running behind or something, something was obviously weighing on her. And then for her just to stop proceedings, I mean, that's like emergency. I mean, couldn't this have waited for a break? That's what's getting me. I don't know why this couldn't have waited till a break. I guess they're just waiting to get Kirsten Nelson on. It's funny, 2 Kirstens. Kirsten Nelson is the attorney for Shanna. So I'm assuming they're waiting for her to get on the phone or on via Zoom. Yikes! All right, well, that's white noise. Now, who's this guy coming up in the white blazer? Don't know him. I don't recognize that guy. The guy with the white hair, he's like IT. That guy that's talking to Kirsten right now and Doug, that's like the head of IT or audio visual. He runs all the electronics and technology. He does a great job. Yeah, I got to catch his name. I was introduced to him, and I can't remember his name right now. But that guy with the white hair walking back towards us, he's like the head of IT and audio visual. And I have no idea who Judge Kite is talking to. I don't recognize that guy. Okay, girl. Yeah, he was kind of putting on his blazer there, wasn't he? His jacket. He was putting on his jacket as he was coming up. I know. Yeah, it's true. It's this the hearings have been contentious between Shanna and the state. And again, judging by the spiciness of this trial, I can only imagine what Shanna's trial is going to be like, especially when you throw in her defense. She's got a strong defense team. I mean, Jose Baez aside, Kirsten Nelson's she doesn't back down either. The state is going to be up against it with Shanna's attorneys. Not that Mario's Mr. Hill and Mr. Dresser are pretty solid themselves, but I have a feeling Shanna's trial is going to have plenty of moments of like, what? What did I just see? So, all right. So it's a hurry up and wait kind of thing. We just we got to see what's going to happen here.
This better not be a nothing burger.
We'll throw our papers if it's a nothing burger. No, there's no way. Judge Kite's not going to stop proceedings literally in the middle of his testimony. And everybody's like looking around and she's like, Mr. Blythe, could you step out? And he's like, okay. Even Mario was like, what? What did I do? I'm just sitting here, Judge. Yeah, I saw. Yeah, I have no idea who this... She did say something about an order of compliance. So maybe Kirsten didn't turn her phone over, but why stop proceedings? Well, I'm going to not speculate. We could just sit here and speculate all day what this is about. So best just to just got to sit and wait. I don't know. I've never seen anything like this. Is she going to come back on the record? I think so. She's pushing buttons. Yeah, Linda, all right. We changed me going today.
Are the attorneys from the Gardner firm on Zoom?
Good morning, Your Honor. Kirsten Nelson on behalf of Ms. Gardner. I believe Jose Baez and Ron Sullivan are also present.
All right.
Yes, Your Honor.
Okay. Good morning. Is Mr. who's Sam Solario?
Sam, if you can hear us, could you just announce your presence?
I can hear you fine. I'm not visible because I'm unsuitably attired for court, Your Honor, and yes. I didn't want to appear poorly.
Yes, sir. I appreciate that. Thank you. So, Mr. Clifton, for purposes of this hearing, I received, while I'm in the middle of the trial of the state of Florida versus Mario Fernandez Saldana, I received an email indicating that Ms. Bridegan is refusing to comply with the court order. Is that correct?
Yes, Your Honor.
All right. And then Ms. Nelson is the person that notified the court. So, Ms. Nelson, I'll hear from you.
Thank you, Your Honor. I also apologize. I am not suitably attired for court, so I will keep my camera off. We are moving for a motion, or our motion is for an order to show cause why Ms. Bridegan should not be held in contempt for failure to comply with the court's August 11th order, as well as the order this morning and the order yesterday.
Ms. Nelson, do you agree that it would be indirect contempt of court?
Yes, Your Honor.
Mr. Clifton, do you understand the nature of the motion for an order to show cause?
Yes, Your Honor.
All right. So it is basically non-compliance with the court's order that was entered in on August 11th. And for the record, The court had a hearing that was requested based on the subpoenas that were issued pursuant to a prior order. The court heard the objection of the non-party. I then, after that hearing and after consideration of the side that was presented during the objection, the court overruled the objection and issued an order of compliance because it was not being complied with. That is the prior order. Then this morning at approximately 7:19, this court got notice that Ms. Bridegan counsel filed a petition for all writs. The 5th District Court of Appeal has docketed now the appellate process, which is the appropriate way to go if there is disagreement with the court's decision. In the trial court, I believe it was you, Mr. Clifton, that filed the motion to stay this morning. It was approximately, I think, about 8:15 or 8:20.
About
maybe
20 p.m. last night, Your Honor. But
it was 10:20. I didn't get notice of it until early this morning.
Yep.
Then defense counsel filed a response. The court then issued another order denying the stay and denied it within, I believe it was about 8:30ish, giving Ms. Bridegan 30 minutes to comply with the court's order. Additionally, in the prior hearing, in the prior order, the defense has gone through the expense of asking and paying for an expert to come up to take possession of the phone to comply with the court's order and then return the phone to Ms. Bridegan in short order so that she could have her phone basically selectively downloaded and then returned to her so that there would be as little time away from her phone as possible. And so that is what is not being complied with. Do you believe that this is sufficient notice, or I can write the order to show cause? I'm going to grant the order to show cause, and I can write down date and time. Pursuant to the rule, I believe that you are entitled to reasonable time to prepare a defense for Ms. Bridegan.
we would want reasonable time to prepare a defense.
All right, and I hope that this is not to wait out whether the 5th District Court of Appeal is somehow going to stay. But I will give you right now, I stopped the trial at exactly 9:30. What do you believe reasonable time would be, Mr. Clifton, for you to be prepared for the defense of an order to show cause for noncompliance, which is indirect criminal contempt of this court?
Your Honor, looking to do this today?
Yes. Because the expert drove up today, and so I don't...
I understand, Your Honor.
Okay.
2 hours?
Can we...
And we have a lunch coming up at some point, 12:30?
Yes, sir. Yes, sir. I will, if you require, I will. I will have something written up and filed for you to answer to. I can get it probably by 10:15, and then I would have the hearing, I would say, at 12:30. Is that reasonable?
Yes, ma'am. That would help.
Yes, sir. All right. And whatever counsel, if you all could get in, do you want Ms. Gardner transported?
No, Your Honor. We'll waive her presence. Thank you.
All right. I will see you all again at 12:30 for this hearing, okay?
Thank you, Your Honor.
All right. Thank you.
Thank you.
It goes without being said, Ms. Bridegan, you need to be present again, okay? Go get the jury to get back ready as soon as...
So that's why she stopped it, was to give them time. Okay, so apparently this expert is driving up to do this cell phone analysis, and that's why she stopped it at 9. Well, she stopped it in order to give both sides time to, and look at Miss Stifler, Ms. Rahi, and Mr. Dresser there. They're like, it wasn't us. We didn't do anything wrong. they're all kind of chuckling. Look at Ms. Stifler. She's like, yeah, I didn't do anything wrong. That's not on me. They're like kids that didn't get in trouble by the principal or teacher. We didn't do anything wrong. It wasn't us. Thank God. That's Shanna's. That's Shanna and Kirsten. Well, poor Kirsten though. So is she just drawing a line in the sand and saying "F you" to Shanna, or she got something to hide? That's the thing. How's it? The plot thickens. Is she just drawing a line saying like, F off Shanna, or does she have something to hide? Well, we won't know. We will not know until later, until they actually get the, I guess, be able to download whatever it is that they're going to download. Oh man, Shanna's trial is just going to be out of control. I cannot wait. Cannot wait. All right, this trial just keeps getting spicier and spicier.
Do they have until 12:30?
They have until she's going to write up something at 10:15, and then they're going to have a hearing at 12:30 for him to. Apparently, he Mr. Clifton there filed a motion with the appellate court, and it sounds like the appellate court ruled in their favor, that they've ruled against the trial judge, which would be Judge Kite. Yeah, Jags girl, Shanna's trial is just going to be whoo. Yeah, Shanna's trial is going to be bonkers. I'm going to be there for opening statements. I'll definitely be there for opening and closings, and I'll try and get up there at least one more time, maybe two more times. So, Adam, she has the right to privacy and not have someone rifling through her personal phone. Yes and no. Yes and no. We've discovered that there's a yes and a no to that. She has the right to not have everything, but she doesn't have the right to say no to a court order. So you're right and wrong. It's like a yes and no kind of thing there. They can't just say, give me your phone, we're going to look through everything. That is a constitutional right they cannot do. But they can look through certain parts of her phone and get certain messages. So they do have that right.
They did that with Chandler's girlfriend, Kat, remember?
Yeah.
They specified certain chunks of her phone.
Oh, I don't remember that.
The whole phone. Yeah,
okay.
She was freaking out because,
yeah,
she had naked
stuff, yeah.
and stuff on there.
So Aaron's reminded me, Chazzy Boy there and Kat, his girlfriend, they did the same thing to her, that they just got certain things. Certain dates. Angela, I can smell Mr. Baez all over this. Well, he's defending his client. Hey, Elle, how are you? Welcome in. Liz, you think it's an FU? Could be. But if the court orders her, she's going to lose, or she goes to jail. For, hopefully Judge Kite will just say 5 hours, go sit in jail for 5 hours. Because I know Judge Kite, I know this is hurting her heart. I know.
Can someone read back to me the last question I asked?
You got it.
I'll pay you.
Can you have a read back, please? Hold the jury.
You don't have to say maybe because you did the collection of messages data that you used at 2 o'clock for the geolocation of Mr. Kenneth with major records to look at on the website. You used Wi-Fi that was sorted with GPS at 2 o'clock. So all I'm saying is I don't know that they're connected to Mario Fernandez Wi-Fi, but there's enough Wi-Fi access to come surrounding them. The phone was able to find a Wi-Fi based location.
Okay. Thank you, Madam Court Reporter. Thank you, Your Honor.
Welcome. They can come in if they're ready.
Your Honor, the jurors are in the courtroom.
Thank you. All right, welcome back in. Members of the jury, everyone may be seated. Mr. Dreiser, if I could just interrupt you for a couple more seconds. Members of the jury, I want to apologize for the interruption. I want to make sure that you all understand that the interruption has nothing to do with either the state or the defendant in this case. Instead, I had an emergency issue that I needed to resolve prior to you all continuing because it's time sensitive. And so I apologize for any interruption. I believe that we're back on track. So if you thought anything, you should disregard anything. It was my issue, not the attorney's. Does everyone understand that? If you could answer out loud.
Yes.
Perfect. Let's go.
All right, we're back.
Yes, sir.
Okay, thanks for being here. We're now on January 29th. That's a day that the government asked you to map, and you did that, right?
Yes.
Now, did you talk yesterday about the fact that you do sometimes, in other cases, review surveillance in conjunction with cellular data so you can form a better expert opinion, right?
Yes.
You did not do that in this case.
I'm generally, unless it's my own case or an FBI case on my squad, I'm not part of the investigative team, and so I'm not out doing video canvases. So any video surveillance that would be provided to me to use in conjunction with this would be dependent on the investigative team. If it was available for them to find it, get it provided.
I still have permission to walk around?
Yes.
I took the liberty without asking. Thank you. Well, just for example, they did provide you information that they thought was important, and I'm reviewing States 210. This is the vehicle, the license plate readers. Do you remember? Here, I can just put it down. Remember looking at that yesterday, Agent?
Yes, I do.
You didn't pull that information, correct?
No.
The investigative team gave that to you, correct?
They did.
And that was to help you, in your expert opinion, make conclusions as to where Henry Tenon may be located, correct?
See if that lines up or not with those locations, yes.
And it did. It had some evidentiary value that a vehicle registered Henry Tenon's father was near the location of where Henry Tenon's cell phone was via its GPS, correct?
Correct.
So that's exactly what we're talking about. The ability to try to confirm otherwise, which is just numbers and data on pieces of paper that you received from T-Mobile, right?
So I use it as a technique. I call it layering. So if I can get more data sets, more locations, I'll use them.
Perfect. And I asked you in this case, did you review any surveillance as a part of your layering technique that you just described to the jury?
No, I don't think there was any other surveillance that I can recall provided to use in conjunction besides the license plate readers.
Would it help assist you in your expert opinion to know, and the jury has already painstakingly watched hours of compiled surveillance that law enforcement did, not at this time, but at the Potomac address? Meaning, would it help you in your expert opinion to know that Mario Fernandez frequents the Potomac address regularly?
I obviously can see when his phone was in that area from the records I reviewed. I haven't reviewed the poll camera or whatever kind of camera surveillance was in that area.
Let's try to do this together. This day, you have Mr. Fernandez's device at the Potomac address for a couple hours, give or take.
Yes.
In evidence is hours and hours of Mr. Fernandez at the Potomac address. Does that help you say that this data is consistent with Mr. Fernandez going to the Potomac address as seen in the surveillance that's been admitted into evidence?
Yes, that would be one more indication. If you see the vehicle or him on camera, that shows that might show that he moved there with his phone.
Consistent with the day that you mapped, right?
Yeah, if there's camera footage showing him there, it's consistent with this map.
That's all I was asking. Now, this is where on slide 19, Mr. Fernandez is moving from the Jacks Beach area to his rental property on January 29th. That's what this slide shows, correct?
I don't know if that's his rental property or not. I know that address is associated with Mr. Tennant.
No one told you that Mr. Fernandez owned that place?
No.
This is the first that you're learning of that?
I don't remember that. Again, I'm not part of the investigative team. I'm there for phone-based location information to try to show where devices are around these circumstances.
Oh. Well, let's talk about it. You're the expert in this case, or one of them. Let's make sure you understand, because I think it could be important. Mr. Tennant is alleged to have killed Jared Bridegan. You know that, right?
Yes.
So when you put, because someone told you to, on your legend, Tennant address, 5239 Potomac Avenue, someone told you to put that?
It told me that that's the residence attributed to Mr. Tennant. They did, they're able to somehow verify that that is his address.
It's interesting because what's also in evidence is a lease agreement that Mr. Fernandez leased the property to Jeremy Ordway on January 27th of 2022. Did you know that?
No.
Would you like to see that, or you take my word for it?
I'll take your word for it if that's in evidence.
Okay. And you would agree with me that this is 2 days after the lease agreement was signed, correct?
It is.
So you don't know why the law enforcement told you to put the murderer's name on this slide and not two different things. One, that it's Mr. Fernandez's actually owned property. I know you're learning that for the first time today, but would you take my word for it that he owns it? Or would you like to see the records and evidence that he owns it?
If that's in evidence, I can take your word for it.
It is. And secondarily, as the landlord of the property, he had already rented it to a different individual by the 29th of January. And you took my word for that fact already, correct?
Again, I don't have any independent knowledge of that. If that's in evidence, so be it.
But nonetheless, whoever told you to make this slide decided it was best to put the Tennant residence when you have taken my word for two facts that make this not the Tennant residence, correct?
I don't know all those factors, if Mr. Tennant still had access to it, or what the dynamic there was. So the investigative team felt that it was a residence attributed to Mr. Tennant, and I took their word for that.
Sure enough. Because that's all you can do is plug in the data that someone gives you, right?
It's more than that, but...
Okay. Let's talk about the movement of Mr. Fernandez's phone. You know that at 2 o'clock on 129, still looking at page 19 of your slides, at 2 o'clock and 5 seconds, Mr. Fernandez is not at Potomac, correct?
What time?
2 o'clock and 5 seconds p.m.
Not yet.
All right. Can you show the jury, so my question's more clear, when I say that he could be anywhere in the band, using that band as an example, can you show the jury where he could be?
Yeah, so this event, this phone could be anywhere in this shaded area of this band.
Mr. Dreiser.
I'm going to ask if would you help me change the color? Is that what you were going to ask, Judge? I'm sorry I interrupted you, but I knew what was coming.
And I say just...
Wait a second.
Oh, sorry.
It's red right now, and you can't see it.
See what blue looks like. Can you try doing that again?
Sure.
There we go. I like that.
And just to clarify, when you show movement of a device and you see these timing advance bands, yes, in isolation, the phone could be anywhere in the shaded area of that band. But if a phone is moving in a vehicle, the phone's going to be on a roadway. So you're going to look to where the roadways are as part of that overall route. in that movement to see where that phone would have been during that time.
I agree with you.
Just to clarify.
There's one road and a swamp on both sides. It's likely on the road, right?
Yes.
People can't drive through a swamp. I think we all get that.
Right.
In this case, there's a lot of roads, though, right?
There are several, yes.
You don't know what road he's on, right?
Not exactly, no.
So he could be pretty much anywhere in the band as long as it's not somewhere off the road.
I mean, based on the timing, I think it's most likely somewhere along Old Kings Road or an adjacent road, but there are several roads around there.
Okay? But we agree, under no circumstances, according to your expert opinion, is he at Potomac.
At 2:02, the phone is
asking you very specifically
on its way.
At 2 o'clock and 5 seconds, he is not at Potomac.
I don't think so yet, no.
Okay? At 2 o'clock and 12 seconds, using the geolocation call-out number, Henry Tenen appears to be at or very close to the Potomac address.
Yes.
And that's a confidence meters of 56 meters, correct?
Yes.
Okay, so if you drew the radius. That is an unknown source, though. And I thought we talked that you don't like to use unknown sources. Do you agree that's an unknown source, Agent Blythe? Mr. It's 2 o'clock.
I don't recall that being an unknown source, but again, I looked at these locations in their totality. The reason I didn't show the radius for the other unknown sources that was so low because they were less than 3 meters, which is unlikely a device could get a location with less than 3 meters, even with GPS. And so, 56 meters is a lot more conservative and reasonable than 1 or 2 meters.
Okay. Nonetheless, 56 meters, approximately 160 feet, somewhere around the Potomac address is what you think?
Yes.
At 2 o'clock and 12 seconds. Right?
Right.
Now, at 2:06 and 53 seconds, Mr. Tenen is definitely not in the area of the Potomac address, correct?
No, he's moved to the area of Old Kings Road and Edgewood.
Yep. And we know he's on the move because he hits another tower at 2:08, and then he has geolocation at 2:10. So bear with me. We know that Mr. Tenen is on the move, 2 o'clock, 2:06, 2:08, and 2:10, moving away from the Potomac address.
Yes.
And we know that Mr. Fernandez at 2 o'clock is not there, and then he moves closer to the Potomac address somewhere around 2:02 and 25 seconds, correct?
Yes.
You said yesterday that they could have been there for a short period of time together, right?
Potentially.
But potentially they were not there at the same time together, correct?
I'm sorry?
Potentially they were not there at the same time together.
So sometime between 2 o'clock and 2:06, I don't know when, Mr. Tenen's phone began moving from the residence towards Old Kings Road. So I don't know exactly when during that 6 minutes and some change that his phone left. It looks like it would probably take, a little bit of time to get that distance. I don't know the exact drive time, but they're very close to overlapping. So I don't know for sure that based on this data, that they were together, but they could have been.
And I really thought my question was really simple. I know you think they could have been. I'm asking you, they may not have been. And you gave a very long answer, but you agree with me that you can't say that they were together at that time period at Potomac, correct?
Correct.
And while you track devices and the studies show that people are within arm's length of their devices, can you tell me one time while Mr. Tenen is away from Potomac that you can put Mario Fernandez with Henry Tenen?
Based on this data, no.
Okay. And based on the data, not a shred of evidence that Mr. Fernandez was with Mr. Tenon during that time period, correct?
There's no location in data, during this time when Mr. Tenon's devices leave and then come back that I can show that on the 29th.
And there's not a shred of surveillance that has ever been provided to you that puts Mr. Fernandez with Mr. Tenon, correct?
I'm not aware of it, no.
You're not aware of any receipts or financial transactions that put Mr. Fernandez outside of the Potomac area during that time period, correct?
Not to my knowledge.
You're not aware of a single eyewitness that puts Mr. Fernandez outside of the Potomac address or area at the time that Mr. Tenon is gone, correct?
Not to my knowledge.
And you don't know whether Mr. Fernandez may have connected to the Wi-Fi at the residence in which he owns, correct?
So, could you repeat the last one?
You don't know if when Mr. Fernandez arrives at Potomac, he connects to the Wi-Fi there.
I don't.
And of course, if he was there and there were data sessions, it wouldn't be picked up on these TA records, correct?
If he's using cellular or using Wi-Fi based data instead of cellular data if and when he connected to that Wi-Fi, I don't know if he did. You can't tell that based on the cellular records.
Exactly. And it's not uncommon for people to connect to Wi-Fi to places that they routinely go, correct?
It's not uncommon.
Thank you. You have a bunch of slides that reflect that Mr. Tenon went near the crime scene during that time period on January 29th, correct?
Yes.
In fact, you even have a zoomed in slide. Can you find it for me, please? January 29th, where he's near. Like right here. Right there. The long red line. There we go. We're looking at slide 26. This shows that you believe Mr. Tenon's device, and by extension of the studies, Mr. Tenon went to the crime scene on that day, correct?
Yes.
You have no evidence whatsoever that he went anywhere near Marsh Inlet, Mr. Fernandez's residence on that day, do you?
I don't think so, no.
February 15th. On February 15th, you have reason to believe, using the data, that Mr. Fernandez may have gone to his rental property in the morning?
Yes, the Potomac Avenue address, yes.
Okay. Mr. Tenon wasn't there?
During this time frame, his device is over where it's indicated with the 9 events here.
We're looking at slide 34.
Correct.
Easy answer is Mr. Tenon's not there, correct?
His device is not there.
His device isn't there. Thank you. And did you know that the area that it is in is Modison Pallets, where Mr. Tenon worked? Did anybody tell you that?
No.
Okay. This would be an example where Mr. Fernandez is at the rental property and Mr. Tenon is not at the rental property, correct?
In this instance, no, correct.
Yeah. Just like on the 29th, right?
On the 29th, you're just talking about Mr. Tenon's device is leaving?
Exactly.
Yeah, Mr. Fernandez's device remains in the area of that residence.
Similar fact, right?
Yes.
Now let's go to later in the afternoon. And again, in your layering concept that you told me about, would it be important to know that in the surveillance that this jury has already seen, that Mr. Fernandez oftentimes goes to the Potomac address more than one time in a single day? Would that help in your layering?
Not really. I mean, it shows a pattern of life, right? That may be good for an investigator to know. But for me, I'm looking at finite periods of time, showing where the devices are and where they move as best as I can.
But you would agree with me, it gives the jury some perspective that he goes there more than one time in a single day, consistent with what you mapped, right?
I don't know that it pertains to my mapping. It's you can make whatever arguments you see fit.
Thank you, sir. I'll do that. And then later in the day, he goes back to the address for a short period of time, correct? Mr. Fernandez goes back to the Potomac address.
Yes.
Slide 35, Your Honor. But now, would you tell the jury, this time you believe the data shows that Mr. Fernandez gets to the rental property that he owns and Mr. Tenen is there, correct?
So between 4 and 4:29:25, Mr. Tenen's device is there.
I know, but let's break that down.
Okay.
Mr. Tenen leaves the property, doesn't he?
He does.
And he leaves before Mr. Fernandez leaves the property, correct?
Before his device does, yes.
Before his device does. Another example of when Mr. Fernandez is at the Potomac address and Mr. Tenen is not at the Potomac address, correct?
I would replace their names with their phones, but yes.
You would, the devices, because you maintain people are with their devices, right?
Usually, but okay. We talked about this earlier, yes.
Yeah, all right. On the evening, moving to the 16th, which is the day of the homicide, let's go around slide 39. Okay. There's a lot of data on these slides. Would you agree at some point in time, and this is real talk, simple, I'm not trying to confuse it, it looks and it appears that Mr. Fernandez left his residence in the early afternoon or late, the early evening, around 5 o'clock. He travels west on Beach Boulevard. He turns around, he travels east on Beach Boulevard and drives home. Would you agree that that's pretty consistent with all of the slides from that time period?
That's a good way to put it.
I'm sorry?
That's a good way to put it.
Thank you. And now, again, no one's ever provided you any evidence that Mr. Fernandez left his home on the evening of the homicide, correct?
Left his home at what time frame? On the 16th?
Yeah, during the homicide. After he gets back from the Beach Boulevard, he goes west, then he goes east, he comes home. You have no surveillance that puts him outside of his home?
No.
You have no eyewitnesses that put him outside of his home?
No, not to my knowledge.
So you talk about TA records and that there could be a gap in the TA records and that it could be that his phone was off during the time of the homicide. That's what you told the jury yesterday.
It's possible.
It's possible. You also told the jury that these are all just snapshots in time, correct?
They are.
You also know, and I'm going to use your words, there can be blocks of time where network engineers just don't record timing advance for a particular market area.
That's true.
And you also know that when you got all the records that you've used to compile this data, it came with a warning, correct?
Yes.
If I just may have a moment, Your Honor, I got to switch gears. I don't have the highlighted one from open. This is the warning that you received from T-Mobile?
It's a note on interpreting timing advance records. Yes, I've seen it or read it.
Would you read the first paragraph to the jury, please?
Your response includes timing advance records. TA records are not call records. TA records are specialized historical location records. They are based on tower registrations and are not dependent on a voice call, text message, or data session. TA records are stored by market as defined by T-Mobile Engineering. TA records are retained for 0 to 90 days. Retention varies by market. Timing advance data may not be available in every market, portion of a market, or for every IMSI, which is an account-specific number for a user on their network. And even if call records are found, there may be times when no timing advance records are available. Please exercise caution in using these records for investigative or prosecutorial purposes.
You are, in fact, using these for prosecutorial purposes.
Absolutely. And what they mean there is you need to know, understand them, and they're gracious enough to come and provide training directly from their network engineers to FBI CAST and other units.
And in their training, because you've already testified to it, you tell the juries that there are times where, I'm going to use your words, there are blocks of times where the network engineers just don't record timing advance for a particular market area. Those are your words.
Yes.
And this is what we're talking about, one of those times between approximately 7:10 and 8:20 p.m., right?
It could be, but I don't know that for sure.
Of course. So now let's go to the slide where it sort of shows the desolate time period that the prosecutor talked about at great length yesterday evening. This is showing that there is activity, TA records around 209, 210.
709, 710.
Yeah, I'm sorry. 2 being the month, 709 to 710, and then there's a gap.
Yes.
Between 820. That's what you were talking about. That's what T-Mobile's talking about, right?
Could be, possibly.
Okay, so now let's go. And this is it. This is the slide they showed you yesterday, where it just slide number 42, where it just shows like no pink, and it looks like nothing happened, right? This is a representative that there's no TA records during 7:11 to 8:19 p.m. That's the slide that you developed, correct?
As well as the note shows there's no outgoing or incoming text messages during the time frames noted.
Okay. Again, you don't know if he's connected to his home Wi-Fi, correct?
I don't know.
And let's go down to the slide that shows a bunch of TA records on the night of the homicide. Slide 49. So on this exhibit that you put together, different than the desolate one where it just shows nothing, you put all these TA records on the right-hand side, correct?
There are a lot of timing advance records, yes.
But let's focus on the top. There's a timing advance at 9/11/04, correct?
Yes.
And there's not another one until 10:02, correct?
That's correct.
That's approximately a 52-minute section where there are no timing advance records, correct?
Yes.
And if you made a slide, if you wanted to, which you didn't, but if I asked you to, and I'm just going to ask the jury to visualize it, a slide, if the crime had occurred at 9:30, just for a moment, are you following me?
Yes.
If the crime occurred at 9:30, you could make an identical slide to the one I just asked you that say between 9/11/04 and 10:02 p.m., and it would look identical. There would be no TA records, correct?
Correct. There's no calls or text messages during that time frame either.
So when the government asked you yesterday, and Ms. Stifler said something to the effect of, and it just happens to be that during the time of the homicide, there's no TA records, it was based on the slide that shows nothing, correct?
That is what it is. There's no records during that time.
And it is what it is that there's no records between 9:11 and 10:02 p.m., right? Just is what it is. There are no records between that time period. And that's not something Mr. Fernandez can control, is it?
So potentially, yes, in some respects. You can not make phone calls. You can not use data. You can turn the phone off and not have connectivity. But there is this other potential reason with the network not recording timing in advance, which it would explain lack of timing in advance. It wouldn't necessarily explain the other data sets, but that's why I pointed out reasons for both yesterday, and you're pointing them out again. And those are the possibilities and the reasons behind them.
Okay. You just don't know, right?
No.
May I just have a moment here?
Yes.
Agent Blythe, do you see that there's a timing advance gap starting at 12:43 a.m. on the 17th?
About a 30-minute time frame.
Yeah, between 12:43:32 and 1:16 a.m. 14, and I'm referring to the same slide, Your Honor, slide 49.
That sort of gap or lack of timing in advance for a short period of time, 30 minutes, let's say, could be the phone being somewhat idle. Text messages, voice calls, using data, cellular data can generate those, as well as signaling when the phone's moving. But while the phone's just sitting there idle, there may be a little bit less.
Or I guess it could be argued that he turned his phone off and back on again, right?
It's possible.
Did you know law enforcement was there at approximately 12:36 that night? That's when they arrived?
I don't know when they arrived. No.
Okay. The jury heard and they'll make their determination, but I'm going to represent to you it was somewhere around 12:36 that they arrived to give the death notification to Ms. Gardner and Mr. Fernandez, okay?
Okay.
And they were there past the 12:43 hour. So again, if Detective Burrell has testified that Mr. Fernandez wasn't playing with his phone, he wasn't fumbling with his phone, it would be likely that Mr. Fernandez did not turn his phone off at that time, right?
I wasn't there. I don't know if he had access to his phone, had it in his hand, in his pocket, or if it's sitting on the nightstand. I don't know.
All right, and then we talked about Pennsylvania, so I'm going to move on. And then you put some graphs together at the end that show a few different ways to visualize what you thought were some important historical pieces of information about when he uses his phone and when he doesn't. Is that a fair description?
It's just pattern of life is showing in a benign way just when the device is used more by frequency when the device is in use based on the call detail records.
That's what I was going to ask you about, based off call detail records, right?
Yes.
None of these charts factor in Wi-Fi whatsoever.
No.
So,
well, Yeah, so text messages are indicated in the records. Calls go in the records even if they're over Wi-Fi. It's not including data sessions.
It's not including data sessions. You didn't factor in Wi-Fi into this equation whatsoever.
Well, a lot of the records are there, whether the phone's using Wi-Fi or not, in the call detail records.
I think my question was, you did not factor what's happening when he's connected to Wi-Fi during these time periods at all.
So again, that's why I was clear. It's based on the call detail records, and it doesn't necessarily account for other usages of the phone that aren't incorporating the cellular network.
Like gaming.
Oh, like gaming?
Gaming, like data session.
Correct.
The jury's learned that Mr. Fernandez was a big gamer. Did you know that?
No.
And I'm sorry, Your Honor, may I just have one more moment with my colleagues?
Yes.
I have no further questions for the witness at this time, but I just need a minute to clean up my mess.
Sure. Ms. Stifler, do you have redirect?
Just 2 questions, Your Honor.
Okay. Do you want to do it from counsel's table?
That would be fine.
Okay. Did you need the?
I might use just one of the slides quickly.
All right.
They don't have to wait
if
for
you
me.
could give them a moment.
I'll just use the Elmo. Thank you.
Yes, ma'am.
I won't.
She should have stayed at the counselor's table. She had a microphone. Turn your microphone on. Turn your microphone on. Turn your microphone on. All right, well, can't hear her because their microphone's not on. Thank you, Mia. Enjoy watching. Thank you so much for your support. Really appreciate that. So Ms. Stifler's microphone is not on. She has a lapel, and there's also one at the podium, but it's not on.
Maps.
Here we go.
I'm trying to show a fair and accurate, reasonable representation visually of where the location of the phones were and the movement of those devices with the level of precision warranted by the data set.
So you speak for the data.
Yes.
And you don't have a position when it comes to the data. You map it as it's provided to you.
Yes.
One last question. You had a couple different types of data, in this case, timing advanced, cellular location data, and Google location data. In your career, have you ever mapped location data that you obtained from the download of a cellular device?
Yes.
What types of location data are available on a cellular device itself? Not from the provider, but right from the phone, plug it in and download it?
Right, so it's the same source that Google's getting the locations from. It's just transmitted to Google, like with the Henry 10 and 53. But the phone has several options to generate a estimated location. It could be the GPS receiver on the phone. It could be what's called Wi-Fi based locations, or the phone can see Wi-Fi access points around it, see the signal strength, and then estimate where its location is based on the location of known Wi-Fi access points around them. Third, could be Bluetooth technology or cellular technology. The phone can see what cell phone towers it gets a signal from around it and can estimate a location as well.
Is that type of data more precise, similar to the Google location data you had for Henry 10 and 53 at Gmail?
Certainly the GPS, Wi-Fi, and Bluetooth sourced locations, yes, those would be typically more precise. Cellular is just going to be similar to cell site in that it's a broader estimated location.
So if you had the ability, if data was available on Mr. Fernandez's phone, with location data, it's possible you could more precisely map the location of his device during some of these time periods.
Yes.
If that data existed and was available to you.
Yes.
I have no further questions, Your Honor.
Anything further for this witness? Just on those points, correct?
Yeah.
Okay.
Do you know if on the night of the homicide, when they gave a death notification, they asked for Mr. Fernandez's phone?
I don't.
Do you know when his phone was collected via a warrant?
I do not.
Certainly law enforcement can get warrants, they can stop people, and they can collect their devices, correct?
Yes.
And generally, the suspect doesn't know when that's going to happen, correct?
Your Honor, this is beyond the scope.
Now, this is directly to her asking questions about other people's phones and other investigations, what information he could use if he
had it.
All right,
stop. I'll overrule the objection. You can ask.
Thank you, Your Honor. People don't generally know when their devices are going to get seized?
No.
And in this particular case, a warrant was issued 11 months. Approximately 11 months after the homicide for Mr. Fernandez's phone. Did you know that?
I did not know that.
And that's when they got it, 11 months later, right? If that's true. That's when you would have had that ability to look at that phone when law enforcement seizes it, right?
Yes.
And in your expertise, nowadays, people are extremely reliant on their cell phones, correct?
Yes.
New cell phones come out regularly, correct?
Yes.
And people get new cell phones fairly often.
Every couple years.
Some people more than that, right?
Yes.
Thank you. No further questions.
Anything further, Ms. Stifler?
Yeah.
May the witness be excused or
Be excused.
subject to recall or no?
Sure, we'll do him subject to recall just in case.
Right. Agent, you understand what that means?
Yes, ma'am.
Okay. So you can step down now. Please stay in contact with the attorneys.
Yes, ma'am.
The next witness, is it a longer or shorter witness?
Probably going to be about an hour.
Okay. Members of the jury, we're going to take our mid-morning break. We'll give, the court will give you 15 minutes, so we'll return back at 10:50. Leave your notepads on your chair, please.
All right. That seemed kind of tame after what we saw with Miss Bridegan and failure to comply. Wow. All right. Actually looking more forward to lunch than I am for the rest of the morning trial. But so who else was it? K-Girl, were you the one that was asking who else? What other witnesses can the state bring up that would be compelling? And to me, I've been saying it from the beginning. It's the financials. We heard that Mario gave Henry 3 checks in the amount of $2,000, $3,000, and $5,000. I would also like to see evidence that Henry did the work that he was contracted to do or paid to do. I know Green Eyed Cat has suggested that. There was a couple other people that have suggested that. K-Girl, it was you, yeah. So to me, I want to see those finances. I want them to bring. I'm pretty sure they talked about that in opening statements, that they were going to bring in. There was going to be a financial person. Cletus Jones, Miss Bridegan has failed to comply to hand over her phone to Shanna Gardner. It was a whole big kerfuffle. Judge stopped the proceedings in mid-sentence. It was pretty intense. And then they're going to have, she has until 12:30. There's going to be a hearing. There's going to be a hearing at 12:30. So stick around. Don't go anywhere for lunch. There's going to be a hearing. Well, I guess from 12 to 12:30 you can go somewhere. But there's going to be another hearing, yet another hearing. Judge has already ruled seven times on this. And Mr. Doug Clifton is they're digging their heels in. They're digging their heels in, and Shanna wants her phone. But she can't get her whole phone. The judge has said that over and over again. You're not going to get the full phone. So Fireworks Friday, yes. Yes, so let's hit the like button, you guys. We are 156 likes. If you guys don't mind, take a few minutes. If you are out there and you're not in chat, please take a moment. If you can hear my voice, and just take a moment and see if you've hit the like button already. And if not, please do so. We are on a break right now. So do take a moment and hit the like button. 157. Let's see if we can get up to what should we shoot for? Say 160. We'll start with baby steps. We'll go with baby steps. See if we can get up to 160 likes before the break is over. Hellrider, how you doing, man? Definitely want to see the money trail. Yeah. Follow the money, right? Isn't that what we always say? Cletus, 157. All right, up to 169. Awesome. Way to go, guys. Fantastic. Super Ball is silently staring from the back until you hit the like. So yeah, Cletus, this has been this ongoing thing between Shanna's defense wants access to Kirsten Bridegan's phone. This has been going on for a couple days now. They've had hearings within court. I keep saying a trial within a trial, but that's not really it, because these are two separate trials. But as of yesterday, they were supposed to have until like 9:30 this morning, or 9 o'clock, I think, to comply. And she just dug her heels in and she said, I'm not giving you my phone at all, which is her constitutional right. But this defense wants just certain little things, and it's all going to go through the judge. So it's not like she's going to give them, she's not giving her phone to the defense and then the defense just has free reign. That's not what the judge set up. The judge set up that, give me your phone, and then the defense is going to tell me what they want to look at, and then I'm going to double check it. That's a lot of work. That's a lot of work for the judge. I'm not sure how she's going to figure that out, but somehow she's going to figure that out. Anyway, so Miss Bridegan, Kirsten Bridegan, dug her heels in and said, nope, I'm not going to comply. And now she may be found in contempt. Can you imagine? The victim's wife, found in contempt for not handing over her cell phone. And I know Judge Kite is very, very sensitive. She has said that multiple times, that she's very sensitive to this. She's sensitive to the privacy of Kirsten. She's sensitive to to Shanna's right to have a fair trial. So she doesn't want this overturned. She doesn't want this to go to court, and then 3 weeks go by, 4 weeks go by, and then 6 months down the road, it's overturned because of the cell phone. So, 193 likes. Can we get to 200? Wow. Dare I dream? Can we get to 200? Can we get to 200 likes, you guys? Wow. Let's see. 194 likes. Let's see if we can get up to 200. So anyway, I know Judge Kite is extremely sensitive to both sides of this, because as a trial lawyer, you do not want to have the court have the trial overturned because of anything, but especially because of this. Would it happen? Who knows? I don't know. That's the thing. You just don't know. But I do know that she did mention something about the appellate court upheld something. What did she say? I didn't quite catch it because it happened so fast. It was on the docket. Okay, so at 7:19 this morning, the court got notice there was a petition for all writs. Kirsten understands the motion to show cause, which is basically they have to. It's a motion that says I'm compelling this person to come to court. Basically, and at 7:19 the court got a notice petitions for all writs. A docket. I just have docket and appellate. I think it went to the appellate court. And I think they actually agreed upon that. 8:15, she got a notice from Mr. Clifton, who is Kirsten's lawyer. Court denied the stay around 8:30, giving Kirsten 30 minutes to comply. And then at the end of the day, she said, I'm going to grant the order to show cause. She said she stopped the court at 9:30. How much time do you need? This was Mr. Clifton. And he says about 2 hours. So she said, all right, I'll have something written to you and sent to you by 10:15. And then they're going to have a hearing at 12:30. So pretty nuts. Again, I've never seen. 207. You guys are the best. Thank you so much, you guys. 207 likes. Fantastic. Thank you, guys. Hey, Stella, how are you? Welcome in. Great to see you. Treasure Hog, yes. Robot says Judge Kite's order to turn over Kirsten's cell phone should be reviewed by an appeals court before Kirsten complies. Yeah, we'll see how it all plays out. They're going to have a hearing at 12:30, so we'll see how it all plays out. We'll see how it all plays out. I can't imagine. Cletus got one. Awesome. Good job, Debbie. Debbie, thank you for the Trial TV Live gifted membership, and Cletus got a gifted membership. Thank you so much for that. Camilla, thank you for the party hat. Appreciate that. Yeah, I don't know. They signed off on it. Apparently, that's the only way I could interpret it. That's the only way I could interpret it. If they were talking fast, everybody was kind of like up on edge. And we saw Judge Kite come in. If you guys rewind and go back to the beginning of the stream, she came in and I made a comment to you guys and I posted in chat. She did not look, I don't know what the right word is, composed. She looked flustered. She looked something was not right. Something was not right. She usually comes in and she's calm. She's a calming presence. She's usually there. Good morning, welcome in. She's usually. She was just different today. And I picked on that right away. And I know you guys did too. So, yeah, she was not happy. She was not happy, for sure. Tosh, why would she want text between daughter and stepmom? It's all about bias. This is all to show bias, and it's not. It's to show bias. They can't go to Justice for Jared because that's a website, so they're not going to be able to access that. It's everything that's on her cell phone, and the defense is saying they don't want to give over all 4 years. They don't want to give over everything. Judge Kite has said multiple times that's constitutionally protected. You're not going to be able to just run, just look at everything. You just can't. So you have to tell us exactly what do you want? What specifically do you want? And the defense, Kirsten's been fighting that. Mr. Clifton has been fighting that because he's like, we don't know what they want. They just said they want the phone. We don't know what they want. So they're kind of like talking in circles, because then Shanna's attorneys are saying they're blocking us. They gave us a suggestion, and now they're blocking the suggestion that they gave us. And then Kirsten is saying, well, Mr. Clifton is saying, we don't know what you want. So again, they're kind of talking in circles. But from Judge Kite's perspective, she wants to protect, and she is protecting Kirsten's privacy, as she should, under constitutional, under the Constitution and Marcy's Law on top of it, because she's a victim. So she is protecting that, but then she's also protecting Shanna to give her access to a fair trial and not have any appellate issues down the road. So And Judge Kite yesterday, she's like, we're setting precedent here. You know, she's been scouring case law. She's mentioned that multiple times. She's like, we're treading in unfamiliar waters right now. So it's very interesting. What we're watching right now will absolutely go down as case law. I would imagine. So it's exciting on that. You know, that's why, you know, Colin Gray and Colt Gray. It was fun to watch that. Only from the aspect of it's case law. It had never happened before in Georgia. It only happened second time here in the United States. So from that aspect, from that angle, from that lens, it was interesting. And I say fun, but you know what I mean. I don't mean it was. Of course, it was terrible, but it's fun to be a part of. I guess is the right. Trying to say it delicately, that it's exciting to be a part of watching something that you know will be case law or is historic. I guess is what I'm trying to say. It was historic, and I have a feeling that this is going to go. Judge Kite even said this is going to set precedent. This could be case law at some point. So, Jane, didn't Judge tell them to decide themselves what could be downloaded and bring it back to her? Everything has to go through her. So whatever it is they do decide, it has to go through her. So the something to that effect. Let me see if I can find my notes real quick before they come back. It was she kind of gave the process yesterday where it was tell it's going to go through her. That's what I remember. Whatever happens, it's going to go through her. So in other words, they're not going to be giving it directly. Nobody's going to be talking directly. Let me see if I can find it. Let's see. So Mr. Clifton kept saying, how can we object if we don't know what they want? Maybe we could extract certain portions, but there's an objection to that by the defense. You can do an objection log. He's like, how can we object if we don't even know what they want? So that's the main thing. He doesn't even know. And Judge said, here's an example. Hey, AB, which would be the daughter, Gardner is a terrible person. Oh, just joking. That's an objection. That shouldn't be given over to the defense. And then I'll weigh it. So Judge Kite is creating this incredible amount of work for herself, but maybe we can make some case law. I'm creating a new path. I mean, she literally said that. She thinks this is going to be case law. I only want to look in camera, very narrow scenario. I'm trying to handle this with as much care for both sides. Let's see. She says, you make a log, like an objection log, and I'll compare it. Is that fair? And then Mr. Clifton said, no, we're not agreeable to that. And then she's like, I've made that ruling. She was pretty strong on him yesterday, too. But then he says, well, if you order us to turn over the phone, I mean, he pretty much yesterday threw his hands up and says, well, if you turn over a phone, and then, let's see what else. The only info, so Mr. Clifton said, the only info is what she testified to at the second deposition. Yeah, she's created like a whole bunch of work for herself, but I guess, I mean, that's what you have to do, right? I've acknowledged her constitutional rights multiple times. I've been respectful of all of her privacy. So, I mean, she's doing her best. She's doing her best. Sandra, it is getting very, very interesting. Stella, how are you? So good to see you on a Friday. What are we calling it? Fireworks Friday. Camilla's come up with Fireworks Friday. Let's see, we had Typo Tuesday. What was Thursday? I forget what Thursday was. K-Girl, Judge may have a few more gray hairs. A few more gray hairs after this trial. I know. Poor Judge Kite. MMC says, if they want the kids' conversations, why don't they just use the kids' phones downloads? That's a really good question. Is that even legal? Can you get, is it legal to obtain a minor's cell phone data? Is that even legal? Whether obtaining a minor's cell phone data is legal depends entirely on who is doing it and how they get it. Parents or guardians generally have legal rights to monitor. However, law enforcement and third parties face strict legal limits. Minors have limited expectations of privacy. Okay. Police and government agencies generally cannot search a minor's phone or demand cell phone data without a valid search warrant, probable cause, or explicit legal consent from a parent or guardian. Coerced or unverified consent from a juvenile alone may be legally contested in court. So I have a feeling that's probably why they're not going to the minors, because they're protected. Children's Online Privacy Protection Act, COPPA, COPA. Commercial apps and websites are strictly prohibited from knowingly collecting personal data from children under 13 without verifiable parental consent. So I'm thinking just because they're minors. Debbie again getting robot Glock. Awesome. Good job, Debbie. Yes, that was Roger. Kaylee, technically the kids' phones belong to the parents, don't they? Well, they have to give consent. Apparently the parents have to give consent. So I guess if the parents bought it, the parents are paying for the service providers. So I guess you could make a case for that. I mean, I would say, yeah. Typo Tuesday, Spicy Wednesday, Turmoil Thursday, and Fireworks Friday. Gotcha. Thank you, Camilla, for that. Grampy, yeah, then there's that. So you could look at this either way. Kirsten is drawing a line in the sand saying, nope, I'm not going to give it to you. And Shanna's saying, well, she's hiding something on a phone. And it has to go to bias. It all has to go to bias. Let me see if I can find those notes. Let's see here. Let's see. If you're arguing that you don't know what you're arguing against, it's related to bias. It's related to bias and motive. So it's related, it's all about bias. That's what this is all about. And apparently Shanna's group is saying there's some content in there that shows Kirsten was biased to us, and I don't know how that's I'm not sure how that's gonna how's that gonna help Shanna's defense. Sure. Nanny 21 just got to the part where she cleared the room. Yeah, just keep watching. Just keep watching. Oh, they're in Utah. I thought they were with I thought they were in Washington. So they're now in Utah. Okay. Yeah, of course she's biased towards Shanna. Trying to think, why would Shanna's defense want to show that Kirsten was biased to her? Like, why does that matter? Why does that matter? Help me fill in that gap. I mean, we've been talking about this, and then now I'm like, well, who cares if she's biased? Right? I mean, of course she's biased, but why? Help me fill in that gap. Why would Shanna's defense say, I mean, why would that matter? Washington. I don't know. I mean, I really, I have no idea. I'm just assuming because that's where Shanna went. I just thought that that's where they were. I could be. You're right. I don't know. Robot. I don't know. KK Bixby. Hi. I just have to say hi to Cletus. My dad's name was Cletus, and it was nice to hear that name being said. Nice. Well, welcome in. Mrs. GA Mom, Georgia Mom, I'll go with. Kirsten's attorney was saying yesterday that it had to do with the site Justice for Jared on socials. I wonder what the defense wants about this. They definitely were saying that the website is off the table because it has to be an app or it has to be on the phone. It can't be accessed like through the phone. The website can't be accessed. I'm pretty sure. Let me see here. Yeah, Justice for Jared site is nothing. Very small areas. It's not even on the phone. It's saved on Meta. That phone won't be used in login, so there's no objection there. Oh, disparaging. I have disbarring. Disparaging comments about defense was on her stories, meaning her Instagram stories. That's what they want. But again, who cares? Who cares if she's saying disparaging comments about that's so now I'm trying to figure this out. Like, who cares if you're Shanna's defense, who cares if the widow is making disparaging remarks about you, right? Mike says, my inclination is there's something incriminating on that phone. We will find out unless she wipes it. Unless she destroys it like, what's his face did? What was his name? Higgins. Yeah, if Higgy, just like Higgins, if she destroys it like Higgins. Horse welfare, have a good one. We'll see in a little bit. Shirley, what's the worst they could do if she accidentally wiped her phone? They can't keep her in jail forever, can they? Well, didn't Mario factory reset his phone? Mario factory reset his phone. Higgins destroyed his phone. Nothing happened to him. What if she... if the communications are with the kids, could they be arguing that she influenced the testimony of the kids? That could be. That could be. And the communications are with the children. Yeah, that could be. Or any other witness too. Yeah, that could be. Maybe that's why they're showing that it goes to bias, so that she was maybe influencing witnesses. She was talking to her children. She was talking to any other witnesses that are going to come in. Yeah. Biggest mistake she could ever make, wiping that phone clean. Yes, our Robin Hood. We are Deadeye Debbie. Yeah, I guess if she was talking to the children and possibly other witnesses, and she was saying disparaging remarks about Shanna, then that goes to bias, and then the kids come in and they testify or they give depositions, and or other witnesses give depositions. Now that makes sense. All right, thanks, Brett. Yeah, that makes sense. Especially with the children, because they're going to be more influenced. Okay. Kaylee, wiping her phone at this point could be altering evidence 100%. Yeah, they'll get her for that. They'll be like, you knew. How did you accidentally or oopsie? Well, she could, I guess, drop it in the St. Johns River, right? Or she could, hey, I went swimming in the Atlantic Ocean and I don't know, popped out of my my swimsuit. Or I was on a boat. We went boating and oops, my phone just happened to be at the bottom of the Atlantic Ocean right now. Suppose Suppose you could say that. Or, right? I mean, suppose you could say that. Terry, hey, you've been watching with us, but just not in chat. This is turning into a hot mess. Absolutely. Swallowed by a fish. Anything could happen. If you go out boating, anything could happen. Rudica says, at this point, her phone is being seized no matter what. Dob says, Shanna's parents definitely didn't want Jared to have the twins. Cletus, I didn't realize the kids are going to come in. They're on the witness list, but they kind of ruled against. There was a ruling about that too, but they are. Oh no, that was for a deposition. I think that was for a deposition. That they ruled. They ruled that they would have to be. It didn't affect the trial per se, but yeah, the kids are on the witness list. Okay. Debbie, yep, can't wait for Shanna's trial. It's going to be a hot one. Exactly. Fell into the toilet. I mean, anything could happen. Anything could happen, Mike. Grampy, yep. Or oops, mine slipped off the balcony. Just as the paver is rolling by, right? Just as the cement truck is rolling by, or the asphalt. They're laying new asphalt. And they got one of those pavers, one of those steamrollers. Oops. Who's to say? Who's to say? Can't they subpoena the cloud? They could, yep. They could get the cloud records, call log records. They could see. They could get text messages. They could get phone. Photos. But any kind of phone calls, they could just see the call, but they don't know the content of the call. So yeah, they could go to the cloud and get the text messages, because that's happened. We've seen that before. Dina, hi everybody. She didn't turn her phone over to the judge this morning. Nope, that's what we're talking about. That's why 12:30. There's going to be a hearing at 12:30. So don't go anywhere for lunch. It's going to be yet another hearing. We're going to have yet another hearing during lunch. What if her phone got stolen? Then there's that. Any number of things. Shanna, oops, dog ate your homework. Exactly. Yeah, any number of things could happen. Let's see. Jane says, do you think initially the state and defense were nervous when Judge Kite cleared the courtroom? Yeah. And then I thought, I don't know if you guys were with us or whoever was with us, when afterwards, when that was over with, both the state and the defense were talking to each other, and they were all smiles. Ms. Stifler was all smiles. And I could just imagine them, I was projecting onto them of like them saying, whew, glad it wasn't us. Because Mr. Blythe was on the stand. He's like, okay. When he was asked to leave, Mario, he's like looking around like, what happened? I mean, it was like literally just dropped in out of nowhere. Meow. Rafa. Debbie, yeah, Henry's trial will be good too. Yeah, no, it's all going to be good. Robot says, if she has an iPhone, I think if you enter the wrong PIN code more than 10 times, it deletes all the personal data, resets the device. But to get there, you have to ignore half a dozen warnings and timeouts. Huh. I didn't know that. Deletes personal data and resets the device. I did not know that. I don't want to try that on my phone. K-Girl, you actually ruined 2 phones by having them fall in the toilet. We don't need to go any further. We'll just leave it at that. Hey, I'm like, yep, it's right out there somewhere in the Atlantic. Exactly. Yeah, Mario's face. Yeah, everybody's like looking around. I mean, they literally were in the middle of testimony, and she's like, Mr. Blythe, please leave the. Well, she sent the jury out first, then Mr. Blythe sent him off the stand, and he's like, okay. And then Mario's like, what did I do wrong? Or I don't know if he's thought that or whatever. Texas Law Cat, thank you for the One Trial TV Live gifted membership. Annabelle, you just received a gifted membership. Debbie Gibby, you have been watching, just working, so no yapping. But I think Kirsten will be arrested during lunch, refusing to hand over phone. She needs a new lawyer. Shirley says, I'm surprised the judge is reading emails while presiding over a trial. You see them doing a lot of work. You see them typing and reading and stuff. You do see them doing that. Well, Kathy, something clearly happened. Something clearly happened. She was supposed to write something and give it to Mr. Clifton by 10:15, but they broke at like 10:30, right? Was it 10:30 when they broke? How long have they been off? Yeah, they've been off for like, gosh, half hour now. Over half hour, 31 minutes. They've been in recess over 31 minutes. Something's going on. Oh, and here they are. And they're back.
Exhibits with defense this morning, and we're entering these into evidence by stipulation of both parties.
Okay.
That's correct, Your Honor.
Thank you, Mr. Hill. And Ms. Stifler, if you could go over them.
Yes.
All right.
States 9G coming in as 213, Google deletion markers, secondary database. 9F coming in as 212, Google deletion markers, primary database. States I coming in as 215, Google deletion data by process data bar graph. And 9H coming in as 214, CDR mediations, Mario Fernandez Saldana with highlights.
Thank you. Are both sides ready?
Yes, Your Honor. May the state and I approach briefly just for scheduling?
Okay.
So the jury has been off, about 35 minutes now, a break? Yes, Richard. Yes, Richard. Stifler's mom. Yes. Yes.
All right, let's bring in the jury, Ms. Gordon. I don't know what that means.
I know, I can't see.
Somebody get a hold of AJ. I don't know.
Your Honor, the jurors are entering the courtroom.
Thank you. Welcome back in. Everyone may be seated. Ms. Stifler of the state will call its next witness.
Your Honor, the state calls Lindsay Butler.
Lindsay Butler, please. Will you please raise your right hand to be sworn in?
Ma'am, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
All right, this way. Watch your step, please. There's an incline. Can you get rid of that cup, Ms. Gordon? Thank you. You may proceed.
Thank you, Your Honor. Good morning, Ms. Butler. Could you please introduce yourself to our jurors?
Good morning. My name is Lindsay Butler.
And Ms. Butler, what is your occupation?
I'm currently a physical security analyst for the North American Electric Reliability Corporation.
And who was your previous employer?
I was previously employed by the Bureau of Alcohol, Tobacco, Firearms, and Explosives, or the ATF.
And could you speak up just a little bit? You're a little soft-spoken. I want to make sure we can hear you okay.
Yes.
How many years were you with the ATF?
I was with the ATF for approximately 5 years.
And what was your position there?
I was an intelligence research specialist.
Can you describe for the jury what an intelligence research specialist does?
Sure. So we receive data, we interpret the data, we analyze the data, and we assist investigators who are investigating a variety of crimes, both state and federal.
Was your position with ATF a civilian position?
Yes, it was.
You're not sworn law enforcement?
Correct.
And can you give the jurors a brief outline of your educational background?
I have a bachelor's in criminal justice from Virginia Commonwealth University and a master's in criminal justice from the University of Cincinnati.
And can you describe for the jurors, today you'll be testifying about your analysis in this case involving cell phones, Google data, and toll records. Can you give the jurors an idea of the training and education you've had in those types of data, the analysis of that type of data?
Sure. So when I started with ATF, I attended a virtual IRS intelligence research specialist basic training program where we covered toll records in our software called PLX. I also attended an advanced IRS techniques course in August of 2021. I attended a PLX advanced course, which covered the analysis and review of toll records in December of 2021. In August of 2022, I attended a 4-week in-person academy, Intelligence Research Specialist Academy, and then I also attended the FBI's CAST cell phone analysis training in the summer of 2023.
You're trained in CAST, in PLX, and utilizing Cellbrite and other applications to review different types of data.
Yes.
I want to talk about your involvement in this case. Back in 2022, were you employed as, and I'm going to call it IRS for short, as an IRS with the ATF?
Yes, I was.
And were you assigned to the Jacksonville office in 2022?
Yes, I was.
How did you become involved in the homicide investigation into the murder of Jared Bridegan?
I was notified by an ATF special agent that the homicide had occurred, and I was asked to assist in the investigation.
Can you describe for the jury what your role as an IRS is in an investigation like a homicide?
Sure. So I would review various types of records, assist investigators with interpreting those records, provide investigative leads, things of that nature.
And in this case, you did some preliminary cell site and timing advanced mapping to assist the investigators.
Yes.
And then later coordinated with Agent Blythe with the FBI regarding that mapping and data.
Correct.
Do you participate in investigation to the extent of a sworn law enforcement officer, like going out in the field, interviewing witnesses, collecting evidence?
No, I do not interview witnesses or directly collect evidence.
And you don't write any reports about your work?
Correct.
You mentioned something called toll records, which is a big portion of what your testimony is going to be today. Can you tell the jury what toll records are?
Sure. So toll records are essentially kind of like the call log that you all have on your phones. It's records that we receive directly from the cell phone provider, and it provides information such as date, time, the number that the phone is communicating with, the duration, the direction, things of that nature.
And in this case, where you provided toll records for several different individuals to include Henry Tenen, Mario Fernandez Saldana, Shanna Gardner, John Biggerstaff, among others, but mainly the focus of what we're going to talk about here today.
Yes, I was.
Where you also provided Google data returns for Henry Tenen, Mario Fernandez and John Biggerstaff in this case?
Yes, I was.
Let me pull up my PowerPoint for everyone. I'm starting with what's been marked and entered into evidence as State's Exhibit 214. Can you tell the jury what we're looking at here on your screen? And it's really hard to read. Don't worry, we'll explain what it is.
This is a Excel spreadsheet containing the toll records for the telephone number 904-566-2633 for the time frame January 1st, 2022 to August 23rd, 2022. Those dates and times were pulled in UTC time, so that's why there's a little bit of a difference when you get down into the data.
So this is a spreadsheet. You did some conversions for UTC time.
I did.
And are these the same records or substantially the same records other than you've included highlighting and a UTC conversion as the toll records from Mario Fernandez received through T-Mobile, which is State's Exhibit 179?
Yes.
And the jury's going to have both, but for ease of interpreting them, they've heard briefly what UTC is, but could you give them a refresher?
Sure. So UTC stands for Coordinated Universal Time, and it's the standard used to establish time zones across the world. So UTC is at UTC 0. In order to get to Eastern Standard Time in the winter months or Eastern Daylight Times in the summer months, you have to subtract hours from the UTC time. So when we need to get to Eastern Standard Time, we subtract 5 hours from the UTC time. When we need to get to Eastern Daylight Time, we subtract 4 hours from the UTC time.
So looking at State's Exhibit 214, as an example to the jury, the first entry for January 1st, 2022, column A is going to be the date of the transaction, meaning some kind of communication on your cell phone, cellular device with this phone number. And this time here, can you explain the difference between columns B and C and what you've done to make this easier to interpret?
Sure. So I took the date and time represented in columns A and B. I combined them together. Then I adjusted the date and time so it would reflect for January 1st Eastern Standard Time. So it's UTC minus 5 hours.
So later, if the jury's looking at these records and they want to know the correct date and time for Jacksonville, Florida, our time zone, would they look in column C?
Yes.
So for example, on transaction line 2, we see 1/1/2022, 1/30/06, and in column C, we see 12/31/21, 20/30/06. What is the adjusted time for the correct time zone?
We subtracted 5 hours.
And we ended up with 20/30/06, which is going to be 8:30 p.m.
Right, on December 31st.
And those are in military time, so hopefully someone knows how to subtract 12 in that jury room. Call type, what is column E going to show us?
The call type shows the type of communication represented in that row. So SMS would be an SMS message. There will be calls represented as well. MTC is a mobile terminating call. So that's a call that's coming into the device that we're looking at. MOC is a mobile originating call. That's a call that's going from the device that's we're looking at. And there's also RCS messages, which is rich content messages, which is kind of just more of a modern text service.
So when we look in the column E, we see MOC and MTC are going to be calls, incoming and outgoing. SMSC and that rich messaging, I can find one. Here we go. RCS, IM chat. Are these just different ways to indicate a chat or text feature like you use when you're texting?
Yes.
And then there's also a column here, column D, for duration. For our calls, not text messages, there will be indicated in seconds the length of a phone connection.
Yes.
Column F, what is this going to indicate?
That indicates the direction of the voice call.
For voice calls, and sometimes we can get that on chats, but not text messages.
If you keep scrolling down to the RCS.
There we go.
Yes, so the RCS IM chats are all going to reflect as outgoing. It's just recording the existence of an RCS chat at that time.
And then G, column G is going to indicate what?
That's going to be the calling number, so the number who initiated the communication.
So, for example, in transaction line 4, we see the calling number is 904-566-2633, which is attributed to Mr. Fernandez. So that means he is making the call. The call is originating from his phone number.
He is sending the SMS chat, SMS message.
Yes. And then here, a called number is at the receiving phone number for the SMS or the outgoing phone calls or the RCMS.
Yes.
And for example, in this one, line 4, we see the called number at 708-4571. They will have a chart of phone numbers back there, but is that the phone number for Shanna Gardner?
Yes.
And you've done some highlighting here also for ease of interpreting these records relevant to this investigation. We have a cell color coding, so all the calls highlighted in green are going to involve an individual phone number attributed to a Shanna Gardner.
Yes.
The blue calls are going to be attributed to the phone number for John Biggerstaff.
Yes.
Yellow for Henry Tenon.
Yes.
Purple for Janie Deal, which we'll get to later in your testimony.
Yes.
And then here, we've got 3 phone numbers listed from Mr. Fernandez's toll records. A secondary phone number for Henry Tenon, a phone number for Kirsten Bridegan, and a phone number for Jared Bridegan. And there were no transactions in these records for those numbers.
Correct.
Okay, so I want to talk about some specific dates of interest within his toll records. Beginning with January 29th, 2022. And everyone's got to be a little bit patient with me trying to scroll through all these records. All right, so we have, beginning on transaction line 1402 through transaction line 1451, all the tolls attributed, well, actually, I'm going to do this the other way. We're going to look at the UTC conversion in column C. We've got 1453 as the last transaction on the 29th, and 1407 as the first transaction on the 29th.
Yes.
I'm interested, one, these yellow highlights, what does that indicate about who these transactions are occurring with on January 29th, 2022?
Those are communications with the phone number attributed to Henry Tenon.
And the adjusted time on these in column C is, these appear to be SMS. Would that be text messages?
Yes.
And the adjusted time appears to be 13:13:02, 13:13:13, 13:15:13, and 13:15:26.
Yes.
We can see here that these messages, 3 of the messages originated from Mr. Fernandez's cell phone to Mr. Tenon's phone. 1 of the messages originated from Mr. Tenon's phone to Mr. Fernandez's phone.
Correct.
And what is the time in converted time from military to, or how we Americans like to say it? What are the times of these communications and transactions?
1:13 and 2 seconds p.m., 1:13 and 13 seconds p.m., 1:15 and 13 seconds p.m., and 1:15 and 26 seconds p.m.
And we see here that there is some activity initiated by this phone number, meaning presumably initiated by Mr. Fernandez, to send text messages.
Correct.
I'm going to call that active usage by the phone holder or the phone subscriber. Between this 1:15:26 p.m. text message outgoing from Mr. Fernandez to Mr. Tenon, is there any other active cell phone usage on the part of Mr. Fernandez or whoever's holding his phone in the time frames between 2 p.m. and 4 p.m.?
No.
So there's no indication that this phone number, Mr. Fernandez's phone number, actively was utilizing cell phone towers to send messages or to make calls during this time frame.
Not based on these records, no.
And here we see at 15:43:16, 17:10:14, and 183822 on lines 1444, 1445, and 1446. Incoming text messages from a 2300 number. Based on your knowledge of toll records, as best you can, what does this show?
Based on my understanding, this could mean a number of things. This could mean some sort of network routing that's being done through the device. It could mean a notification of some sort. It could be a short code received. There's a couple of different things that it could mean.
Does it indicate any active use or activity by the cell phone belonging to Mario Fernandez to somebody else?
Not based on my understanding, no.
And then the next contact after these texts with Mr. Tenon and these unknown notifications, we have a text message coming into Mr. Fernandez's phone at 1841 on the 29th, which would be 6:41 p.m.?
Yes.
And who is that text message from?
Ms. Gardner.
So on the 29th, just to recap, there is no active cellular usage by this phone number during the time frame between 2 p.m. Well, actually, the last active we have would be what? 1:15 p.m.? And then the next outgoing text from Mr. Fernandez is going to be 6:55 p.m.
That's correct.
I want to move ahead to February 16th of 2022. And by the way, here as I'm scrolling, did you notate every single transaction that you observed between Mario Fernandez and the phone number ending in 7612 belonging to Henry Tenon in yellow?
Yes, I did.
So as we scroll through, we'll see, and I'll get to that in a minute, but did you observe transaction and communication activity between Mario Fernandez and Henry Tenon in January, February, March, and April of 2022?
Yes, I did.
So we're moving ahead. We see some highlighted transactions on February 15th, 2022 between Mr. Fernandez and Mr. Tenon, beginning in lines 2, 3, 6, 4, and continuing on. And on that same date, we see highlighted in blue a number of transactions, and whose phone is indicated by the blue highlights?
That's the number attributed to John Biggerstaff.
So on February 15th, we have communications with Mr. Tenon and then communications with Mr. Biggerstaff.
Correct.
Moving to the 16th, I want to talk about a time frame. So beginning with our corrected from UTC to Eastern Standard Time in column C, the first transaction for 2/16/22 here on 2419. And we'll go through this date. Can you give me the times of the communications here in blue on February 16th with Mr. Biggerstaff?
Sure. 3:43 p.m., 3:43 p.m., 3:46 p.m., 4:23 p.m., 4:23 p.m., 4:23 p.m., 4:23 p.m., 4:26 p.m., and 10:46 p.m.
Here we see an incoming call to Mr. Fernandez's phone on February 16th. What time did this call come in?
6:08 p.m.
And then we have an SMSC originating from that 2300 unknown notification. What time did that notification come in?
6:29 p.m.
And lastly, we see an incoming phone call. And what time did that come in?
7:09 p.m.
Ms. Butler, you had mapped data previously. Have you had the opportunity to review Agent Bobby Blythe's slides regarding timing advanced data mapping for Mr. Fernandez's phone on February 16th?
Yes.
And we have here on States Exhibit 182, slide 41. Have you seen this slide previously?
I have.
And it shows here a timing advanced transaction at 7:09:53 p.m. And does that generally correspond with the last cellular activity on his phone during this time frame here in line 2441?
Yes.
Is there any cellular transactions between 7:09 And actually, I'll just ask you this. When is the next cellular transaction in the records after that 7:09 p.m. on February 16th?
10:46 p.m.
Are there any cellular activities between those two time frames in these records?
No.
And you've reviewed Agent Blythe's slide that also indicates there are no timing advance records for an overlapping portion of time to the toll records that you reviewed.
Correct.
I want to talk about, I'm showing you a chart that you made for demonstrative purposes for today's testimony. Can you explain to me what we are seeing here in this chart?
This is a chart of the number of communications between the phone number attributed to Mr. Fernandez and the phone number attributed to Mr. Tenon between January 1st, 2022 to August 23rd, 2022, and this reflects the adjusted time zone from UTC.
And when you are including communications, what are you including in this tally as to the total amounts?
I'm including any record that was present in the toll records that were returned from the cell phone provider.
That include incoming calls, outgoing calls, and text messages or chats?
Yes.
We see here in January of 2022, there were 26 communications between Mr. Tenon and Mr. Fernandez, or at least those phone numbers associated with them.
Yes.
And in February, how many communications were there between the two of them?
37.
In March?
32.
In April?
21.
In May?
9.
In June?
5.
In July?
2.
In August?
0.
I'm showing you, as for demonstrative purposes, Mario Fernandez Saldana's communications with John Biggerstaff for the same time frame. And similar to the last one, did you include all incoming, outgoing calls, text messages, and chats?
Yes.
And here, how many communications between Mr. Fernandez's number and Mr. Biggerstaff's number were there in January of 2022?
27.
February?
70.
March?
0.
April?
42.
May?
55.
June?
84.
July?
91.
And August?
45.
And your toll records for Mr. Fernandez only go through August of 2022?
For this exhibit, yes.
I want to ask about one more date in these records. Actually, two more dates. As I'm scrolling, we're seeing there's a lot of transactions in green from Ms. Gardner. I want to ask about these transactions here for March 10th of 2022. Highlighted in yellow, beginning on line 4185 through lines 4192. These are transactions with Mr. Tenon, and can you go through them, just these few highlighted ones, line from line, and say what time they were and what type of communication, and from whom to whom?
Sure. The first one was all on March 10th at 3:16 p.m., a text message from Mr. Tenon to Mr. Fernandez. The second was at 3:17 p.m., a text message from Mr. Tenon to Mr. Fernandez. The third was at 3:28 p.m., a text message from Mr. Fernandez to Mr. Tenon. The next one was at 3:36 p.m., a voice call from Mr. Fernandez to Mr. Tenon. At 3:48 p.m., another voice call from Mr. Fernandez to Mr. Tenon. At 4:12 p.m., a text message from Mr. Fernandez to Mr. Tenon. And then finally at 4:36 p.m., an incoming voice call from Mr. Tenon to Mr. Fernandez.
And we see some of these calls include duration data. For this call on line 4188, how long was the duration of that call?
4 seconds.
And then here at this call on 4192, what was the duration of this call?
1,638 seconds.
About how long is that? How many minutes would that be?
I believe it's approximately 27 minutes.
And I ask about that date specifically because as part of your investigation, did you pull those records and provide them to detectives based on a specific date being of interest to you all?
Yes, I did.
And what was the date of interest to you when you looked at these records and pulled those March 10th phone calls?
Based on my understanding, on March 9th, the Jacksonville Beach Police Department released images of the suspect vehicle, the blue Ford F-150, to the media.
Do you know the total duration of minutes total from these records between Mr. Fernandez and Mr. Tenen for these transactions from January through July of 2022? How many minutes total did they speak over this 1, 2, 3, 4, 5, 6, 7-month time period?
It was over 10,000 seconds, approximately 176 minutes, which is approximately 3 hours.
And then here with Mr. Biggerstaff on Mr. Fernandez's phone, the tolls indicate that they were in communication in January, February, and April of 2022.
Correct.
All right, I'm going to move on to Mr. Fernandez's Google return. And I'm going to, this is going to be State's Exhibit 185. Did you receive a return from Google for Mr. Fernandez's Google account linked to his Gmail address?
Yes.
Can you describe for the jury what a Google return is? Is it like a cloud?
Sure. It could be considered equivalent to the iCloud for Apple devices, but it contains a ton of records, quite frankly, for the Google account. So it'll have search history, YouTube history, sometimes it has location data, email content, messages, photos, just everything having to do with that account.
I want to talk about some exhibits that you thought were of interest that you pulled for investigation purposes in this case. Beginning with, when you receive a Google return, is this how it looks to you when you're viewing it through your Axiom program?
Yes.
And we see here evidence sources 2, and there is one return here and one return there. Can you explain to the jury what this screen indicates?
Sure. So the return on the left was the first return received, and it covered the time period from January 1st, 2022 to April 15th, 2022. The return on the right is the second Google return that was received, and that covers the time period from November 1st, 2021 to March 27th, 2023.
Do you remember when investigators, first of all, do you have to obtain these by a search warrant?
Yes.
Do you remember when these returns were returned from Google?
I don't know the exact date, but it would have been after the end date listed in the return.
Was there a time gap between law enforcement's receipt of the return number 1 to return number 2?
Yes.
I'm starting with the first return you received in States 185. When you were reviewing it, did you look in the contacts to see if Henry Tenen was a listed contact in Mr. Fernandez's Google Cloud?
I did.
And here we see, is this how you search? This is a screenshot. Is this how you search and find those contacts in that Axiom report?
Yes.
And there's a highlight there, and it says Henry at Potomac, and over here we see the artifact information. Whose phone number is that so that we can attribute it to whoever Henry at Potomac is?
That's Henry Tenen's phone number.
And he has him listed there as Henry at Potomac. Moving on to the return number 2, law enforcement received this return after the first one. Did you also review to see if Mr. Tenen was a contact in the second Google Cloud return for Mr. Fernandez?
I did.
And here is the contact list. Was Mr. Tenen a contact in Mr. Fernandez's Google return in the second return law enforcement received?
No, he was not.
I want to talk to you about some analysis you did of deletion data in Mr. Fernandez's Google account. Are you able to go into someone's Google return and see if they have deleted data from their Google account?
Yes.
Can you describe to the jury where you look and how you find that?
Sure. So within the Google return, there's a folder called My Activity that contains information about activity associated with the account for different Google products. So there'll be Chrome data in there, search data. There's also a folder titled Deletion Markers. And within that folder, there is a file that contains the records of the deletions process from the account.
Did you pull spreadsheet reports of the Google deletion data in Mario Fernandez's Google returns?
Yes.
I'm going to start by showing you what's been entered into evidence as State's Exhibit 202. And this looks like Greek to me, but can you explain to us what this shows?
So this primary file, based on my understanding, contains information about bulk deletions of data or mass deletions of data. So this would be if a user requests the entirety of their search history to be deleted, the entirety of their YouTube history to be deleted. Google refers to them as corpus deletions.
And these specific exhibits, did you pull Google deletion for a specific time frame?
I reviewed all of the Google deletions that were available.
In coming to understand and learn how to interpret these records, have you personally yourself had training or conversations with members of Google in order to understand and interpret these records?
I did speak with members of Google's law enforcement team, yes.
I'm going to turn your attention to State's Exhibit 213, which is the secondary database of Google deletion records. Can you explain to the jury what is contained in, based on your experience and your conversations with the Google law enforcement team, what's contained in this database?
So column A is going to be the date and time in UTC, that's what that Z means, that the deletion was processed from the account. The column B has the original event timestamp, so the date and time of the original record that's being deleted. And column C has the product associated with the deletion in that row.
And here in the secondary database, we see that there was a total of 11,511, well, 510 if we take out the top deletion markers. But I want to ask you about specific time frame. Did you look at deletion markers for a specific time frame in this case?
I mapped all of the deletions, and when I did that, it allowed me to focus in on a more specific time frame.
Was there a statistical, I won't say outlier, but something of statistical significance to you when you mapped the deletion of the Google records?
Yes.
And have you prepared a chart showing that deletion rate over time?
Yes.
And does that chart fairly and accurately show the data when it's mapped out in terms of the volume?
Yes.
I'm showing you what's been entered into evidence as State's Exhibit 215. This is a Google deletion data by processed date chart. And can you explain to the jury what we're seeing here?
Sure. So this is using the secondary database that we just viewed, or the secondary spreadsheet that we just viewed. And it is breaking down the number of processed deletions by date for the entire time period that we had records for.
And as a data analyst looking at this chart, what stood out to you as being of potentially evidentiary value?
March 1st of 2022.
And why did that date stand out to you?
Because there were over 5,000 processed deletions on that date.
And was the date, did you look at the time and date range of these deletions?
I did.
When they started and when they ended, and can you give the jury idea of when they began?
Sure. So for the March 1st date specifically, the deletions started early in the morning, approximately 06:11 hours. And I'm not sure exactly when they ended, but the bulk of the deletions on that day were at 06:11.
And during your work on this case, was there something significant in the investigation that occurred on March 1st of 2022?
Yes.
What was that?
That was the date that Mr. Fernandez and Ms. Gardner were interviewed by Jacksonville Beach Police for the first time.
And to your knowledge, Mr. Fernandez spoke to Jacksonville Beach Police on February 28th to arrange to come in on March 1st for his interview.
I believe that the contact was made through Ms. Gardner, who then contacted Mr. Fernandez.
And are these deletions prior to when he would have arrived at the Jacksonville Beach Police Department for his interview?
Yes.
Speaking of February 28th into March 1st, 2022, when you were reviewing Mr. Fernandez's Google return, did you also find internet searches that appeared to be of evidentiary value?
Yes.
Can you explain what those were?
Sure. So in the evening of February 28th, this would be at approximately 6:02 p.m., around that time there were multiple records that indicated that there were searches or viewing of maps associated with areas in Pittsburgh, Pennsylvania, as well as North Carolina.
And did you also review and obtain evidence related to cell site data from Agent Blythe that Mr. Fernandez had driven to North Carolina and then Pennsylvania after his interview with police at the Jacksonville Beach Police Department beginning March 2nd?
Yes.
Did you do any investigation into the nature of that trip and look up any toll records or financial records related to his trip to North Carolina and Pittsburgh?
Yes, I did.
Can you describe for the jury what records you reviewed?
I reviewed toll records. I reviewed financial records that came back. I reviewed receipts that were obtained by the detectives, among other things.
And what stood out to you from your review of those records as being potentially of evidentiary value?
In North Carolina, it appeared that Mr. Fernandez visited a Walmart and purchased what could be described as toiletry items. And then as he continued his trip up north, there were multiple phone calls to hotels in the Pittsburgh area and ultimately a reservation that was made.
And how many nights did he make a reservation for at a hotel in Pittsburgh?
2 nights.
And how many, according to your review of toll records and the cell site records, how many nights did he actually stay?
1 night.
And let's talk about a little bit about the phone activity during this time frame. From March 2nd to March 6th. Particularly on that March 6th, that day that he came back, was he communicating with anybody of significance in the investigation?
He had multiple communications with Miss Gardner.
Was there anyone else's phone number that stood out to you as being potentially of interest to you in reviewing his toll records during that trip?
Mr. Fernandez communicated with Miss Gardner's father, Sterling Gardner, as well as Miss Gardner's sister.
And since the jury hasn't seen it yet, I'm going to show you the documents that you recovered as part of the investigation. Is this a receipt that members of Jacksonville Beach Police Department obtained for Mr. Fernandez at the Walmart you spoke about in North Carolina? Hold on. State's Exhibit 195.
Yes.
And you said that he purchased some, what you would consider to be toiletry items.
Yes.
Why were these records, the toll records, the financial transactions, the searches, and the cell site data, why was that significant to you?
It seemed that the trip might not have been planned very far in advance, and it also coincided with the CPT interviews that were being conducted of the 2 juvenile children in this case.
I want to talk to you next about the Google return you received for John Biggerstaff. And this is going to be contained in State's Exhibit 187. Did you receive a Google Cloud return for John Biggerstaff similar to the one you received for Mr. Fernandez?
Yes.
And was that received via search warrant?
Yes.
So here on State's I'm going to publish to everyone. Here on State's Exhibit 187, we see a extraction report for a Google return, and this shows user accounts. Can you explain to the jury what user accounts are?
So these are accounts that are associated with the Google account that the search warrant was obtained for.
And we see here we have biggerstaffjohn904@gmail.com and a user ID for a Google account. Were you able to search through Mr. Biggerstaff's Google Cloud, including his web searches and web browser history?
Yes.
And in doing a web search, did you find some searches involving firearms and ammunition?
Yes.
Before we get to that, was the date of those searches significant to you based on cellular data that you had mapped and that later Agent Blythe had mapped?
Yes.
And what date are we talking about?
January 25th of 2022.
And what had the cellular data shown about January 25th, 2022?
It showed that Mr. Fernandez's device was in the area of Mr. Biggerstaff's residence from approximately 1500 to 1630 hours, so approximately 3 p.m. to 4:30 p.m.
And when you were going through Mr. Biggerstaff's search history for that date, January 25th, 2022, what type of searches did you find?
I found searches for 10 millimeter, the search says 10 millimeter Glock pistol, and that was at 8:15 p.m. on January 25th.
And these are not converted out of UTC the way that Google has them here. So it's when it says UTC, does that mean the jury needs to subtract 4 hours?
Subtract 5 hours.
5 hours. So we're still in Eastern Standard Time.
Yes.
Subtract 5 hours. So explain to the jury, is this how the data appears to you when you look at the Google records?
It is.
We have on our slide here 3 searches. The first one, Glock 20 Gen 4. Second is 10 millimeter Glock pistol, and third is 10 millimeter Glock pistol. And then the next slide, we see in the same time frame a Chrome search. And what does this indicate?
It's indicating that the account visited the website listed here, so guns.com, looking at Glock G20 Gen 4s.
And are you able in the return to actually see a screenshot of the page that was visited, captured at the time that it was visited?
Yes.
And so moving through the slides we have here, is this what Mr. Biggerstaff would have visited at guns.com when he clicked on those Chrome searches?
I cannot say that this is exactly what he would have seen, but this is what pulls up when you click that link.
And we see a couple photographs of Glock G20 Gen 4 10 millimeter pistols. What else did Mr. Biggerstaff search for? And can you give us a date and time of these searches?
Sure. So this one has the bottom 2 are the search.
Well, if we go down in 15 minutes, you'll know why. So if we go down, if YouTube takes us down in 15 minutes, you'll know why. I tried to block that, but yeah, we'll see. Hopefully we won't go down. Usually about 15 minutes later. So if we're still up at 12:15, that means we're okay. But if we go down, you'll know why.
Searches that we talked about on the last slide. The top one is a search on January 25th, 2022 at 8:17 p.m. For a 9 millimeter Smith & Wesson pistol.
And then for the following slide,
these are searches for 10 millimeter pistols.
And then on this slide, can you give us a date and time and what he was searching?
Sure. So this would be January 24th at, 9:03 p.m. for pin on hidden gun case. The middle one says that he visited, or the account visited Willa Hyde, introduces all no hidden storage furniture line, and then additional searches at the top for pin on hidden gun case.
Okay, the last date I want to ask you about of being of some significance is August 18th, 2022. Was that a significant date in the investigation?
Yes.
And why was that a significant date?
That was the date that Henry Tenon was initially arrested for driving-related charges.
And starting August 18th on line 19722, this is at 7:57 a.m. That's the first contact that day. At the next line, 19723, can you tell us what time and date this call was?
That was August 18th at 8:33 a.m.
And was Mr. Tenon already in custody at that point?
Yes, he was.
And this is indicated in purple as an outgoing phone call from Mr. Fernandez to this phone number, duration 7 seconds. Whose phone number is this in purple?
That phone number has been attributed to Janie Deal.
And who is Janie Deal?
She is Henry Tenon's girlfriend.
Was this the first last and only phone call to Ms. Deal and Mr. Tennant's toll records for this time period from January 1st to August 23rd, 2022?
Yes, it was.
Last thing I'm going to show you is State's Exhibit 207. As part of your IRS duties, do you also do research on individuals, obtaining photographs, background information, associated addresses, that type of information? And did you find a photograph of Mr. Fernandez and Ms. Gardner that was taken after the death of Jared Bridegan?
Yes.
Is this the photograph here in States 207?
Yes.
Where did you obtain that photograph?
I obtained this photograph from a blog, Shelly.com.
And who is Shelly?
Shelly Gardner is Shanna Gardner's mother.
And do you remember approximately what date this photograph was posted?
Let me check my notes. I believe this was posted in March of 2022.
Thank you, Ms. Butler. I have no further questions, Your Honor.
All right, members of the jury, you all wanted to take the break, correct? Is that right?
Yes, correct.
Okay. Members of the jury, we're going to take our lunch recess at this time. We will return back in session at 1 p.m. Thank you. Court's in recess.
Good vibes, maybe a little bit of both. Mario's definitely a slight figure. 5'6" maybe. He's kind of like Prince. Kind of reminds me of Prince. So maybe 5'6"-ish, and Shanna maybe 5'10". So she could be, 6. Yeah. So, all right. So we are going to feed the kitties real quick. Grab a quick bite. And get ready for this 12:30 hearing that's coming up. So, but what I found interesting about that testimony, again, I was thinking, oh man, we just heard this. We heard this testimony from Agent Blythe about cell phones, and I was like, oh, why are they going to show us again? But basically, the takeaway from that was that, well, there's a couple takeaways. I didn't think this was a big deal. Communications with Henry ramped up in March and then ended in August, 0 in August. Well, he got arrested in August, so that's not a big deal. Okay, whatevs. Then the deletions. 11,511 deleted items. And on March 1st, which was the day they were interviewed, Mario and Shanna were interviewed on March 1st. He deleted over 5,000. I think it was like 54 maybe. I couldn't quite see because they didn't zoom in. But I think it was like 5,400. So 5,000 items were deleted. And then he communicates with Shanna's dad, Sterling, and her sister while on the trip. Okay, I'm not sure what that's about. And then there's that photo of them on March, or in March. It was posted by Shelly, who is Shanna's mother. So the big takeaway for me from that, over 5,000 items were deleted. I think those were those his Google searches, because they were talking about his account and his searches. So were those? It's just Were those searches that he deleted, or were those like photos? I want to think it was searches, because she was talking about his Google account. So I think it was both. So I'm just saying items, 11,511. So, all right. Laura, welcome in. How are you? Good to see you. Adam, 91 calls. There were 91 calls with John. Yeah, John Biggerstaff. In July, there were 91 calls. So January, there were 27. February, 70. 0 in March. 42 in April. 55 in May. 84 in June. 91 in July. And 45 in August. There was another one. There was another thing that... there was a 27-minute phone call with Henry on March 10th. The only reason that was significant is because Jacksonville Sheriff's Office, JSO, released a photo of the blue truck on March 9th. So there's another thing. You know, these coincidences, unfortunately, are starting to add up. Hey Gina, yes, very sus. Yeah, these things are starting to add up. Sleep with one eye open. How are you? All right. Okay, Erin had a great suggestion, as she always does. Let's just rewind and watch what happened. That's going to lead us to... Where is it? Hold on a second. It happened at 9:30. Here it is. All right, we're going to play leading up to this hearing. We're going to play this in case you guys missed it. We're going to play this again.
Courtroom. Everyone may be seated.
Yes, ma'am.
Mr. Fernandez needs to go in the back. I need Miss...
able to generate.
All right. This is what's leading up to the 12:30.
I guess all I'm saying is I don't know if it connected to Mario Fernandez's Wi-Fi, but there's enough Wi-Fi access points around there that the phone was able to generate a Wi-Fi based location.
All right, let me pause you for a moment. Members of the jury, I need you to go into the jury room, please. Step outside the courtroom. Agent Blythe, I'm going to ask you step outside the courtroom. Everyone may be seated.
Yes, ma'am.
Mr. Fernandez needs to go in the back. I need Miss Bridegan to step up, Mr. Clifton to step up, and get Kirsten Nelson on the phone. On Zoom, switch over. If the state would clear the way so they can have a seat. Do you want to call your appellate counsel? They can join via Zoom. Ms. Bridegan, you can sit down. It's okay.
All right, for you guys just coming in, we're replaying this. All right, we're replaying this. This already happened, so we're just replaying this. I just want to have this lead up into the 12:30. So we're replaying this. We've already watched this. We're replaying it for those that haven't seen it already. So we're not on a delay. We're just replaying it. I'm going to fast forward to where it gets more talking happens. Because there's a lot of dead space here. So let me... So we're going to be feeding our cats and grab some food before this 12:30 hearing. Let's get to the meat of it.
Firm. Are the attorneys from the Gardner firm on
yes,
Zoom?
That's Rafa.
Good morning, Your Honor. Kirsten Nelson on behalf of Ms. Gardner.
Here we go.
I believe Jose Baez and Ron Sullivan are also present.
All right.
Yes, Your Honor.
Okay. Good morning. Is Mr. who's Sam Solario?
Sam, if you can hear us, could you just announce your presence?
I can hear you fine. I'm not visible because I'm unsuitably attired for court, Your Honor, and
Yes.
I didn't want to appear poorly.
Yes, sir. I appreciate that. Thank you. So, Mr. Clifton, for purposes of this hearing, I received, while I'm in the middle of the trial of the state of Florida versus Mario Fernandez Saldana, I received an email indicating that Ms. Bridegan is refusing to comply with the court order. Is that correct?
Yes, Your Honor.
All right. And then Ms. Nelson is the person that notified the court. So, Ms. Nelson, I'll hear from you.
Thank you, Your Honor. I also apologize. I am not suitably attired for court, so I will keep my camera off. We are moving for a motion, or our motion is for an order to show cause why Ms. Bridegan should not be held in contempt for failure to comply with the court's August 11th order, as well as the order this morning and the order yesterday.
Ms. Nelson, do you agree that it would be indirect contempt of court?
Yes, Your Honor.
Mr. Clifton, do you understand the nature of the motion for an order to show cause?
Yes, Your Honor.
All right. So it is basically noncompliance with the court's order that was entered in on August 11th. And for the record, the court had a hearing that was requested based on the subpoenas that were issued pursuant to a prior order. The court heard the objection of the party, the non-party. I then, after that hearing and after consideration of the side that was presented during the objection, the court overruled the objection and issued an order of compliance because it was not being complied with. That is the prior order. Then this morning at approximately 7:19, this court got notice that Ms. Bridegan wanted, counsel filed a petition for all writs. The 5th District Court of Appeal has docketed now the appellate process, which is the appropriate way to go if there is disagreement with the court's decision. In the trial court, I believe it was you, Mr. Clifton, that filed the motion to stay this morning. It was approximately, I think, about 8:15 or 8:20.
About
maybe
20 p.m. last night, Your Honor. But
it was 10:20. I didn't get notice of it until early this morning.
Yep.
Then defense counsel filed a response. The court then issued another order denying the stay and denied it within, I believe it was about 8:30ish, giving Ms. Bridegan 30 minutes to comply with the court's order. Additionally, in the prior hearing, in the prior order, the defense has gone through the expense of asking and paying for an expert to come up to take possession of the phone to comply with the court's order and then return the phone to Ms. Bridegan in short order so that she could have her phone basically selectively downloaded and then returned to her so that there would be as little time away from her phone as possible. And so that is what is not being complied with. Do you believe that this is sufficient notice, or I can write the order to show cause? I'm going to grant the order to show cause, and I can write down date and time. Pursuant to the rule, I believe that you are entitled to reasonable time to prepare a defense for Ms. Bridegan.
We would want reasonable time to prepare a defense.
All right, and I hope that this is not to wait out whether the 5th District Court of Appeal is somehow going to stay. But I will give you, right now, I stopped the trial at exactly 9:30. What do you believe reasonable time would be, Mr. Clifton, for you to be prepared for the defense of an order to show cause for noncompliance, which is indirect criminal contempt of this court?
Your Honor, looking to do this today?
Yes. Because the expert drove up today, and so I don't...
I understand, Your Honor.
Okay.
2 hours?
Can we...
And we have a lunch coming up at some point. 12:30?
Yes, sir. Yes, sir. I will, if you require, I will. I will have something written up and filed for you to answer to. If I can get it probably by 10:15, and then I would have the hearing, I would say, at 12:30. Is that reasonable?
Yes, ma'am. That would help.
Yes, sir. All right. And whatever counsel, if you all could get in, do you want Ms. Gardner transported?
No, Your Honor. We'll waive her presence. Thank you.
All right. I will see you all again at 12:30 for this hearing, okay?
Thank you, Your Honor.
All right. Thank you.
Thank you.
It goes without being said, Ms. Bridegan, you need to be present again, okay? Go get the jury to get back ready as soon as... All right, so that was kind of a preview, I guess, of 12:30. So we've got about 10 minutes. Got about 10 minutes before they are due back in court. So
she's drawn a line in the sand. She's saying no. You can't have my phone at all. But as Judge said earlier or yesterday, she's protected constitutionally to. She can't just hand over her entire phone. They can't just ask for her entire phone. Kay Brownie, she looks about to smile like she's thinking, put me in jail, go ahead. Yeah, I guess. I mean, from a legal standpoint, judge has to do what a judge has to do. Just like, the law is the law. And if she is found in contempt, she will spend time in jail. It won't look good from a public opinion, PR standpoint. I don't know what the end game is going to be. Will Kirsten have sympathy for her on her side, or will people be, she's not, I don't know. I mean, but again, that's the court of public opinion versus the law is the law. Judge Kite has to follow the law. So no, the jury won't know it. Yeah, jury's not going to know this at all. This could mess up Shanna's. I mean, they were already very, very aware of the publicity that this was getting, and will it possibly affect Shanna's jury selection? It could. It could. Let me see if. Hold on a sec. Let me see if I can grab some. Let's see if we have any news reports. Let's see here. See if there's any shorts. All right. All right. Nobody's uploaded any shorts yet there. Let me see. See if there's anything over here. I'm seeing if the news has done anything. All right, nothing there. All right, I guess they're probably going to do something later. They may have it live. They may be talking about it on their live. Robot, why is the judge unwilling to wait for the Court of Appeals to come back with a decision? It sounds like there's something already pending with the 5th District. I just brought this over because I didn't want Rafa to eat the cheese. Maybe she, she said it's an emergency. She said this is, maybe she can't wait. Maybe she can't wait. The wheels of justice are churning and she can't wait. I don't know. Sure. I really don't know. I don't know. Oh, you hear that sound? That's the sound of pizza. That's the sound of pizza being ready. Good Vibe says, please forgive me. Is this Mario's defense team or Shanna's defense team compelling this? Shanna. This is all about Shanna. Mario got sent out of the room. He's not private or privy to this. This is all Shanna's defense team wanting access, saying that it goes to bias, possibly, and we're only speculating, possibly because Kirsten was talking to her kids and or adults about what to say, most likely her children. So it could be, witness tampering, I suppose, even. I don't know. Adam, the scope of what they can look at needs to be narrow and specific. Judge has totally said that. Judge has said that multiple times. And Mr. Clifton's argument, sorry guys, you hear that sound? That's the sound of Aaron eating pizza. No. So Mr. Clifton's point is like, we don't even know what we're objecting to. They want everything and we don't even know what we're objecting to. So that's his position. So it's messy. It is absolutely messy. So we will stay here for sure. I'm hoping that, let me see. So all I have is just a don't have any. I was hoping for like a news clip. They're just showing the video, which is what we did. All right, so we just wait. Horse welfare, how is the narrow and specific enforced? That's going to be Judge Kite. Everything has to go through her. She's going to be the gatekeeper. She has said that multiple times. I don't know why Mr. Clifton and Kirsten are kind of digging their heels into this, because Judge Kite has said it's going through her. Judge Kite has said multiple times, Kirsten is protected constitutionally. You're not just going to get her phone and just go willy-nilly through it. So, Shanna, you had to leave, just got back. Are we good? I'm good. I got a slice of pizza here with my name on it, which I'll get to afterwards, but maybe I can shovel it in 5 minutes. All right, I'll be back. All right, welcome back, everybody. Welcome back. We are waiting for this hearing to take place regarding Kirsten Bridegan's cell phone. So it was supposed to happen at 12:30. So I can get rid of this. Don't need that anymore. Come down here a little bit. All right. Let's see, Mike. I did not block you. I haven't blocked anybody. I don't block people. Thank you, Kimbers. Thank you, Debbie. Thank you, Horse Welfare. We have no audio right now. Correct. I did not put any music on. I didn't think you guys wanted to hear me eating. Mike, I don't block people. So, Mike, are you still around? Let me see if I'll tag you. Mike is gone. Mike, I can't tag you. Oh, there you are. Okay, here. Maybe if I just tag you. You have your phone connected to your car radio. Just want to make sure. Yeah. Nope. I just tagged you, Mike. I think maybe that'll work. Sometimes that happens. I remember that used to happen with if I don't tag people for a while, I notice that they can't tag me. I have noticed that. So, Mike, if you're there, I just tagged you. It's the price that we pay. Price that we pay. It was just salad and a slice, not a big deal. Yeah, you'd be heartbroken. Aw. No, Mike, I don't block people. I just ban them. Sorry. No, Mike, I'm not gonna block you. There's no reason to block you, Mike. All right. Super Ball is getting restless. Even Super Ball is getting restless.
Yeah.
She's walking back and forth.
Dude, come and sit in here, baby. Come here, please. No? You want to come sit in here? You don't? I know it has other cats thinking.
Remember Snidely Whiplash? Wasn't that oh yeah. What was what was that with what was her name? What was that name of that? Yes. Dudley Do-Right. That's right. Dudley Do-Right. Yes. Snidely Whiplash. With Boris. Who was wasn't his what was his wife? What didn't he have a and Natasha. Yes, Natasha Fatale and Boris Badenoff. Dick Dastardly. Was that part of Bullwinkle? And Rocky? That was part of Rocky and Bullwinkle? Yeah, I guess that they were the ones, yeah. All right. Yes, Rocky and Bullwinkle. God, Mike, I haven't thought about them in like 40 years. No, wait, I'm only 25. I haven't thought about them in 15 years. Penelope's Pit Stop. Is she part of this? I see Nell Fenwick. I don't see Penelope Pit Stop. Oh, there she is. Penelope Pit Stop. Yep. Muttley. Oh, I like Muttley. I think Muttley with that. I like Muttley. Muttley was fun. Right? Muttley was the dog that would go. Yes. Super Bowl is getting anxious, and she wants my pizza. Kaylee, you made it back just in time. Yes, you did. Well, Well, Green-eyed cat, that's the way it works. I'm aging myself, yes. I just turned 25, so I haven't watched that in 15 years. Ah, yes, the good old cartoons. Gosh, Saturday and Sunday morning cartoons. Nothing better than waking up on a Sunday and everybody's still asleep and you get to go watch cartoons from like 6 or 7 o'clock until 8 or 9 when everybody wakes up. Then my mom would make pancakes on Sundays. Oh, life was good. Life was good, watching cartoons and having pancakes. Not having to pay bills, having your parents worry about paying bills. Yeah, Muttley was your favorite. Yeah, Muttley was pretty cool. Ed, I think both sides have good lawyers. Gordon, I still remember Huckleberry Hound. Yep, Huckleberry Hound. Yep. Hard Rock says she has something to hide in her phone. It's possible. Or she just doesn't want to give Shanna an inch. I can see that too. I mean, I can see both sides. I can see both sides are probably not very happy with each other. So put yourself in both sides' positions. You know, you're the wife and your spouse has been taken out by the ex. You're not going to be too friendly with them. Allegedly. Ed, who remembers the channels signing off at midnight? Yeah, with the snow. It was just like Poltergeist, where you'd have the Iwo Jima flag being planted, and you'd have what is it? Dun, 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 dun. What is that song? What's the song? It's not the Star Spangled Banner, is it? No. Oh, say, can you see?
No, it's not.
Oh, let's get it down. Right? No,
it's not that.
All right, what was the song that they signed off on? Okay, by the time I Google it, you guys will have the answer.
Star Spangled Banner.
Was it the Star Spangled Banner? This just shows you how much I know.
Yeah.
Or America the Beautiful. Maybe that's what it was. No, I guess it was the Star Spangled Banner. Yes. Yeah, the national anthem.
Haven't you watched Poltergeist enough?
I know.
Haven't I forced you to watch it?
It just shows you how much I retain in the old noggin up here. With taps, Kaylee. No, it wasn't taps. No, they weren't sending somebody off into the great beyond.
It's the national anthem.
Yeah, isn't that the Star Spangled Banner? Oh. Yeah.
But is it? We're gonna get in trouble.
Yeah, don't. Yeah. Let's not. Oh, Sugars, you have PTSD from Sundays watching Davy and Goliath, then being dragged to Sunday school. Oh, sorry to hear that. What the Healer, I loved Laugh Olympics with all the different cartoon characters. Debbie Gibby, you love the song from Golden Girls. Thank you for being a friend. I love that song. Roadrunner was pretty good. I love that song. I love the Roadrunner song. That was fun. Roadrunner, if he catches you, you're through. Roadrunner, catches you, you're through. Roadrunner. And I think Speed Racer was my favorite. I'll put that out there. I think Speed Racer is probably my all-time favorite cartoon. Christine, Roadrunner was your dad's favorite cartoon. Well, Mike Morrow, you were just aged. Or Christine, you just aged yourself. So Christine, Mike's as old as your dad. Flintstones was your favorite? Sometimes the national anthem. Yes. Yeah, Foghorn Leghorn. He's reminiscent. Well, I say, boy. Foghorn Leghorn. He was pretty good too. Well, I say. Foghorn Leghorn was great. We're strolling down memory lane here while we're waiting for Judge Kite. I hope this is streamed. I mean, she's shown this like all the time. She's shown every hearing so far. I hope she doesn't. Yeah, beep, beep. I hope she doesn't Hope she doesn't not show it. K-Girl, I remember they had Roadrunner and The Shining when Danny's watching the cartoons. Yeah. I'm sure that meant something too, right? Kubrick always put something in there. Christine, your dad not been with us for a long time. Aw. Sorry to hear that. You just ate okay. 80s Music Man, Jetsons, right? Not the Jettisons. I'm like, wait, the Jettisons? No, the Jetsons. The Jetsons. Yes, they were. I like the Jetsons. Yeah, they were good too. Ed, I used to get up early Saturdays and watch Hercules. Loved it for some reason. Oh, Hercules. Yeah, I love the Henry Harryhausen, right? Henry Harryhausen, was that his first name? Yeah, those claymations, the stop motion, all that stuff. Is that what you're talking about? Those with the those were like the Sinbads. I love the Sinbad ones with the skeletons and fighting the Cyclops and all that stuff. I love that. Jason and the Argonauts for sure. Yeah, for sure. Jason and the Argonauts. Back before AI and you had like CGI, all that stuff. I showed my nephew, he came down to visit. He was like he was in college, so he was like 20 or something. And we watched, I think we had Jason and the Argonauts on. And I'm like, oh, here, watch this. Just check this out. And he was like, what? What is this? This is like so boring. Blah. I'm like, you have no idea what it takes to make a skeleton go like this with a sword. Even just that, take like 3 days just to make a skeleton do that. You have to understand the craft. You have to appreciate the craft, the time that it goes in to make a skeleton pull a sword out and go like that. That took a month. Yes, Mr. Peabody, of course. Dudley Do Right. Hercules, the Legendary Journey was a great show with Kevin Sorbo. Oh, okay. Yeah, I remember that. That's like from the 80s though, right? Yeah, that's after our time. No. Yes. Well, that was Xena, right? Wasn't Xena the Princess Warrior? She was part of that. Hong Kong Phooey. Yes, Green Eye Cat. I think Hong Kong Phooey gets the best song though. Hong Kong Phooey was definitely he gets the best song. Best song for a cartoon. Hong Kong Phooey was a good one. I like that. Yep, Speed Racer, Hong Kong Phooey. I'll go with that. I'll go with that. And Underdog. Yep, Underdog. Wasn't there a Dudley Do Right in the Brendan Fraser movie? Or with Brendan? Oh, maybe. Not quite sure. Maybe. Top Cat. I remember Top Cat. Oh, H&R Puffin stuff. Yeah, I remember them. Oh, do you remember the Banana Splits? Do you guys, who out there remembers the Banana Splits? They had a fantastic song. I absolutely love that song. 1 banana, 2 banana, 3 banana, 4, 5 banana, 6 banana, open up the door, whatever it was. Na 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 meow meow meow. I always go back to meowing. Banana Splits. They had a great song. I like the Banana Splits, but they weren't a cartoon. They were dress up in costumes and stuff. Ed, you still have Columbia House? I do too. I have a ton of Columbia House. Everyone was kung fu fighting. Oh, Sugars, you remember the Banana Splits? Yeah, I love the Banana Splits, man. I love that song. I love the Banana Splits. I think I even had like a little car, like the VW, the hot rodded, tricked out VW dune buggy. The dune buggy. 80s Music Man, you watch Hogan's Heroes way before your time, but love it now. Start watching it. Josie and the Pussycats. Yeah. Josie and the Pussycats. Yep. That they had a great song too. Yep. I remember and liked Josie and the Pussycats. Yeah. Christine, your 2 kids loved banana splits. The tune used to drive me nuts because they watched it too much. That's probably what my older siblings probably thought of me too, because they probably thought that of me as well. Oh, the Archies, yeah. Super Chicken, yeah. Pepe Le Pew. Mike, why do I get a sense that you remind me of Pepe Le Pew? Got manners. I had a single sung by a punk band. Oh, the Dickies. I know the Dickies. Yeah. Oh, they did a version of Banana Splits. Yeah, I remember the Dickies. Patty Loves Paper. Yes, absolutely fun memories. Absolutely. Dina, I don't know. No, Dina pulling us back down to reality. All right, enough of this memory lane stuff. Let's get back to the trial. I don't know. She's shown it the entire time. She's all the other hearings. Judge Kite has had. Judge Kite has shown it, so I do not know why. I'm not sure why we're not seeing it now. But I'm looking at 3 different sources and nobody's on. I'm looking at 3 different sources. So what have we established here during lunch? We have established that Josie and the Pussycats, Banana Splits, had great theme songs. That's what we have established. We have established that Mike Morrow is like Pepe Le Pew. We have established that it takes a month for a skeleton claymation stop action to make a move. What else? What else have we established? Poor Barry. Yes, we do have a Freaky Friday. This could be a Freaky Friday. Let's see. New cartoon series, Scrambling Lawyers. Right? Mrs. Baba Yaga, how are you doing? Great to see you. Thank you for joining us. We are old. We are all old as dirt. We established that 80s Music Man is saying go Steelers and not Browns. Oh my. Well, there are some lines that are being drawn here today, folks. It's okay, Kimbers. I've got plenty of friends that like the Steelers. As I snort my disdain. Yes. Let's see what else. Do we have spies in the courthouse? Unfortunately not. It would have been me. I was thinking about going today, but we made the choice not to go. We'll have to excuse him. Mike. Oh, no, wait. No, it's 80s Music Man. Oh, Sugar, Steelers fan here. Yep. I try not to bring sports into it because I know how divisive it can be. But coming from I'm not going to say it. Anyway, yes, I have a lot of friends that are, not a lot, but a few friends that are Steelers fans because the Browns are that terrible. They are that terrible that they root for the arch rivals. Go Bills! Go Bills! Erin is from Buffalo, but she's not a sports ball person. Yeah, rivalry in chat. We got the Bloods and the Crips. We got the Sharks and the Jets. We got lines being drawn. Lines are being drawn. And then we all used to crowd around a 19-inch TV. You were lucky to have a 19-inch. I'm so old. I remember watching TV in a blizzard, going to school uphill both ways. watching a black and white 5-inch TV in a blizzard, going to school uphill both ways. That's how old I am. Yogi Bear, yeah, Yogi Bear was fun. And Boo Boo, hey, Boo Boo. Yeah, Yogi Bear and Boo Boo were cool. I like them. Yep. Dina, hey, Boo Boo. Absolutely. All right, let's see here. Kaylee, your coworkers crowd around your 14-inch laptop to see the cats. Aw. We are surely showing our age. Yes, this is. Guess how old everybody is on Trial TV Live moment. Wow, it's almost 1 o'clock. So they're supposed to be coming back. What is going on with Judge Kite? Why is she not showing us this? Mike, your new name is La Pew Pew Pew. That's a good one, Mike. I like that. And the Muppets, of course, the Muppets. Oh, you know what? My mom loved the Muppets. I have distinct memories of my mom crocheting and us watching the Muppets. I think it was like Friday night or Saturday night. This was, of course, before I went out. And my mom would be watching the Muppets and just laughing hysterically. She would watch cartoons too. I love my mom to death for that reason. She would watch cartoons with me. But yeah, we'd watch the Muppets together. She loved the 2 old men. Those were her favorite. The two cranky old men in the balcony. That was my mom's. Those were my mom's favorites. Yep, there you go, Mike. Yeah, that was my mom's favorite. Were the two old men in the balcony, and the Swedish Chef. Yeah, doordy 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 door. Swedish Chef. Yeah. All right. Let's see. Camilla, Thundercats. Yeah, you know who loved the Thundercats was my oldest nephew. Thundercats, ho! Thundercats, ho! He got me into Thundercats because I was already past that time, but he watched the Thundercats. So when I spent a couple months living with my sister and her son, my nephew. So he loved the Thundercats. So I got into the Thundercats because of him. It's good. It was good. I enjoyed it. I had fun. Skeletor, it was cool. Patty loves paper. You're crocheting now, watching you. Nice. Kimbers loved the 2 men in the balcony. They were pretty funny. They were pretty good. Aaron loved the Muppets. Yeah, Muppets were great. Fanny, how about Blue's Clues? Big comfy couch, your kid's favorite? Big Bill, appeals court gave her 3 days. Okay. Are you getting that from their docket? Nobody has mentioned Scooby-Doo. That is shocking. Scooby-Doo was absolutely one of my favorites. Absolutely. Because of the mystery. I mean, hello, how can we forget about Scooby-Doo? I mean, come on. Scooby-Doo definitely was a highlight of my morning or afternoon, whenever they were on. Scooby-Doo because of the mysteries. I loved. And the one with Jonathan Winters, I think that was my all-time favorite because he was making all these noises, you know. Yeah, Scooby-Doo for sure because of the, the whole mystery aspect. All right, let's get back to, wait, how do you, let me get back to, did I miss it? Who posted that? Big Bill, did you find that on a docket? How do you know that? Let us know how you. Oh, here we go. We got some action here.
Is there anything we need to take up prior to bringing in the jury? All right, let's bring in the jury.
We're going to bring him up.
Okay, it's 1 o'clock.
Doesn't sound like we're going to get, unless Big Bill was correct there. Doesn't sound like there was anything that happened over lunch. So I guess there wasn't a hearing, or if there was a hearing, we didn't.
Go with the jury, and it will be with him in like 3 minutes.
I remember Adam Ant. Yes, Kiss was on Scooby-Doo. Monkeys were cool. I saw the Monkeys with the Moody Blues in a reunion or whatever, a revival tour. That was pretty fun. Yeah, the Monkeys were fun. So, Big Bill, how do you know that? Please let me know how you know that, because it clearly looks like we're not going to have any kind of hearing. And she still sounds a little upset. Yeah, I agree. Kaylee, yeah, she still looks a little perturbed. Good vibes. She still seems a little ticked off. Lived for the Smurfs. Kite can't be pleased. She did not want the appeals court stay to come back before she got the phone. It sounded like it in this morning's hearing, yeah. All right. All right, we got to focus. We got to get our focus back on here. Let's turn the dial back to this trial. Ooh, turn the dial back to this trial. That just came out of nowhere. But somebody wants to put some music to that or a beat. Let's turn this dial back to the trial. But let's do that. Let's get back to this trial. If somebody can find out what happened, let us know. Let us know what happened. Pippi, clearly something happened. Either it was done out of the presence of cameras, or they did something in the back room, or it just got resolved somehow. Something happened. There was a stay. Oh, we got an email. Okay, hold on. Email. Hold on, let me check. We got an email. Where? I'm not seeing it. Wait, hold on. Not that. Hold on. Non-party. That says Kristen. I thought it was Kirsten. Bridegan's response to order directing Kirsten. Oh, they spelled her name wrong. Jeez. Comes now. Kirsten Bridegan via counsel. All motions and the answer shall be in writing unless specified otherwise by the judge. Defendant's All right, I'll read this. At a break. Okay, this is coming from Doug Clifton. This was filed at 11:51. I'll read this at a break. All right, hold on. All right, I'm going to try and find out what happened.
Your Honor, the jurors are entering the courtroom.
Thank you.
All right, I reached out, and I'm going to see what comes back. Oh. Your extension time to allow appellate review should not be an issue for the defense. All right, we'll sort it out.
All right, welcome back, members of the jury. Everyone may be seated. All right, before we get started, I want to confirm with the jurors that even though you had your devices over the lunch recess, did you follow the communication rules? If you could answer out loud.
Yes.
All right, thank you. Mr. Hill, you may proceed with your cross-examination.
Good afternoon, Ms. Butler.
Good afternoon.
My name is James Hill. I didn't get to meet you during your deposition. It's nice to meet you this afternoon.
Nice to meet you as well.
My understanding, you're now in the private sector. Is that correct?
Yes, I am.
In this particular case, you specialize, I believe that it was IRS.
Yes, that's the abbreviation for my position.
And that was your primary and only duty in this case?
Yes.
You reviewed thousands of records, countless hours working, in essence, to help the investigative team try to narrow down to specific suspects. Is that accurate?
Yes.
Okay. And in that in particular, with regards to Mario Fernandez, is it your understanding that he was in essence a person of interest almost starting on day one?
I can't classify what law enforcement classified him as, but I was told about Mr. Fernandez on February 17th. Yes, sir.
So immediately after the homicide, you began to at least research into him?
Yes, sir.
This also included Shanna Gardner?
Yes.
John Biggerstaff?
I didn't begin to research into Mr. Biggerstaff immediately, no.
But ultimately John Biggerstaff and Henry Tennant, correct?
Correct.
Among other people?
Yes.
I know that the state presented a photograph to you of Mr. Fernandez and Ms. Gardner. That was located on a blog by Ms. Gardner's mother?
The blog is run by Ms. Gardner's mother, yes.
Did you also do investigation into Shelley and Sterling Gardner?
I wouldn't say that I did an investigation into them. I became familiar with them through the course of my investigation.
Was it only the blog that you were investigating?
I believe I might have done some social media searches, but as far as documentation, the blog.
And I'm kind of going out of order, but you would agree nothing in the blog where you pulled that photograph provided any further relevant information regarding Mario Fernandez and the homicide of Jared Bridegan. You would agree with that?
I would agree with that.
That was just a photograph of husband and wife together that was posted on Mr. Fernandez's mother-in-law's blog.
Right. The purpose was to understand the activities before and after the homicide.
And you were able to learn through that research somewhat about the Gardner family and their finances. Is that correct?
Yes.
Specifically Sterling and Shelley Gardner, that they're wealthy individuals.
Yes.
Would you agree that primarily through your research, the finances that Mr. Fernandez had were primarily tied to his marriage to Shanna Gardner?
I didn't do enough financial research into Mr. Fernandez to be able to answer that definitively.
Were you able to determine he earned an income from his rental properties?
I don't recall looking into that specifically, no.
Now I want to draw your attention back to the actual night of the homicide, February 16th. You provided some testimony that you made a determination that his phone was not communicating with the network during certain times.
Correct. There were no cellular transactions during certain times.
And that was information that ultimately was utilized by Agent Blythe?
It wasn't utilized by Agent Blythe. I discussed it with Agent Blythe.
But you're not an expert in that particular area, correct?
I am not, no.
So you're not able to draw any type of opinion from an expert standpoint as to what the lack of records or the presence of records actually means?
Correct. I conducted preliminary analysis to provide investigative leads.
And there's no dispute that there was also network data gaps at other points in that same evening?
That's correct.
My understanding is that that could be for several different reasons. A person could have their cell phone powered off, would be one reason?
Yes, sir.
Okay. Their phone could be placed in airplane mode?
Yes.
Yep. And for other reasons?
That's correct.
And that could be pretty broad. You would agree with that?
I would agree with that.
Some of that entirely out of the control of the person that actually possesses the device.
I would say that's fair.
For instance, T-Mobile, as it applies to Mr. Fernandez, whatever T-Mobile may be doing from a network standpoint would be outside of the control of someone with a T-Mobile device.
That's correct.
So if there's no timing advance records for a particular time period, and it's not because the phone is off or in airplane mode, that would be outside of the control of the user. Would you agree with that?
It could be.
And you're not able to testify specifically as to that first gap as to whether or not it's off, airplane mode, or other. Would you agree with that?
That's correct.
And I believe you were also asked about some other gaps that were later that evening. Would you be surprised to know that law enforcement has testified in this trial that they made contact with Mr. Fernandez and Ms. Gardner during one of those timing advance gaps?
I would not be surprised. I know that law enforcement did make contact with them.
And further, that they made no observations of Mr. Fernandez fumbling with his phone, turning it off, turning it on, or otherwise?
Sure.
Okay. And would you agree that that could be evidence that, in fact, there is a networking issue, at least during the time period where law enforcement is watching and seeing him during one of those timing advance gaps?
I would say based on my understanding it's possible, but I can't say one way or another.
So with any of the gaps that the state has elicited and that I brought up, you're not able to actually offer any testimony as to what the actual reason for that timing gap is?
No, I'm not.
And certainly you can't say that any of those timing gaps specifically implicate Mr. Fernandez in the homicide of Jared Bridegan.
I can only say that there are gaps.
Only say that there are gaps.
Yes.
As to why there's gaps, you cannot say.
Correct.
Now, my understanding, you did further analysis 30 days prior to the homicide, the day of, and 30 days post-homicide. For a total of 61 days, you looked to compare to see if there were other gaps in network connectivity. Is that correct?
Yes.
And the specific gap that was referenced was 1910 to 2019, which is what people refer to as military time, but that would be 7:10 p.m. to 8:19 p.m. Is that accurate?
That's correct.
And that's the time gap that the state had referenced that they believe is that Mr. Fernandez had his phone off during the homicide. Whether that's true, you're not able to testify that, but that is the time period in which you researched. Is that correct?
That's the gap around the time of the homicide.
Yes, ma'am. And as you just mentioned, you did somewhat of a historical analysis for pre-homicide and post-homicide for that exact same time period, correct?
Yes, I did.
And because that particular time period is significant, you wanted to see if that ever occurred at any other time before the homicide or after. Is that accurate?
That's correct.
And it's accurate that you did find other occasions that that took place.
I did.
You found approximately 4 of those, correct?
I did.
And just so the jury understands it, I would imagine every single one of them has a cell phone. In order for someone to power their phone down, depending if it's an Apple or Android, they press or hold down a button, the phone shuts down. Fair enough?
More or less, yes.
Same way with starting it back up, correct?
Yes.
You would agree, though, for someone to have 4 identical gaps, they would have to be able to shut their phone down at precisely the exact time. You would agree with that?
Based on my recollection of the analysis, the gaps weren't identical. My analysis was just about were there transactions during that time frame on other days.
And you found 4 exact duplicate transaction periods. And that 30 days before and 30 days after for the time period you were researching.
It did not reflect that the cell phone stopped communicating with the network or the gap started at the same time on all 4 of those days. No, it did not.
It was a lack of transactions.
Correct.
Okay. Which again, you relate back to saying that if there's a lack of transactions, it means that it is not communicating with the network. Is that my understanding?
That is one possible reason, yes.
But there's multiple possible reasons, as you testified.
Yes.
The cell phone could be off, is one.
Yes.
Which is what the state has tried to elicit from you, that they believe the cell phone was off, correct?
I was not asked that by the state.
But that's what's being presented to this jury. But your testimony is very clear. You cannot make that determination at all.
No, I cannot.
And you found 4 other occasions with 0 transactions during the same time period you researched for that 61-day time period.
That's correct. When I did my preliminary analysis, that's what I found.
But you did not research any other time periods in that 61-day time period to see if there were other network gaps, did you?
No, I did not. I focused on the time period surrounding the homicide.
And that cell phone information has been provided in evidence, so the jury will be able to review it. But would you be surprised to know that there were other network gaps throughout that same evening?
I do know that there were additional gaps, as we're calling it, throughout that evening.
Other than me telling you this afternoon, did you know that law enforcement spoke to Mr. Fernandez during one of those particular network gaps? I may not be using the right terminology, but a gap in transactions.
I knew that law enforcement spoke to him that night. I don't recall ever putting the two together that it was during one of the lack of transactions.
And is that because you were more of a, and I don't want to diminish your role, but you were more of a data analyst as opposed to a law enforcement investigator?
That's correct. I was an analyst and I did preliminary analysis.
And with regards to Mr. Biggerstaff, I understand you did a similar analysis on his device?
I did.
Okay. And are you aware that there has been testimony that Mr. Biggerstaff was present at a location far away from Jacksonville Beach during the same time period?
Yes.
And he actually operates at the time an AT&T device, is that your understanding?
Yes.
Could that be for the same reasons as a T-Mobile device as far as off, airplane mode, or other?
Based on my understanding, yes.
And certainly you wouldn't be able to offer any testimony as to which of those particular options it would have been to cause that lack of network transaction.
That's correct.
As your understanding, Mr. Biggerstaff's gap actually encompassed from 4:25 p.m. till 10 p.m. that evening.
I don't have the exact numbers in front of me, but it was longer than Mr. Fernandez's gap.
And it was different?
Yes.
You don't have any evidence that there was any direct communication that said turn your cell phone off in a particular time period?
I'm not aware of any evidence to that nature, no.
In fact, you don't have any evidence at all that you've reviewed from your data analysis of Mr. Fernandez trying to communicate with other people to coordinate powering down phones, putting them in airplane mode or other?
I just have records of communications. I'm not aware of what the contents of those communications were.
And specifically with Mr. Biggerstaff, you did a similar analysis 30 days before and 30 days after, is that correct?
Yes.
And in his particular device, you found approximately 10 occasions with a similar type of activity or lack of activity.
That's correct.
And since you've been involved in this case since, in essence, day one, you would agree with that?
Yes.
Okay. And when there's major breaks in the case, you're made aware of those, correct?
Yes.
You're aware that the truck was found?
Yes.
You're aware that Henry Tennant was arrested?
Yes.
You were made aware that Mario Fernandez was arrested?
Yes.
As well as Shanna Gardner?
Yes.
Okay. You've not been told that John Biggerstaff has ever been arrested, correct?
Correct.
Juan Biggerstaff never been arrested?
Correct.
No, the state also asked you with regards to some of your financial analysis. The date of the homicide occurred on February 16th. No dispute about that, correct?
Correct.
You found no evidence that Mr. Fernandez paid Henry Tennant any money related to this homicide or otherwise prior to February 16th, correct?
That's correct.
And you looked for that?
I did review Mr. Fernandez's financials. I can't speak to exactly the start date and the end date.
But certainly if you had found something to evidence a payment prior to the homicide, we would expect to hear that today.
Yes.
We would expect there would likely be a picture of a check or cash or otherwise that you would be testifying to on direct examination.
Not sure what the evidence would have been, but I likely would have been testifying to it if I found it.
We can agree none of that testimony was elicited to you earlier this morning.
That's correct.
Now, you did testify that there were 3 checks that you did find.
I did not testify about checks.
Have you identified those in your financial analysis?
I have seen the scans of the checks. I was not the one that identified them initially, no.
When you reviewed the financials, did you come across them at all?
I remember seeing the checks in the financials, but I was not the one that initially located them.
No dispute that those were after the homicide.
That's correct.
And that was approximately March and then April of 2022. Is that correct?
Late March, early April, yes.
No evidence that there were any payments after that April date.
Not that I'm aware of, no.
And certainly you would be the one to likely assist or be the one to find those payments based upon what your role in this investigation was.
I might have. I would say that I would be aware if there were.
Now this question is going to sound almost common sense, but you would agree a check, which not many people use anymore these days, has the name of the person or the company that's issuing the check.
Correct.
Okay. And someone in a position such as the ATF, the FBI, JSO, or Jax Beach, they can certainly track down by way of the name of a person or a business to find out who wrote that check.
Yes.
Okay. And what else would be on there is the person's signature that actually signed the check.
Correct.
Okay. Wouldn't be hard to find because you have the person's name and their business or their address listed on the check.
That's correct.
Okay. Now, the state has somewhat alleged that this is hiding in plain sight, but it certainly could be the opposite. It could be for legitimate purposes. Would you agree with that?
It could be.
None of those checks, and you've seen copies of those checks, correct?
I have.
They certainly don't say murder of Jared Bridegan on there, do they?
That's correct. They do not.
Okay. They say landscaping for one.
Yes.
Tree work for another, or excuse me, landscaping and tree work and then roofing for another.
I'm not sure about the exact wording of the first one. The second one does say roofing.
Right. And then one said Kickstarter.
Kickstarter, good luck.
Okay. And were you made aware that once the truck was recovered in the search of the Potomac property, they actually found a business plan for Mr. Tennant?
I remember hearing about that. I'm not sure. I don't know that I knew that it was found in the Potomac house.
If I represent to you that law enforcement recovered that, would you take my word for it?
Yes.
Okay. No dispute that a handwritten check with a signature and the writing in the memo line with the name of your business is a pretty identifiable instrument.
It's identifiable, yes.
Much easier to trace than cash.
That's correct.
Certainly better than crypto.
That's correct.
All ways that people committing crimes and issuing payments may utilize to avoid having it traced back to them.
Yes, there are a number of ways to accomplish that.
But in this case, the only payments that you found or were found by law enforcement with your knowledge was by way of these 3 checks.
To my knowledge, yes.
Okay. And you assisted in the location of the blue F-150?
I did.
And that was by way of your cellular data investigation?
Yes.
And that was specific to Henry Tennant, correct?
We reviewed Henry Tennant's records, different types of records to find the blue truck, yes.
You didn't find any evidence that Mario Fernandez or his devices ever went to that particular location, correct?
Not that I recall, no.
No connection to that location that you're aware of, correct?
Not that I'm aware of, no.
And certainly, as you mentioned, you have knowledge of the major breaks in the case.
Yes.
Okay. Had there been a connection between the property where the F-150 was found, you would expect you would have known that.
If it was determined, if there was a connection determined to exist, I believe I would have known that, yes.
Going back to that particular property where the F-150 was found.
Yes.
Were you able to identify anyone other than Henry Tennant that had a connection to that property?
The individual who was spoken to by law enforcement?
Do you know that person's name?
Jimmy Jones.
Okay. Did you ever find any connection between Mario Fernandez and Jimmy Jones?
I did not know.
After those 3 checks, which was March and April, no disagreement that there was no evidence of payments November of 2021 from Mario Fernandez to Henry Tenen.
Not that I'm aware of, no.
None for December of 2021.
Not that I'm aware of, no.
Nothing in January of 2022.
Not that I'm aware of.
And nothing in February of 2022 when the homicide occurred.
That's correct.
You would agree you found no evidence, Mr. Tenen, a text message between him and Mario Fernandez with regards to payments for a homicide?
That's correct.
You've never been made aware of a jail phone call from Henry Tenen to anyone complaining that he didn't get paid for this homicide?
No.
No other information related to Henry Tenen getting paid for this homicide other than the allegation that these 3 checks may have had some significance?
I don't have information that I can speak to now that there was these 3 checks were anything other than what they said on the memo line, but I can't speak one way or the other.
Certainly you're not convinced, as you sit here today, that those checks were for the homicide or for the work that's written in the memo line.
I'm not sure that it's appropriate for me to speculate about that.
You can't draw a conclusion either way.
Not with the information I have.
Understood. Now, you referenced these data deletions.
Yes.
Now, these data deletions, the state brought those up on what has been marked as States 212. Can you tell me if that's displayed on your screen?
Yes.
This is a big spreadsheet, all from what you received back from Google. Is that correct?
What law enforcement received, yes.
Okay. Some of these have more data than others, correct?
That's correct.
Now, the state didn't highlight this in their direct examination, but I'm going to start with item number 4. You would agree if you go to the far right, starting at P, for number 4, it indicates Facebook.com. Do you see that?
Yes.
Okay. Sounds pretty elementary, but you would agree that that appears to be something deleted related to Facebook.
I believe so, based on my understanding of what the records show.
No information that there's ever been anything posted on Facebook by Mario Fernandez as it relates to the homicide of Jared Bridegan.
Not that I'm aware of, but if it was deleted, I wouldn't have been able to review it.
But certainly, law enforcement can get a subpoena to send to Meta to collect data of Facebook posts and stories.
That's correct.
Okay. Something that the ATF can do.
That's correct.
Okay. JSO could do that.
That's correct.
Jacksonville Beach Police Department.
Yep. Yes.
And certainly we had the FBI involved as well. They could do that too.
Yes.
Okay. So if someone thought it was significant that Mario Fernandez deleted things from Facebook, there are mechanisms that law enforcement can employ to go and find out what it was.
That's correct.
Okay. But as you sit here today, you don't even know exactly what that Facebook deletion was.
I do not.
Okay. The state just wanted to elicit that there were a lot of deletions on the date that Mr. Fernandez went in for a voluntary interview.
That's
agree with that.
Yes.
All right, so thank you to some sleuthing by Aaron and others. Appeals court gives Jared Bridegan's widow 3 business days to respond to a subpoena of contempt of court issue. After a heated back and forth Thursday, an order from Judge London Kite that she turned over her phone to the court at 9 a.m. Friday morning, Jared Bridegan's widow was given a reprieve, albeit a brief one, by Florida's 5th District Court of Appeals. The appellate court granted Kirsten Bridegan 3 business days to respond to Kite's order that she comply with a subpoena from Shanna Gardner's defense team over her cell phone. Gardner's defense team wants access to specific private communications on Bridegan's phone that they believe could have evidentiary value for Gardner's trial, and Kite has ordered Bridegan to comply with the subpoena. Gardner, the ex-wife of Bridegan's late husband Jared, is one of the 3 defendants. She interrupted proceedings at 9:30 in the middle of testimony after learning that Kirsten Bridegan failed to turn her cell phone over to the court as Kite ordered. After Kite's order Thursday morning, Kirsten Bridegan's attorney, Doug Clifton, filed an emergency motion for a stay, and Gardner's attorney responded. Kite denied the stay motion at 8:30, upholding her order for Bridegan to turn her phone over by the 9 a.m. deadline. Despite Kite's orders, the phone was not turned over to the court, and a noticeably frustrated Kite stopped the Fernandez trial to hold an emergency hearing on the issue. Gardner's attorneys are now asking for Bridegan to be held in contempt of court for refusing to comply with the order, and Kite agreed to hold a hearing at 12:30 to allow Clifton time to respond. At the same time, Clifton took the issues to the appeals court, and before the 12:30 p.m. hearing, the appeals court granted Bridegan a stay. That means her attorneys now have 3 business days to respond to both the subpoena from Gardner's team and Kite's order that Bridegan show cause why she should not be held in contempt of court for failing to comply. The appeals court ruling says that Bridegan's attorneys must file a petition for a writ of certiorari with the appellate court. That means requesting that the appeals court find that Kite's order to comply with the subpoena violates Bridegan's rights. So everybody's going back and forth, back and forth. I'll continue reading after. To get the appeals court to grant a right of certiorari, sorry, I don't know how to pronounce that, Bridegan's attorneys will need to prove that Kite's order broke a clearly established rule or standard of law and that the error caused a material injury that cannot be fixed later on a normal appeal from a final judgment. Kite's order that Bridegan turn over her phone followed a heated dispute over the motion from Gardner's defense team seeking private messages and other material from Bridegan's phone and social media accounts that they believe could be relevant to Gardner's defense. Clifton previously argued the request from Gardner's attorneys was an overly broad fishing expedition and an improper attempt to examine the phone of a widow of a murder victim. Just said that word. They said a reliable forensic extraction would require imaging an entire phone, potentially exposing private information unrelated to the case. But Kite had already said in court that she believes imaging the entire phone is a violation of Bridegan's privacy rights, which is why she narrowed the scope of what could be retrieved from Bridegan's accounts. The parties also disagreed over the vendor who could conduct the forensic examination. Clifton objected to the first defense selected vendor, arguing that the vendor appeared to be part of Gardner's legal team. We saw all this yesterday, and made misleading statements about its independence. Gardner's attorneys on Thursday offered a different third-party vendor option to the court, not connected to the defense team, that they said would be willing to extract only the more narrow information the court has allowed. Previous vendors had said that would not be possible. Seems reasonable, right? That seems reasonable on Shanna's part. Clifton also argued that she is entitled to heightened protection under Florida's Victims' Rights Law, commonly known as Marcy's Law. We've heard that Kirsten is protected by that. Mr. Clifton said the law protects her from harassment, intimidation, and disclosure of information that could reveal confidential details or be used to locate or harass her or her family. Also a very valid defense. Clifton asked Kite to reconsider her earlier order requiring Bridegan to provide phone data. Alternatively, he asked to learn the specific reasons the defense considers the requested information material so they could properly challenge the intrusion into Bridegan's privacy. We heard all that yesterday. He's like, we don't even know what we're objecting to until we find out what it is that you guys want. Kite overruled their objections, saying Bridegan has no right to no defense strategy. Kite said she previously reviewed a sealed submission from Gardner's attorneys and determined that some of the requested information had evidentiary value. Her order limits the scope of the material that may be shared and requires the court to review the communications first. Again, everything's going to go through Judge Kite. Only substantive information is to be provided to the defense. Gardner is slated to begin jury selection, yada, yada, yada. So there you go. Perfect time.
Mr. Hill.
And Ms. Butler, we were talking about some of those Google deletions, and I think we were talking about number 4 on the spreadsheet that's in front of you.
Can I request that you expand it so I can see the timestamp? I believe the Google deletions were not on the date that we were talking about, or I'm sorry, the Facebook deletion was not on the date that we were talking about, but I can't see the timestamp.
Can you let him know what column it is?
Oh, I'm sorry, column A.
So go up to the top in the middle. Yeah, there you go.
Now, this is a spreadsheet that you produced, correct?
This came from the Google return. I did not create this spreadsheet.
But you offered it in testimony this morning, correct?
That I reviewed it and it came from the Google return, yes.
And I understand when you were testifying on direct examination for the state attorney's office, you didn't request to see the date of any of these deletions.
We weren't referring to specific rows. It was just more of a general overview of what the spreadsheet contained.
About the number of deletions for that particular day.
Not based on this spreadsheet.
It appeared that it was represented by way of your testimony. When it was presented by Ms. Stifler, there was 5,000 some odd deletions on the date of Mr. Fernandez's first voluntary interview.
That's correct.
Okay. And this spreadsheet was produced by you in anticipation of your testimony. Is that correct?
Yes, the spreadsheet is not the spreadsheet that details every single deletion made on a specific date.
Are you testifying to this court that you would include deletions that have nothing to do with the deletions that were referenced for the date of Mr. Fernandez's voluntary interview?
In order for me to do a sound analysis, I need to look at all of the data. So that's what I did in this case.
I understand that. Can you tell me why you didn't make that same statement to the state attorney's office on their direct examination showing you what's been marked as State's Exhibit 212?
This spreadsheet, to my recollection of my direct examination, was brought up to show that there were 2 different spreadsheets. This spreadsheet contains records of bulk deletions of data, and I believe that I stated that the secondary spreadsheet, the spreadsheet titled secondary, contains the line-by-line records of everything that was deleted from the account.
We'll get to that one in just a moment.
Okay.
Okay. But since your testimony is you don't know, or if I recall, you're not aware of exactly what was deleted from many of these particular deletions. Is that accurate?
That's correct.
Leaving a jury with no information as to what possibly could be deleted. You would agree with that?
I can tell you the Google product that was affected by the deletion.
But you would agree on this particular spreadsheet that is the state's evidence that you testified to this morning, it includes, pull it over so they can see, includes items such as Facebook. You would agree with that?
It includes URLs.
Okay.
Yep, yes.
But my question was Facebook.
URLs for Facebook, yes.
URLs for YouTube.
Yes.
You've not found any evidence related to the homicide as it relates to Mario Fernandez and YouTube, correct?
I have not, no.
Never found any searches of how to dispose of a firearm, correct?
I did not, and I wouldn't be able to see them if they'd been deleted.
But the answer is no.
Correct.
Okay. Then we have iCloud photos.
Yes.
Okay. Found no evidence that Mr. Fernandez took any photographs that were related to the homicide of Jared Bridegan, correct?
Not to my knowledge.
Okay. eRome.com, have no idea what that is.
I do not.
Okay. Just because my mother's probably watching this, I'm not going to read out loud what the next item is below that. But you would agree that that particular website doesn't appear to have anything to do with homicide, correct?
Not that I'm aware of.
Okay. Appears to be several entries for that particular website.
That's correct.
And you would agree there's numerous entries for Facebook, YouTube, and iCloud photos?
Correct.
Okay. And then there's a lot of data that doesn't have what the URL or what exactly was deleted.
That's correct.
So certainly you can't offer any testimony this afternoon or ever, as it stands today, that any of these deletions relate at all to the homicide of Jared Bridegan.
I can testify that the deletions were processed on the same day that Mr. Fernandez had his interview.
You would agree deletions could include Gmail accounts, like emails?
They could, but that's not the case in this incident.
It was Google Chrome?
The upwards of 5,200 records the morning of March 1st were Google Chrome records.
But no idea what those are.
That's correct.
They could be something as simple as websites.
That would be what's contained in Google Chrome records.
Just like what we reviewed. Facebook, iCloud, pornographic websites, anything.
They could be, yes.
And by could be, meaning you're not convinced that any of those deletions are actually related to the homicide of Jared Bridegan.
All I can say is that they were processed on the same date of the first interview.
Let's go to the secondary. This is the one that you mentioned that was line itemed?
Yes.
Similar to my previous question, nothing to indicate exactly what was deleted.
Just the Google product affected.
Google Chrome.
For what's on the screen right now, yes.
As to what that is, you could never testify it has anything to do with the homicide of Jared Bridegan.
I can just say that it's Google Chrome.
And that it happened on a particular date.
Correct.
You made mention in your direct examination that there were some map searches on February 28th for Pittsburgh?
Yes.
And that's a location that Mario Fernandez went to, correct?
To the area of Pittsburgh.
You would agree February 28th is several days prior to that trip?
Correct. The searches were made on the evening that he was notified about the interview.
But you have no information as to whether or not he was already intending on going to Pittsburgh.
I can just speak to what the records reflect, that there were searches that evening.
Sure. The way you presented that testimony was to make a connection that his trip to Pittsburgh had something to do with his interview, but you have no evidence of that, correct?
I can only speak to the dates that the searches were conducted, compared to the date that Mr. Fernandez was notified, compared to the date that the interview happened on the following day.
But he did the search prior to going on the trip.
That's correct.
Okay. And he didn't go to Pittsburgh and avoid going in for his interview, did he?
No, the interview happened before, yes?
Voluntarily, and sat down with law enforcement and gave a lengthy interview.
Correct.
Okay. He could have, if he had chosen to, declined that interview.
I believe he could have.
Right? He wasn't under arrest.
Correct.
It was voluntary.
Correct.
Okay. Everybody knows what that word means. It means that he walked in under his own accord and sat down consensually with law enforcement.
That's correct.
Okay. But several days prior, he did a search in Pittsburgh.
Yes.
Okay. So you have no evidence one way or another has anything to do with the fact that he was going in for an interview.
I can just say that it happened the day before his interview, and the trip ultimately coincided with the CPT interviews of the children.
But again, whether one thing has to do with another, you have no evidence.
I can only speak to the dates.
You can only speculate.
I can speak to the dates.
You testified that he went on his trip north. You guys were able to track him by way of his cell phone data, correct?
That's correct.
Didn't appear that he purchased a burner phone or anything to try to not be tracked. You would agree with that?
Not that I'm aware of, no.
He used his debit card or credit card?
I don't recall which card he used, but there were records of his financial transactions, yes.
You mentioned, I believe it states 195. Your Honor, may I approach the evidence?
Yes.
States 195. Bear with me 1 second, please. Can you see that on your screen?
Not yet. I can see it now.
This was a receipt gathered by Walmart? From Walmart?
I believe so, yes. Can you scroll up so I can see the top of it, please? Thank you.
No dispute, this is what Ms. Stifler showed you on your direct examination.
That's correct.
Okay. Floss swords?
Yes.
Any idea what that is?
I believe it's floss picks to floss your teeth.
Like oral hygiene?
Yes.
That doesn't relate to the homicide of Mario Fernandez, or excuse me, Jared Bridegan, does it?
It's a purchase of toiletries.
Sure. Aveeno dial? What is that?
I believe it's Aveeno Dale, like daily, possibly a moisturizer or a soap of some sort.
As you said, toiletries.
Correct.
Okay. The next two don't really relate to me, but hair care products.
Yes.
Okay. Nothing to do with the homicide. You would agree with that?
It just says hair care.
Exactly. Body wash and some other men's product. And just normal toiletries.
Correct.
Okay. Nothing out of the ordinary for somebody that may be going on a trip. Right?
People need supplies, yes.
Exactly. There's entire aisles at places like Walmart that sell travel containers of various hygiene products.
That's correct.
That's not unusual.
There are those sections in stores, yes.
Now, Walmart sells a lot of things. No disputing that, right?
Correct.
Okay. You don't see anything on this receipt or any other receipt that Mr. Fernandez bought a tent, like to hide out in the woods?
There's no tent on here.
Okay. He didn't buy any type of makeup products or fake mustaches or anything to try to disguise himself?
I can only speak to what's on here.
Right, exactly. But certainly if you had found evidence that Mr. Fernandez was gathering any type of items to go on the run and to hide from law enforcement, we would expect you would testify to that, correct?
Somebody would have testified to it,
certainly.
Yes.
Okay. But all you're able to testify to is this receipt from Walmart that Mr. Fernandez bought hygiene products.
That's correct.
Okay. You would agree that that's not going to help this jury in any way decide whether or not Mr. Fernandez is involved in a homicide.
I can't speak to what might help the jury or not help the jury. I'm just speaking to what the receipt says.
Okay. And on this particular receipt, it does say credit card approved. Were you able to determine that that was Mr. Fernandez's credit card?
I believe it did ultimately match the financials we had available for Mr. Fernandez, yes.
So again, there was no effort by way of financials for him to try to mask where he was going and what he was paying for?
He used a credit card, yes.
You also found evidence of him having dinner at a Ruby Tuesdays?
I believe the Jacksonville Beach Police Department found those records.
But again, Ruby Tuesdays, you know what that is, right?
Yes.
Well-known little restaurant?
Yes.
Nationwide chain?
Yes.
Okay. Law enforcement was able to determine that's where Mr. Fernandez went and had dinner with a friend?
Yes.
Okay. McDonald's?
I'm not aware of a McDonald's
Wouldn't
purchase.
surprise you though, would it?
It's food.
Things people might do on a road trip.
Correct.
Go through a drive-through and pick up a Big Mac or something.
Correct.
Okay. You made mention of the hotel in Pennsylvania.
Yes.
Did he book 2 nights but only stayed for 1?
Correct.
Okay. What time, from your own experience, is the normal checkout time at hotels?
Approximately 11 a.m.
Okay. Do you know what time, based upon the cell phone records, Mr. Fernandez actually left the Pittsburgh area?
I believe it was later that evening.
Okay. So if you wanted to extend your stay, you weren't ready to leave yet, you might have to purchase a second night.
The 2 nights were booked at the same time.
Sure. But if he decided, I'm going to leave later in the evening, I'm not actually going to stay the night, in order for him to stay in the room past that 11 a.m. checkout time, he would have to have it booked for 2 nights. You would agree with that?
I can't say that he would have had to have it booked. I can say that he had 2 nights booked and he ultimately only stayed for 1.
He stayed for 1.5 days.
I can't speak to exactly when his cell site data shows that he left the hotel.
But you understand he left later that evening from the Pittsburgh area.
From the Pittsburgh area, yes.
You can't tell this jury that he didn't stay in the room later throughout the day and decided to leave that evening.
I cannot right now based on my preliminary analysis that I did.
Certainly can't say whether he decided to leave earlier or later has anything to do with the homicide of Jared Bridegan.
I, again, can only speak to the dates that it occurred.
Exactly. You understood at the time Mr. Fernandez had access to a lot of money.
I think that's fair to say.
Okay. So it wasn't going to break the bank, so to speak, if he were to book a second night and not end up staying the entire night.
He had financial resources.
Again, it wasn't going to put him out on the street by having a second night that he didn't stay for.
That's correct.
Now, State mentioned Mr. Biggerstaff.
Yes.
And that Mr. Fernandez had gone to Mr. Biggerstaff's on February 15th as well as January 25th.
Yes.
Okay. On January 25th, you have no idea why Mr. Fernandez was at John Biggerstaff's. You would agree with that?
Yes.
Okay. And you do know that they've had a long-term relationship for decades.
I can't speak to the length, but I do know that they've been familiar with each other for an extended period of time.
Did you know that Mr. Fernandez went to high school with John Biggerstaff's daughter?
Yes.
Did you know that John Biggerstaff and Mario Fernandez would sometimes work out together?
I did not know about workouts.
Did you know that Mr. Biggerstaff would do some handyman work with Mr. Fernandez at his property?
Yes.
So no disputing that they had plenty of legitimate reasons to be together.
That's correct.
So as far as why Mr. Fernandez was there on January 25th, you're not able to say that personally to Mario Fernandez it had any relation to the murder of Jared Bridegan.
I can say that Mr. Fernandez was in the area of Mr. Biggerstaff's house, and then approximately 3 hours and 45 minutes, Mr. Biggerstaff searched for the 10mm Glock pistol.
Sorry, who searched for it?
Mr. Biggerstaff's account.
Okay. Mario Fernandez was not there at that time, correct?
That's correct.
Okay. His device, which we heard from Agent Blythe, generally is within arm's reach of the person that owns that device. Any dispute of that?
I can't speak to where individual people have their devices, but...
Sure. But no disputing, based upon your analysis, Mario Fernandez was not present with John Biggerstaff whenever whomever was searching for a 10mm.
That's correct.
Okay. And you understood that John Biggerstaff was a convicted felon?
Yes.
Okay. And I know some of the searches you pulled up included places you could purchase a firearm, correct?
A website, yes.
Any evidence that a firearm was purchased from any of those websites?
Not that I'm aware of, no.
Okay. And you would agree, if you go on Google, you type in any type of item, sometimes in the search results, it brings up places where you can purchase those items that you've searched.
Yes.
Okay. So, for instance, if I were to Google right now on my cell phone, Glock 40 Gen 4, 10mm, some of those return results might be places I can purchase that firearm.
That's correct. In the case of Mr. Biggerstaff's account, there was indication that he visited the website.
Sure. But there's no indication that he purchased anything.
Correct.
Whether he wanted to go in and look at a firearm he used to own because he had an affinity for firearms, you're not able to testify one way or another.
I believe it was a different firearm than the one that he owned, but you're right, I can't.
Sure. You worked for ATF. Are you aware that there's 3 different models of a 10mm?
Of the Glock 10mm?
Sure.
I'm not, but I believe you when you say that.
Okay. So whether or not he's clicking on the exact one he owned or a newer generation, you're not able to testify to that.
I can testify that the one that he owned, based on my recollection, was a 10mm Glock 40 Gen 4, and the one that he clicked on was a 10mm Glock 20 Gen 4.
Okay. So now we have 2 different Glock 10mm that have now been brought up in this case. You understand that?
One that was owned by Mr. Biggerstaff.
Sure. And what your testimony is that he actually clicked on a different model of that 10mm.
Yes.
Okay. And again, no evidence that anything was purchased.
That's correct.
Are you aware that the allegation is it was a Glock 10mm 40 that was used in this homicide?
I'm aware.
Okay. So you would agree a Glock of a different model is unrelated to this homicide?
I will say that the search did not specify which was which.
But you just testified that he Tell us again, which Glock did he click on?
He clicked on the G20. You're right.
Okay. And it's alleged that it is a 40 Gen 4.
Correct.
Okay. You would agree those are two different models.
Those are two different models.
Caliber.
Yes.
And you would agree the one he clicked on is not what is alleged to be used in this homicide.
That's correct.
Did you review all the searches that Mr. Biggerstaff made, or at least were made on his device?
I can't say that I went line by line through them, no.
You brought up a 9mm?
Yes.
Smith & Wesson?
Yes.
Not used in this homicide, correct?
Not to my knowledge.
Would it surprise you that he searched various military bases in South Carolina?
I don't recall that in his search history.
Do you recall searching for a resort in South Carolina and a particular band that plays there?
I don't recall those searches.
You recall handmade flour tortillas being a search that Mr. Biggerstaff made?
I do not recall that, no.
Would you agree in your own experience, people Google all sorts of things?
Yes, I would agree.
May I have just a moment, Your Honor?
Yes.
Ms. Butler, I'm going to come back to some of those searches in just a moment.
Okay.
Bringing up the trial exhibit from the state, I believe it's Exhibit 214, which is the CDR call logs of Mr. Fernandez. There's one in particular that the state highlighted in purple. You see that on your screen?
Yes.
And who did you determine that that was a call to, or at least to the device that was possessed by a certain person? Or
that was the phone number that was used by Janie Deal.
And that was Mr. Tennant's girlfriend?
At the time, I believe so, yes.
And this was the date of his arrest?
Correct.
Okay. Did you know that Mr. Tennant had like a black dog?
Yes.
Okay. And that it was actually in the vehicle with him when he was arrested?
Yes.
Okay. Do you have any evidence as to whether or not Mr. Fernandez was calling to make sure Henry Tennant's girlfriend had his dog?
I didn't listen to the call. I do know that there was a conversation about the dog with somebody else.
Did you ever review any of the poll cameras in this particular case?
I might have looked at them. I don't remember specifics about the poll cameras.
You don't know whether or not there's poll camera video of this Mr. Tennant's dog running around the Potomac property?
I don't recall seeing a video like that.
But as to the significance of that call, it's just that it occurred on the date of Mr. Tennant's arrest to Mr. Tennant's girlfriend.
That's correct, and it was the only one.
Whether it's for a dog or any other reason, you can't testify.
Correct.
Okay. Now, Ms. Butler, I was asking you questions about some of the other searches by Mr. Biggerstaff on January 25th. And you didn't recall some of those that I mentioned. Your Honor, may I approach the witness?
Yes.
I'll approach. Ms. Butler, what I'm showing you is a composite exhibit, Defendant's Exhibit 53. I want to give you an opportunity to look at these and see if you can identify them for the jury.
Sure. So the one I'm holding right now appears to be a record of a search for Charleston, South Carolina military base that and UTC time was January 26th of 2022 at 1:51 a.m.
And doing that math, can you tell us what time that would have been in Eastern Standard Time, either with daylight savings or otherwise, whatever would be appropriate?
Sure. It would be January 25th, 2022 at 8:51 p.m.
Okay. This would be around the same time period of the other searches you testified to, correct?
Around the same time, I believe the other searches started at 8:15 p.m.
Okay. But within the same hour?
Correct.
Okay. And there's another one I'm going to show you. And if you could do that same somewhat UTC analysis.
Sure. This one is a search for Randy Reap, and the converted time would be January 25th, 2022 at 3:05 p.m.
And these appear to be similar to the same searches that you recovered as far as the way they look.
Yes.
And the same device that you were referencing.
The same Google account, yes.
And that was related to Mr. Biggerstaff?
Correct.
Okay. You would agree that a search for a Charleston, South Carolina military base doesn't appear to have any relevance to the homicide of Jared Bridegan?
Not that I'm aware of, no.
And Randy Reap, a local attorney, no information that that has any relation to the homicide of Jared Bridegan?
Not that I'm aware of, no.
Your Honor, may I publish to the jury?
Yes.
Now, Ms. Butler, after reviewing those, you would agree there were plenty of other searches from Mr. Biggerstaff's device that didn't have anything to do with firearms?
Yes.
And didn't appear to have any relevance to the homicide of Jared Bridegan?
Not that I am aware of, no.
You had an opportunity to review the Google searches of Henry Tenen?
I likely did. I can't recall the details of them.
If you had an opportunity to review some of those searches, would it refresh your recollection?
It might, yes.
Your Honor, may I approach the witness?
Yes, you may throughout. Is that something in evidence?
No, ma'am.
Okay. Is there an objection?
I haven't had time, but I don't know if I have an objection.
Okay. Members of the jury, we're going to take our mid-afternoon break, okay? We'll come back in 15 minutes. All right, Ms. Butler, everyone may be seated. Ms. Butler, you're still in the witness stand, so you can take the break. Just don't discuss your testimony with anyone, okay? Stay here. All right, thank you. Court's in recess.
All right, I wanted to show you this. Aaron was able to find this. Now let's see here. All right, let me zoom in here. All right, in the okay, so this is the appeal. Kirsten Bridegan is the petitioner. Obviously today, so this was filed at 12:01 and 21 seconds. Okay, by order of the court on compliance with subpoenas rendered August 20th, and the order to show cause, setting a hearing for August 21st. So wait a minute. Okay, so this was okay. Okay, so hereby stayed for a period of 3 business days from the date hereof, and conditioned upon the filing of a petition of wit in the court, and petitioner is seeking a stay. So he was able to get in front of an appellate court. That's interesting. So this happened at what, like 9:30? By the time he got out of there, it was like 10 o'clock, and then he was able to file. I mean, he being Mr. Clifton, Doug Clifton, was able to file that, within 2.5 hours. So he was able to file that at 12:01. Right? Aaron is on it, right? Thank you, Debbie and Beach Mom. Pretty amazing, right? That happened. All right, here's the other thing I wanted to, let me see here. All right, so this was filed, this was filed at 11:51 a.m. This was filed right before midnight. Comes now Kirsten Bridegan via counsel and pursuant to Florida law, files the below in response. All motions and the answer shall be in writing unless specified otherwise by the judge. A defendant's omission to file motions or answers should not be deemed as admission of guilt of the contempt charge. 1. Mrs. Bridegan requests the opportunity to be heard at a hearing order for 12:30 p.m. August 21st. Mrs. Bridegan has pursued her rights to appellate review of the judge's order, demanding she turn her phone over for up to 3 days to the custody in Vista. On August 21st, 2026, an emergency petition to invoke all writs jurisdiction has been filed with the 5th District Court of Appeal for the state of Florida. Number 4, the 5th District Court of Appeal has acknowledged acceptance. 5, the 9 a.m. deadline for Mrs. Bridegan to turn her phone over effectively prohibits appellate review. 6, an extraction of phone data is a process that only takes a few hours, not days, to complete. Providing an opportunity for the 5th District Court of Appeal to review does not prejudice any party to the case. On August 19th, 2026, defendant proposed the morning of Wednesday, August 26th, 2026, as the date for extraction of Mrs. Bridegan's phone. The proposal was included in the motion for status conference regarding compliance with the court's August 19th, 2026 directive to identify a forensic vendor. So they're just trying to find a third party. Well, they did, pursuant to review. So this is them asking for more time, basically. A short extension in time to allow appellate review should not be issued for the defense. If Wednesday, August 26th was accepted by the defense on August 19th. Oh, wow. So now they're saying the defense shouldn't be allowed to order an issue. Now they're saying, I'm sorry, an extension. So now they're saying we want an extension for the appellate review, but Shanna doesn't get an extension. I'm sorry, that's really funny, but In addition, counsel spoke with Kyla Nelson, forensic analyst with Invista Forensics, while she was outside the courtroom this morning. Counsel advised that Mrs. Bridegan's current iOS, okay, so she's got an iPhone 26.6, so Kirsten has an iPhone, is a system that Invista does not believe will be able to perform an extraction. Okay, so there you go. So they need to find somebody else. Kyla Nelson left the courthouse while counsel was in this morning's hearing regarding the motion to show cause. Mrs. Bridegan's husband was unfortunately deleted. She's currently attending the trial of one of the co-defendants. 13, Mrs. Bridegan fully cooperated with the Jacksonville Beach Department when this investigation began. 14, Mrs. Bridegan has sat through nearly 10 hours of depositions by defense counsel. That she has, and two different occasions. She's gone two different times. Just, it's like crazy, right? 15, at the very least, Mrs. Bridegan deserves the opportunity to allow the 5th District Court of Appeal to rule on her current filings. Yeah, I mean, she's got that right. 16, if the court finds Mrs. Bridegan in contempt, a sentence will be announced. All right. So they're saying, okay, at least allow us the chance to appeal, and if you still find us in contempt, all right. 17, the idea of jailing a widow while her alleged deleter trial is taking place would be an unthinkable and devastating outcome. So here's the crux of it right there for sure, especially under the circumstance where appellate review is imminent. That's, I think, where a lot of you guys are falling, right? The idea of jailing a widow while her alleged deleter's trial is taking place. Well, not her husband's. Well, a widow while Mario's trial is taking place would be unthinkable and devastating, especially under the circumstances where appellate review is imminent. Well, I'm glad that there was this stay. I'm glad that they were able to stay it, and I'm just looking at. So it went to the Baez law firm, Kirsten Nelson. They're down in Miami. I went over to Dresser. He's in Jacksonville. So, that would be pretty bad. Paula, do we know why? They feel that there is information on there that shows bias. It goes to bias of Kirsten. She probably, and talking to her kids who are witnesses, possibly other people, saying disparaging remarks about the defense team. I'm sure she was probably saying disparaging remarks about Shanna, Mario, who knows. But it's basically, it goes to the bias. Unthinkable, devastating, and stupid. Paula says, Debbie, if they sentence, it's so wrong if they sentence her. Adam, when I was in high school, I was aide for a circuit court judge. I saw how awful some attorneys can be. That's why I became a medical professional. Yeah. K-Girl, is Judge Kite mad about being called out by appeals? I don't know. Maybe, I don't know. Yeah. I'm not sure. I've never been a judge, so I don't know how that works. Everybody's kind of like a big ouch cube right now. Everybody's like, stepping on everybody's toes and stepping, softly and lightly. And it's, I don't know. How would you like it if you made a ruling and then your supervisor or some group above you knocked that down? I guess it's kind of like that. Paula, Judge Kite is trying to allow Shanna to have a unbiased trial. She's trying to give her the fairest trial possible without witnesses being biased. So she's trying to save Shanna's trial from being overturned because of some kind of bias that came in. We are a delicate humanity. Yep, I agree. K-girl, she shouldn't be, but she just seemed annoyed. Yeah, I mean, I could have, I mean, like I said, I've never been a judge, but the only thing I can think of is like you make a ruling and then somebody above you says, yep, nope, your ruling is thrown out. That's kind of the only thing I can sort of think about it. Soglo, it is the lawyer's job to appeal for their client. Sally, in your opinion, she's relieved as she stated there's no case history on this matter. That's true. Yeah, I mean, she may be flustered or frustrated. Maybe she's frustrated more than anything. She might be just frustrated because I know she's like had seven hearings, 7 rulings, and then this came up again in the middle of trial. She's probably just frustrated by it, and maybe ultimately she's probably happy that the appellate court has stepped in. But they're basically just giving her 3 days. I mean, that's really all they're giving her. Right? Doesn't she still have to make a decision? Yeah, they're just giving. So they're basically just giving her 3 days. And what happens after that? The order of compliance stayed for a period of 3 days. So really, that's conditioned upon the filing of a petition of writ. So they're just giving her 3 days to decide what to do. So we may be in this problem again 3 days from now, 3 business days. So that's going to be Wednesday. We may be right back where we were today, 3 days from now, So it's not like they're saying you have to give your phone over or you don't have to give your phone over. They're not saying that. They're just saying she has 3 days. Shanna, I agree. She's frustrated. Yeah, I think she's. It seems like she's more frustrated. Christine, I will be going there either Wednesday or Thursday. I'm going to go either Wednesday or Thursday. I want to go for closings. I'm going to go for closings. Robot says, that's what I would have thought, but judge's comments to Kirsten's lawyer. This isn't an attempt to stall until the 5th degree appellate court ruling on your stay comes back, suggests otherwise. Dreamcatcher, what is a looking on her phone? What is a looking for on her phone? Don't you have to have probable cause? That's for law enforcement. Law enforcement is for probable cause. I don't think for attorneys and depositions. I don't think so. And I from what I understand, I don't think Kirsten is upset necessarily about letting them see. She just doesn't want them to see like everything and anything and have this catch-all. Like Mr. Clifton was saying, it's a fishing expedition. We don't want them just saying, "Hey, we want to look at your phone," and then just go through everything. It's like looking under your everything. It's like I don't know. It's looking at everything that and that's what they're really fighting. So closings are going to be next week. Yeah, Wednesday or Thursday. Sheila in New York, you are very, yes, you are very, that is an understatement. Yes, Kirsten Bridegan is Jared's wife and Jared is the victim. So that is his widow. She's already testified. She's already given 2 depositions. So I'm sure she's over this. I'm sure she's just over this. Oh, let's see. Eileen, file charges if they believe there's witness tampering. Yeah, they may. I mean, don't think this is over. I mean, this is going to go on. This is going to be contentious. It's going to be terrible. It's going to be just I hate to say it, it's going to be like a bloodbath, I think, for both sides. But we'll see who's got the more resolve, who's got more resolve to get through this. We've got Jose Baez and his team. Kirsten Nelson seems pretty, she seems pretty on it. And then you got the state, Mr. Mizrahi and Ms. Stifler. We'll see who's got more resolve, and they're going to battle it out in court. But already it's getting messy, and it was messy from the get-go. We've been watching hearings for a year now with these three parties with Mario, and it hasn't been pretty. All right, Debbie, we'll see you in a little bit. Sheila, you hope to catch up this weekend? Sounds good. Yeah, Sheila, read our description. If you have a question, I would say start there. Read our description. That tells you a lot. Tells you all the players and gives you a background. Talks about Henry. I'm sure you'll hear Henry's comes up a lot. The only person we don't have in our description is John Biggerstaff. We don't have him in our description. I don't think we do. I don't think so. Anyway, yeah, read our description. Take a minute while court's in recess and read our description. That will help you. So, Eileen, the appellate court may side with Kirsten and rule the judge's decision to make her turn over her phone to the defense. Yeah, again, this does not say that she's free and clear. This just says she has 3 days. Nowhere in here where it says that you don't have to do anything. You don't have to turn the phone over. It just says here that the hearing scheduled for 12:30 has been stayed for a period of 3 business days. And the petitioner is seeking a stay. So they're just asking for more time, and then a ruling. So they're not saying you don't have to give the phone over. They're just saying you have 3 days. And then they're seeking a stay on all of this. So Jane, what if something from her phone would be leaked if downloaded? I'd be thinking that wouldn't be the first time. Grampy, no, they're both in jail. Actually, all three of them. All three of them are still in jail. None of them were able to catch bond. They're all in jail. Yes. When in doubt, check the description. Check the description first, and then come back with any questions. Carolyn, why can't the judge simply deny it? Because the appellate court is above her. The appellate court is above her. And then above that, you've got the state Supreme Court. And then, of course, above that, you've got the U.S. Supreme Court. So you have all these layers. So the judge can't deny it because the appellate court has jurisdiction over, has the say over her. So let's see. Okay, girl, judge has to balance Fourth and Sixth Amendment rights. She has said multiple times it's your constitutional right to privacy and Marcy's Law, which is the victim, because Kirsten is a victim and she has rights. She absolutely has rights, just like Shanna has rights. So you're right. It's this balancing act. It really is a balancing act. No problem, Grampy. And there are no such things as stupid questions. That is true. As Camilla says, there are no stupid questions. Yes, you guys are on the same page. Sheila, thank you for the jewels. Appreciate that. Thank you. All right, have we all hit the like button? We're at 295 likes. Let's see if we can get to 300. Can we get to 300 likes, you guys? We have 327 people watching. Take a moment and see if you've hit the like button. Take a moment to see if you have hit the like button and see if you can get us to 300. Can we get to 300 likes before court comes back from recess? Taking a 15-minute break, which I think will get us to the bottom of the hour. So take a moment and actually they've been going longer than, they've been recessed for 20 minutes. See if we can get to 300. We're at 296 likes. Eileen, it's it's been stayed for 3 days. Hereby stayed for 3 days. So I'm not sure when. I'm not sure. I think they have to file more. I think they have to do more filings now. Ooh, 301. Awesome. Good job. Thank you, guys. Appreciate that. Pirate, the judge could have denied the defense motion for this. This is a bad call. But then the defense would have appealed that, and then it just would have been. I think the defense would have appealed that, right? Why? I mean, I think whatever the judge decided, the other side was going to appeal it. This is the way I feel that this is going. Missy, I wonder if we're going to be late again tonight with this court. I don't know. It's Friday night. They went late yesterday. They went like an hour and 5 minutes. I would say no. If I had to guess, Missy, I would say no. Only because they went late last night and it's Friday night. I don't think she wants her jury to be burned out. I don't think she wants her jury to be burned out. Brett, yep, basically Kirsten's been giving 3 days to try to move this fight to the appeals court. The judge's current ruling would make an eventual Kirsten victory a hollow one, so this gives her a shot. Ooh, 309 likes. Good job. Thank you so much, you guys. All right, I'm going to go get some water. I'll be back in a second. Hello, Super Ball. Super Ball's tail's like a shark. She just kind of goes back and forth. All right. Yes, Shan. Oh, and they're back. 300 likes, celebration time. All right, here we come back.
All right, thank you. Let's bring in the jury.
Your Honor, if you would like, James Hill on behalf of Mr. Fernandez, the state and defense had an opportunity to review some additional pieces of evidence, and by stipulation and agreement, we have pre-marked and entered defendants 58, which are Chrome records for Henry Tennant as a composite, 2 pages, and defendants 59, which are Chrome records regarding John Biggerstaff.
Okay. All right. Let's get that jury.
No objection from the state.
Thank you.
Your Honor, the jurors are entering the courtroom.
Thank you. Thank you. Welcome back, members of the jury. Everyone may be seated. Mr. Hill, you can continue.
Thank you, Your Honor. Ms. Butler?
Yes.
I'm going to use the technology this time.
Okay.
I'm going to show you what has been marked by agreement and entered as defendants 59. Can you see this on the page?
A little blurry.
I will do my best.
Is the autofocus on?
I'll zoom in a little more, otherwise I'm going to do it the old way. Is that better for you?
Yes.
Okay. If you could, read to the jury these additional searches starting at the top from Mr. Biggerstaff.
Starting at the top, it is a visit to a website or a URL that says how to measure your bra size at home, 4 simple steps.
The next search?
Bra size chart dash third love.
And the third search?
How to measure bra size and bra size calculator, Victoria's Secret. I'd just like to clarify, these are Chrome, looks like these are Chrome records and not searches.
Can you tell the difference? Can you explain to the jury what that means?
Sure. So because it said Chrome at the top, based on my understanding, that indicates, that was a website that was viewed with that URL, whereas the records that we viewed previously had search at the top.
But you would agree, Mr. Biggerstaff has gone to all sorts of different types of websites that certainly seem to be unrelated to the homicide of Jared Bridegan.
Yes.
Now I'm going to show you another document. This is Defendants 58, which is a composite of Chrome records from Henry Tenen. Can you see this clearly on the screen?
Yes, I can see that.
Okay. And can you start with the first one up top, including the date?
Sure. The first one says visited Form Swift, create your business plan V2. And the converted date would be March 20th of 2022 at 3:41 p.m.
Okay, and could you read the following 3 for the jury?
Sure. Choose free business plan forms templates, March 20th, 2022 at 3:40 p.m. Choose free business plan forms templates, March 20th, 2022 at 3:40 p.m. And free business plan forms templates, March 20th at 3:39 p.m.
Thank you, Ms. Butler. It's your understanding, based upon being involved in this investigation, that Mr. Fernandez provided a check in the memo line that said, Kickstarter, good luck.
Yes.
And that at some point in time, law enforcement recovered a notebook belonging to Henry Tenen that also included a page for business plan.
Yes.
Okay. And you would agree that the dates of search or for the sites visited are around the same time period of the checks that Mr. Tenen received from Mr. Fernandez?
Roughly late March.
I believe it was March 28th were 2 checks, and then April 4th for the Kickstarter.
That sounds correct.
You would agree that's within a 2-week period?
Correct.
Ms. Butler, there was discussion of January 29th on your direct examination about Mr. Fernandez being at the Potomac residence.
Yes.
Okay, as well as Mr. Tenen being somewhere in the vicinity of the Potomac residence.
Yes.
Okay. And Agent Blythe previously testified, so we won't go into the timing events and his analysis, but you would agree you personally have no evidence that puts Mr. Tenen and Mr. Fernandez actually together on that date?
Not that I'm aware of, no.
And no evidence that Mr. Fernandez was ever in the blue F-150 as it made its travel south on that particular date with Mr. Tenen?
I apologize. Can I back up?
Sure.
For the previous question, if they were together on that date, I can just say that there are periods of time where their devices were roughly in the same area.
Same area.
Correct.
And you would agree that Agent Blythe, being an expert in CAS data, that he would be more appropriate as to helping the jury determine the proximity of those devices?
Yes.
Okay. And with regards to the blue truck release by the media, you saw photographs of that truck, of what was released to the media?
Yes, I did.
And at the time, there was an inability to even make out what the tag on that vehicle was, correct?
Correct.
Okay. These were not perfect still shots of a vehicle. Would you agree with that?
I can't say that they were perfect or imperfect, but you're correct. There was no tag visible.
And these were snapshots taken from surveillance videos as that vehicle was driving through various areas of Jacksonville Beach?
Yes.
Okay. In essence, the public needed to help to try to identify this truck because it wasn't able to be identified just by the photograph by law enforcement.
Correct.
And your review of the data established that Mario Fernandez and Henry Tennant spoke on average about 30 times per month.
I'd have to do some math. Let's see. I can speak to the number of times per month. I apologize. I'm not sure about the average.
And no disagreement that they had fairly regular communication.
Yes.
Okay. And no dispute that for a time period, Mr. Tennant was a tenant of Mario Fernandez.
Correct. And
your understanding from being involved in this investigation that Mr. Tennant also did some landscaping and other work for Mr. Fernandez.
Based on the checks, yes.
Okay. So certainly if someone is doing work for a person, it wouldn't be unusual for them to have phone calls or text messages between the two.
I would likely expect to see communication between people.
I imagine for your testimony today, you were in communication with the state attorney's office.
Yes.
Okay, the phone calls or text messages or emails.
Yes.
Okay, so it wouldn't be uncommon for people that work together in some capacity to have communication.
Correct.
And when the truck was released to the media, there wasn't what we would consider like a flutter of calls between Mr. Tennant and Mr. Fernandez.
I'm not sure what a flutter, but there were the calls that I mentioned in my direct examination.
They were actually the day after it was released to the media.
Correct.
It wasn't the same evening that that was released to the media.
Correct.
Your Honor, may I have one moment with counsel?
Yes.
No further questions for this witness. Thank you, Ms. Butler.
Thank you.
Thank you. Redirect.
Just briefly, Your Honor. Ms. Butler, Mr. Hill mentioned that you did a historical review of periods of time. That was for periods of time in which there were both no timing advance and no cellular activity.
No timing advance and no outgoing cellular activity.
Were there any of those time periods include incoming cellular activity?
Yes.
Okay, so that's different than the time period we're talking about on February 16th, because the time period from 7:10 p.m. to 8:20 p.m. was no cellular activity whatsoever, correct?
Correct.
Meaning no incoming and no outgoing.
Correct.
And no timing advanced.
Correct.
And those other 4 periods you talked about were just no outgoing, but included incoming.
I can't speak to every single date, but I did look at that in my analysis.
So the presence of that time frame with no timing advance, no incoming, and no outgoing is less than 5 out of 60 times in that historical period.
Less than 5 out of 61.
Sustained.
Do you know what percentage that would equate to? 4 out of 60, let's be generous and say one of those times had incoming.
Man, I'm getting put on the spot here. I know that 5 out of 61 days would be 92%, so a little bit less than 92% for 4 out of 60.
92% of the time, his phone was either recording timing advance or using cellular data in that 60-day time period.
During the time frame that I looked at in the 61-day time period, yes.
Mr. Hill asked you a bunch of questions about financial analysis. Based on his background, did Detective Johns kind of take charge of the financial analysis in this case?
Yes, he did.
The Google Chrome deletions that Mr. Hill was asking you about, you testified earlier that the primary database was bulk deletions. And the chart you made with that spike of 5,000, which database was that from, the primary or the secondary?
The secondary.
And can you explain to the jury what the secondary database deletions indicates to you, or what it means based on your conversations with Google and your experience?
So the secondary file is the one that contains the line by line. So it's an accounting of every record that was deleted from the Google account within a certain time frame. And that's the one that has the process date and time, as well as the original event date and time and the Google product affected by the deletion.
What types of Google products did you observe as affected by the deletions in the secondary database?
In the secondary database, there were a number of Google products to include Add, Google Discover, Image Search, YouTube, Gmail, Chrome, Search. There was a number of different products.
And Mr. Hill asked you about connections between a man named Jimmy Jones and Mario Fernandez Saldana. Did you observe any connections between the two of them in any of the records you reviewed in connection with this case?
Nothing in the records that I reviewed.
Did you see any connection between Jimmy Jones and Jared Bridegan in any of the records or phone downloads you looked at in this case?
Nothing that I reviewed.
And you had Mr. Bridegan's toll records and phone downloads as well to review?
Yes.
Did you see any connection between Jared Bridegan and any of the toll records or phone downloads or financial records or other records you reviewed in this case between Jared Bridegan and Henry Tenon?
No, I did not.
There were none?
There were none.
Did you see any records or connections between Jared Bridegan and John Biggerstaff in any of the records you reviewed?
No, I did not.
The only connections between all these individuals were Mr. Fernandez, obviously, based on your prior testimony, had communication with Mr. Biggerstaff and with Mr. Tenon.
Correct.
That phone call to Janie Deal on August 18th, 2022, to your knowledge, was Ms. Deal, when that call was placed, detained by Jacksonville Beach police detectives at the CJIC office for questioning?
Yes.
When Mr. Fernandez called her?
Yes.
Thank you. I have no further questions, Your Honor.
Anything further for the witness?
Just briefly. Ms. Butler, any evidence that Mario Fernandez knew where Janie Gill was at the time he made that phone call?
I don't have any evidence about that.
I have no further questions.
Ms. Stifler, anything further? Okay. Thank you, Ms. Butler.
Thank you.
Call your next witness. Calls Detective David Ostertag, JSO.
Officer Ostertag. Good afternoon. If you could just pause here in the front, raise your right hand to be sworn in.
Detective, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
All right, sir, if you head over this way, watch your step. There's a slight incline. Make yourself comfortable. You may proceed.
Thank you, Your Honor. Good afternoon, Detective.
Good afternoon.
Could you please introduce yourself to our jurors?
My name is Detective David Ostertag. That's spelled O-S-T-E-R-T-A-G.
And Detective, what agency are you employed with?
I'm employed by the Jacksonville Sheriff's Office.
How many years have you been with JSO?
I've been with JSO for 20 years.
And what's your current position at JSO?
I'm a detective in the Digital Forensic Investigations Unit.
And what other positions have you held in your many years with JSO?
I was a patrol officer in what is now District 5, as well as a field training officer.
Can you give the jury a little bit of background into yourself? Tell us about your educational background.
Yes, I have a bachelor's degree from Auburn University in Management Information Systems. I also have a master's degree in criminology from Florida State University. I have approximately a little over 1,500 hours of training in digital forensics, encompassing various aspects, including cell phone forensics, data forensics network, as well as computer forensics.
And as part of your work with the Digital Forensics Unit at JSO, do you perform device extractions?
Yes, I do.
How many would you say you've performed in your career with CFIU or Forensics Unit?
I would estimate approximately 1,500 or so.
And can you tell the jury the tools and software that you're trained in order to perform these extractions? I've been trained in various softwares and tools, including those made by the Cellbrite Corporation that is for extraction and analysis of data, as well as the Axiom program, which is also a program for extraction and analysis, and then various computer forensic softwares such as X-Ways and Forensic Toolkit and those types of things. And are you trained not only in extracting information from various devices, but in interpreting data that you receive from Apple iCloud or Google Cloud or other digital forms of data?
Yes, I have been.
Can you explain to the jury how data is extracted from a device, whether a phone or a computer or otherwise?
So the data is isolated from the network to start with, and that means either putting the phone in airplane mode or examining it in a secure environment in our digital forensics lab. So what happens in the most basic form is the device, whether it's a computer or a cell phone, it's connected to a forensic extraction device of some sort, and that extraction device acts as a go-between between the forensic computer and the device that's being examined. It also prevents any sort of overwriting of data or any writing to the device itself or any changes made to the device. So the forensic extraction device acts as a go-between. It communicates with the cell phone or computer and then transfers the data over to the forensic machine where it's then analyzed.
The data that you extract from a device, do you have to take steps to make it readable to the average person?
Yes.
Can you describe that for the jury?
So the forensic extraction device reads the raw data, and it writes the raw data to the forensic computer. On the forensic computer, there's analysis software, and what that does is creates reports. It goes through the raw data. It parses out the data into readable categories such as text messages, cell phone logs, pictures, videos, event logs, and then the data is then readable in a report format.
Can you search for different types of data once you've extracted and parsed that data into a readable format?
Yes, you can.
And if we're talking about specifically a phone extraction, like the ones we have in this case, what types of data are contained in a phone?
There's various types of data. There's user data, which would be cell phone logs, call logs, and then you have text messages, application messages like Facebook Messenger and Instagram, and then you have pictures and videos and other things that the user can see. But then it also extracts some back-end data, which only the phone itself can see, and that would be device events, communication logs, like it counts the types of data that's being transferred and the amounts of data transferred between the network and the cell phone. And then there's operating system data, and that data is typically not parsed out by the Cellbrite software.
If something's not parsed out by Cellbrite software, as a computer forensics detective, are you able to look into the raw data to look for more information?
Yes, I can.
I want to turn your attention to work in this case where you asked to review cell phone extractions and Google returns related to 3 individuals, 2 cellular devices for Henry Tenon.
Correct.
1 cell phone extraction for John Biggerstaff.
Correct.
And for the defendant in this case, Mario Fernandez Saldana, 1 device extraction and 2 Google returns.
That's correct.
I have a PowerPoint for ease of use while we talk. We're going to start with Mr. Tenon, and we're going to start with the data from his phone, the CoolPad 0513, and I'm showing here photographs. This is State's Exhibit 186. When CFIU receives a cell phone, is this how it comes to you?
Yes, it is.
What steps are taken to ensure that the data on a cell phone is preserved for forensic extraction and analysis when it is seized from an individual?
We take various steps, and that could include putting the phone in airplane mode. We also have a secure environment at the digital forensics unit in order to examine phones off the network.
And is that to ensure that data can't be remotely wiped by somebody or interfered with in any other way?
That's correct.
So in this case, we have States 186. That's a view of that CoolPad phone. Did you review the extraction completed and parsed through Cellbrite of this CoolPad cell phone purportedly belonging to Henry Tenon?
Yes, I did.
I'm going to ask you a few things about the reports you reviewed. So I'm showing you part of States 186. This is an extraction report from that cell phone, and it is labeled contacts. Are you able to parse reports showing what contacts exist in a cell phone?
Yes, that's correct.
And in this case, were you asked to pull a report to see whether Mr. Tenon had a contact for a phone number 904-566-2633?
Yes.
And we see here this extraction report, and what does this indicate?
This extraction report indicates there is a contact on the phone stored as the name Mario with the phone numbers 904-566-2633.
And for this particular phone, were you also asked to see if there were any cell phone communications stored on the phone, communications through texting or instant messaging or social media between this phone number and the CoolPad itself?
Yes, it was.
Were there any contacts, calls, texts, or interactions between Mario 904-566-2633 and this phone?
There were none.
I'm going to skip ahead a little bit to still in States Exhibit 186, were you given a second cell phone purportedly belonging to Henry Tenon, which was an LG phone?
Yes.
And in that phone, was it associated with a phone number ending in 7612?
Yes, it was.
And here we see an extraction report where you asked to look for any communications, text messages, instant messages, otherwise, between this cell phone number, 7612, and Mario Fernandez, 566-2633, stored as Mario in this phone?
Yes, I was.
And were you able to find the presence of any messages in this phone?
Yes, I was.
And how many were there?
4.
And here we see one of those messages. First of all, is this the report that you pulled? I split it up into 4 slides, but we're showing 4 messages.
Yes, it is.
The first message, did you convert these from UTC to daylight savings time?
This is standard time, but
standard
yes.
Time, I'm sorry. So that would be UTC -5?
Correct.
So see here we have one message from Mario, 566-2633.
Correct.
We have one message here heading your way from 566-2633. And the date on this message?
Yes, this one is January 4th, 2022.
And 7:03:47 p.m., that would be the correct time converted from UTC.
That is correct.
On the following slide, we see what appears to be the same chat thread. The owner of the phone, which would be 7612, Mr. Tenon, presumably replying, okay.
Correct.
And then this phone number belonging to Mario, 566-2633, saying, I'm here, brother. And this is 7:21 p.m. and 7:50 p.m.
That's correct.
On January 4th.
Yes, ma'am, that's correct.
Were there any other messages present in this cell phone between the number for Henry Tenon and Mario Fernandez?
No, there were not.
Only 4?
Correct.
I'm next going to draw your attention to some reports you pulled from a Samsung Galaxy Note 20 the phone number 517-6322, purportedly belonging to John Biggerstaff, and that is State's Exhibit 187.
Yes, ma'am.
And here we see, are these photographs taken by CFIU when they receive the evidence?
Yes, that's correct.
In the second slide, we see, what are we seeing in this picture?
This is the SIM card for the device. It acts as a go-between between the phone and the carrier just to identify it as a valid cell phone on their network.
And was a full extraction completed for the evidence we're discussing today?
Yes, there was.
And can you tell the jury what a full extraction means?
A full extraction just means every accessible file on the device is downloaded from the phone and then transferred over to the forensic computer.
So does that mean the reports we're reviewing contain what is on the phone and available?
That is correct.
There's nothing lost during that parsing or extraction process with a full extraction?
Correct.
And I'm showing you an extraction report from Mr. Biggerstaff's phone where you asked to pull the instant messages available on this phone between Mr. Biggerstaff and Mario Fernandez 5662633.
Yes.
And how many messages were available for extraction and parsing?
654 messages.
And I'm showing you the first of these messages. When you reviewed them, are they first of all, are they time dated and in time order when you're looking at an extraction?
Yes, they are.
And in this case, when was the first available message for review between Mr. Biggerstaff and Mr. Fernandez?
The first one available was May 12th, 2022.
There were no text messages still on the phone prior to May 12th of 2022 between Mr. Biggerstaff and Mr. Fernandez?
No, there were not.
And there are some texts between the two of them. The jury will have some of these reports for review later. And the last, we don't need spell check. The last text available, what was the date on the last text available for extraction and review?
August 22nd, 2022.
So when Mr. Biggerstaff's phone was placed into that extracted, parsed the data, we have a date range of May 12th, 2022 through August 22nd, 2022.
That's correct.
No text predating that time period.
None between these two parties.
Okay. I'm going to move along to Mr. Fernandez's Google return, where you ask to parse some data through Axiom and pull reports through Axiom related to a Google return from Mario Fernandez.
Yes, I was.
And that State's Exhibit 185. We'll start with this, where you asked to pull a report in relation to records under the keyword search 5239 Potomac Avenue in Mr. Fernandez's Google return.
Yes, I was.
And the jury will have those reports. I just want to go through a few records, and when they're looking at records themselves, can you explain to them what they're reading and how to read it?
So these records, this is a typical email record, and what it shows is who the email is to, who it's from, and then you have the times that they were submitted, which is when the user clicked send, and then delivered is the time that it took to go through the network, and then it was received on the other end. And then, of course, you see the subject here, the subject of the email, as well as the body of the email. And then I'll go back to where you see the submitted and delivered dates and times. It says UTC +0. That means that it hasn't been corrected to the current time zone. So during the winter, which this is February 24th, we're still on Eastern Standard Time, you would subtract 5 hours in order to get the submitted and delivered dates and times for those. For daylight time, it would be 4 hours difference. In this case, this email was sent actually on February 23rd, 2022 at 7:11 and 28 seconds p.m., for example.
And some of the records that you were asked to pull related to invoicing and the exchange of paperwork, invoices, and calendar invites between First Choice Home Rentals and a Bueller Air Conditioning under the keyword search 5239 Potomac Avenue.
Yes, that's correct.
And these show that Mr. Fernandez, or this email address stored in his Google account, was coordinating for some work to be done on the home. And in doing so, they were sending these are notifications,
correct,
calendar invites, invoices, and acceptance of calendar invites.
Yes, that's correct.
And acceptance letters.
Correct.
When you review the records, are you also able to see attachments to emails that are sent?
Yes, I am.
And here in this slide, this is slide 31, is this an example of an attachment that was in the body of those emails that we discussed?
Yes, it is.
And this is showing a service plan where Mr. Fernandez apparently has gotten a service plan with Bueller Air Conditioning to run from September 1st, 2022 to September 1st, 2023.
Yes, that's correct.
I want to ask about some emails you were asked to pull from September of 2022. Can you explain to the jury what this is indicating here? Is this an invitation for like a calendar invite via email?
Correct. That's an invitation sent from Brandon Hood to First Choice Home Rentals, Mario Fernandez, in reference to a meeting on September 7th at 3:30.
And what is the corrected date and time of this invite or calendar invite?
This was sent at, September 4th, 2022, subtract 4 hours. I'm sorry, September 5th, 2022, subtract 4 hours, and that would be 6:53 and 18 seconds p.m.
And in review, we were asked to pull some of the records related to an email exchange between First Choice Home Rentals and Brandon Hood at atlasHomebuyers.com. Are these those emails that you pulled?
Yes, they are.
And this is just showing more calendar invites for a seller appointment with Mr. Fernandez.
Correct.
Is this showing another calendar invite with that same atlasHomebuyers.com?
Yes, that's correct.
And what is the corrected date for this?
This would be September 8th, 2022, and subtract 4 hours would be 3:52 and 23 seconds p.m.
And we see here, is this an attachment to one of these emails that includes a DocuSign document?
Yes, it is.
And what is the name of the document that's attached?
The name of the document is pricereduction.pdf.
And then we have an email here from a floridatitle.com.
Correct.
What is the corrected date and time of this email?
September 21st, 2022 at 12:07 p.m.
And we see here just an email talking about a contract to purchase Potomac Avenue for $90,000, hoping to close by October 12th and hoping to close remotely.
That's correct.
And then here is an email discussing some payoff information regarding that sale.
Yes, that's correct.
Lastly, I'm going to ask you about an extraction report that you reviewed for Mario Fernandez's Samsung Galaxy A13. And these reports are in evidence as States Exhibit 185. And we're looking at an extraction report device events. Can you describe to the jury what this report shows?
So as I sort of mentioned earlier, the device stores certain events, power logs, screen on, screen off, that sort of thing. One of the events that was stored on this phone was a factory reset for this phone.
Can you tell the jury what a factory reset does?
So if factory reset, what happens is all of the files on the phone are locked. Each individual file has their own lock. It's encryption. It has a key in which the lock is opened and the data is decrypted. So during a factory reset, the keys that unlock these files are destroyed by the phone. So it's no longer able to unlock any of these files. And where those files used to reside, it's now marked that those files can now be overwritten by new data. It would be similar to one of these large self-storage warehouses where each locker is each individual file. And then these files have locks. Well, I take all the keys to those locks on a key ring and I throw them in the trash, I throw them in the river, incinerate them, do whatever. Basically, you can't get to any of that data anymore. And while that was happening, the manager of the store went and put new locks on everything and decided that other customers could come in and put their new belongings inside these lockers, to where I can't get any of the old stuff back anymore, but all you see is what is currently on the phone and currently in those lockers.
And this device event report indicates that this phone was factory reset and wiped on August 26, 2022.
That's correct.
And everything up until this date, August 26, 2022, following the wipe factory reset, would that be no longer present on the phone?
That's correct.
That includes every photograph on the camera.
Correct.
I'm sorry, every photograph on that phone.
Correct.
Every text message on that phone.
Correct.
Every Google search on that phone.
Correct.
All social media.
Correct.
Any phone logs or phone records.
Correct.
Location information that predates this time frame.
That's correct.
If you wanted to keep your phone and use it further, would you have to log back into all of your accounts to get back into using that data?
Yes, you would.
So in this case, did you review Mr. Fernandez's on the Samsung Galaxy A13, the user accounts that were present on this phone when you reviewed it?
Yes, I did.
And here we see in States 185 user accounts, there are 35.
That's correct.
And what type of user accounts does a phone store in this report? Or what kind of data does it reflect in this report? I should say that's a better way to say it.
This shows login information for applications, certain websites, as well as Samsung Cloud, Google, basically any account that resides on the device is stored here.
Facebook Messenger.
Correct.
Social media, your Google.
Yes.
A First Choice Home Rentals Google account.
That's correct.
WhatsApp.
Correct.
Photos, Venmo, Gmail, basically any application you have on your phone is going to create a user account in this section of your phone.
That's correct.
Or in this database.
Yes.
So for Mr. Fernandez to have 35 user accounts present on his phone following that factory reset wipe, what does that mean he had to do?
That means he had to download these applications again from the Google Play Store and then log into those applications, install those applications and then log into them again on this phone.
I'm going to ask you about the chats that were available on this phone when you reviewed the extraction report.
Yes.
Were there any chats between the phone number associated with the phone, Mr. Fernandez, and John Biggerstaff?
Yes.
And how many chats were present on the phone?
There were 71.
And do you recall the date range that was available for your review following that factory reset and wipe?
Yes, it was August 27th through August 31st.
Did you search and see if there were any chats available with the phone number associated to Henry Tenen ending in 7612?
Yes, I did.
Were there any present on this phone?
There were none.
And in Mr. Fernandez's phone extraction, did he have a database still available for review of his contacts?
Yes.
And I'm showing you that report where you asked to pull a report of his contacts.
Yes, I was.
How many contacts were in his phone?
1,097.
And does that include the way we store contacts in our phone as well as social media contacts?
That's correct.
Did you search to see if there was a Henry Tenen, a Henry at Potomac? or a phone number associated to Henry Tennant ending in 7612 within the contacts database in Mr. Fernandez's phone?
Yes, I did do that search.
And was any of those present in his phone?
No, there were not.
You mentioned the device events report can give somebody viewing an extraction report a lot of information about the activity on the phone. Does that, and you mentioned power on, power off. Can you tell the jury what data you would be able to see if you looked in device events report relating to powering up, powering off, airplane mode?
Correct. So you can see any sort of settings change, including airplane mode, turning location services on and off in some cases, as well as plugging your phone in, taking it off a charger, turning the screen on and off, and other various functions that you wouldn't normally care about. But Samsung uses it for analytics, so it stores it on the phone.
Can you even tell if somebody used their password or Face ID to unlock their phone?
Yes, in some cases.
So you could, with some certainty, actually with precise certainty, you could tell if somebody had put their phone in airplane mode or turned their phone off at a specific time and date, if you had that device log.
Correct, yes.
You could tell if somebody was connected to Wi-Fi by looking through data on their phone.
Yes.
You could tell if they turned off location services by looking at their phone.
Yes.
Were you able to get any of that information from Mr. Fernandez's phone?
No, I was not.
And why not?
Because the phone was factory reset on that August date.
All right. May I have a moment with counsel, Your Honor?
Yes.
No further questions.
Thank you. Cross-examination. Sure.
May I proceed, Your Honor?
Yes, thank you.
Good afternoon, Detective.
Good afternoon, sir.
Nice to meet you.
You too.
I just have a few questions for you.
Okay.
The state indicated that you found a contact in Henry Tennant's phone for Mario Fernandez.
Yes, that's correct.
And you do understand that for a period of time, Henry Tennant was a tenant in one of the properties owned by Mario Fernandez.
Yes, that's correct.
So certainly it would be reasonable that a tenant would have the phone number for his landlord as a contact in his cell phone.
Yes, sir.
Nothing necessarily nefarious about that contact.
No, sir.
There were messages from the defendant, Mr. Fernandez, to Henry Tennant on January 4th, I believe was your testimony?
Yes, sir.
Okay. But you saw no messages on January 5th, correct?
That's correct.
Now, if I believe from your testimony, you mentioned there were 644 messages between John Biggerstaff and Mario Fernandez?
Yes, sir, I believe.
Sound about right?
That sounds about right.
You didn't recover or review any messages related to a 10-millimeter firearm, did you?
No, sir.
No messages related to the homicide of Jared Bridegan, did you?
No, sir.
Okay. But you did find messages consistent with work that Mr. Biggerstaff was completing with Mr. Fernandez?
Yes, sir.
Okay. And you found other personal messages between the two men?
Yes, sir, that's correct.
Now, there's mention of this factory reset on August 26th?
Yes, sir.
Okay. And when an individual purchases a new cell phone, okay,
yes, sir.
You're buying a new cell phone, so you're no longer going to use the old cell phone.
Correct.
Your understanding from own personal experience is sometimes the old cell phone is either disposed of or turned over as a trade-in to the provider.
Yes, that's correct.
That's not an uncommon situation.
Correct.
Okay? And certainly if you were going to turn in your cell phone back to T-Mobile in this particular circumstance, you would do a factory reset of your phone so that somebody else would not have access to your data.
Yes, sir.
Okay, that's not unreasonable.
Correct.
And certainly that would log you out of all of those different applications, Facebook, Gmail, Instagram, WhatsApp, whatever it may be.
Yes, sir.
Okay. Are you familiar with what IMEI stands for?
Yes, I am.
Can you tell the jury what that is?
The IMEI basically stands for the international, basically a unique identifier for the phone itself. It's a 15-digit number, and it uniquely identifies a phone on the network.
International Mobile Equipment Identity. Does that sound to be what that stands for?
Yes, sir.
Maybe a simpler way of putting it is it's a digital fingerprint for a particular device?
Digital identifier, yes, sir.
And each device would be different than the other?
Correct.
Okay. So if you have one cell phone, it will have an IMEI number, but if you had a different device, because you bought a new phone, it would have a different IMEI identifier.
Yes, sir, that's correct.
And that's something that when you do these forensic downloads, that would be contained in those records?
Yes.
Okay. So that's going to go back with the jury, and they would be able to see for themselves if on August 26th of 2022, if there are two different IMEI numbers, they would understand that as representing two different devices.
Not necessarily two different devices, because on newer phones, they will have two IMEI numbers assigned to them. There's one for the physical SIM card, which is that chip that we saw in the picture, and then there's an electronic SIM, which is embedded into the phone itself.
But not uncommon for two devices to have two different IMEI numbers.
Correct.
And certainly that could help to provide an explanation as to why there would be a factory reset of one device, is that it could be because a second device was purchased.
It could, yes, sir.
Certainly, if any member of the jury in their own personal experience had taken a device in to get the newer version, or they broke their phone, they may do a factory reset in order to get a new phone.
Correct.
Just a moment, Your Honor.
Yes.
Mr. Ostertag, Detective, I'm showing you a document that's contained in States 170, which are the financial records of Mr. Fernandez. Can you see that on your screen, sir?
Yes, sir.
I want to draw your attention to August 26th.
Okay.
Can you read to the jury what you see under those USAA records for August of 2022 on August 26th?
Yes, sir. There's a purchase made at T-Mobile Store 136E in Jacksonville, Florida, in the amount of $70.46.
And that's the same date as the factory reset that you testified to on direct examination. Is that correct?
Yes, sir.
Just a moment, Your Honor.
Yes.
No further questions, Your Honor.
Thank you. Any further questions by the state?
Detective Ostertag, the cell phone extraction was performed on a cell phone seized from the person of Mr. Fernandez in March of February 2023.
That's correct.
And if he bought another phone, he still continued to use this one because he reactivated all of his user accounts, correct?
That's correct.
And often, I know Mr. Hill asked you about people resetting their phone when they are going to trade it in. When you factory reset your phone to sell it or trade it in, you don't generally retain possession of it and continue to use it, do you?
No, you don't.
Thank you, Detective.
Anything further?
No, he can be excused.
Nothing further, Your Honor.
Not subject to recall?
No, Your Honor.
Okay. Thank you, Detective.
Thank you, Your Honor.
Let me see the lawyers at sidebar for schedule.
So he made a purchase at T-Mobile. All right, hold on. Let me see if I can figure this out. So he made a factory reset. When did he make that factory reset? August 26th. So he made a purchase on August 25th. So is he buying a new SIM card? Is that what they were trying to insinuate there? We did so Mario did a factory reset August 26th. Let me hear that again.
From the person. Any further questions? For direct examination, is that correct? Any further? Detective Ostertag, the cell phone extraction was performed on a cell phone seized from the person of Mr. Fernandez in February 2023.
That's correct.
And if he bought another phone, he still continued to use this one because he reactivated all of his user accounts, correct?
That's correct.
And often, I know Mr. Hill asked you about people resetting their phone when they are going to trade it in. When you factory reset your phone to sell it or trade it in, you don't generally retain possession of it and continue to use it, do you?
No, you don't.
Thank you, Detective. Anything further? No, he can be excused.
So what was he buying for $70? Is that a SIM card? I don't know. I haven't bought a SIM card, so I don't know. What was he buying at T-Mobile for $70? SIM cards. How much are SIM cards? $8, $9, $9. So he bought more than just a SIM card. They're only like $10.
I'm going to ask that you all push through this will be the last witness for today, and that should get you out early if we just push through and not have a mid-afternoon break, okay? All right, if the state will call its next witness.
The state calls Daniel Hausdorff.
Daniel Hausdorff. With the court reporter?
No, I don't think so.
Okay. Pause the witness.
Yeah, maybe a burner phone. That's the other thing I was thinking about. Maybe a burner phone. Well, he could have bought several things, right? That was like a credit card or debit card or something. So he could have bought multiple things. He could have bought, right? It just said T-Mobile and then $70. He could have bought a couple things. How much are burner phones? $179. Wow, they go from $179 to $11. Oh, that's a pre-owned. Flip phone, $20.
Change of plans. So I'm going to give you a break, 10 minutes. We'll come back. So shorter than 15, but 10, okay? Leave your notepads on your chair.
Well, that stinks. I thought we were going to get out early so we could start our Dwayne Davis early, but change of plans. He could have been paying his bill. Yeah, anything. Could have been paying his bill, maybe accessories. Yeah, who knows? Charger. Yeah, could have been anything. Could have been anything. So, all right. But the takeaway from that was... Takeaway from Mr. Ostertag was... There was a couple things here. There was only 4 messages. So Henry had 2 phones. Actually, had 4 phones, but the 2 phones that were focusing on. There was only 4 messages in that second phone, and they were from January 4th. And then John Biggerstaff's phone had 654 messages. And the first text, though, starts with Mario on May 12th. It's kind of weird. The factory reset. I guess that's the big takeaway from that was that it was wiped. He did a factory reset August 26th. And he went in what, March 1st or 2nd, I think. So he deleted like what, 5,400, 5,200, whatever items, I think the day after he talked to police or the day of, I forget which. But anyway, within, either that day or the next day. And then August 26th, he wipes his phone. Now, that's a 2022. Mario's not arrested until 2023. He's arrested March 16th. And then Shanna's arrested August 16th. So she's actually arrested like pretty much, let's see. Yeah, she's arrested like almost to the day that Mario's trial is starting, which I think is kind of interesting. So, some interesting things came out today. The cell phone being wiped, I think that was pretty interesting. The 5,000 or 52, 5,400, however many, over 5,000 items deleted. No cellular activity during the time of the homicide. Thought that was pretty big. Let's see what else. What are some other big things? Well, besides Shanna and Kirsten, that was pretty big. I'm talking about just testimony here. Oh, yeah, the FBI agent Blythe there had a couple typos in his presentation. He forgot to take the draft stamp off. Oops. But yeah, the typo. So the slide was from March 5th, and it said the call-out date was from February 17th. That was his trip to Pittsburgh. What else? I think those are some of the highlights. Yeah, the no activity between 7:09 and 10:46, basically 7 almost to 11 o'clock. No activity. Again, it's not a crime, but that's right when the homicide, 7:52 is when this homicide happened. So, no communication with Henry in August, but Henry's arrested. So that to me wasn't a big deal. So March 1st, that's when the deletion started. And that's when they were interviewed. Okay, so they were interviewed the same day. So they were interviewed on the same day. And then he communicated with Shanna's dad and her sister while on that trip to Pittsburgh. Again, nothing nefarious, but just interesting. Excuse me. Robot, that's the interesting thing. They showed Dr. John. Detective Johns is going to come, I guess he's going to come back because Miss Butler there said that Detective Johns was the one that dealt with the financial side of things. And he's testified. He's testified once. He didn't say anything. Now he didn't say anything about the finances. He hasn't said anything yet, or in his testimony so far, he hasn't said anything about about the finances. But there was, they recovered processed checks, I guess. I was going to say canceled checks. They weren't canceled. I guess they were processed checks in Henry's truck, in that blue truck. So that's the only little sniff that we've found about these checks, other than the state talking about it. So I still want to see. Them bring that in. I want to see them bring that in, and I would also love to see any kind of evidence that the state has that Henry purchased any kind of lawn care supplies, lumber, shingles. We know that. We know that Mario. We don't know for sure, but they're insinuating, or they're saying that when Mario would come to the Potomac residence, in the bed of his truck, he had tile in the bed of his truck, and that there was some work being done on the bathroom tile. But if he's truly paying Henry to do lawn landscaping, cut down some branches, fix the roof, there should be some kind of evidence that he bought he bought supplies or something. Mia says, I saw the checks being discussed Tuesday, I believe, from the CSI, found the stubs in the glove. Yeah, that's exactly what it was. Yep. So that's as much as we've gotten. We've got this little sniff, a little hint of these checks. And I remember the picture, but that's as far as they've gotten. Yes, I've been saying that, Grampy. Yes, $2,000, $3,000, and $5,000, totaling obviously $10,000. So that is correct. Jane Dixon, want to see Henry's checking account? Yeah, because if he goes from because he was constantly being overdrafted or overdrafted, and he's behind on his, child support. He's not paying rent. He's basically homeless there. Then all of a sudden he's got $2,000, $3,000, $5,000 coming in. I don't know. I want more financial. I want to see the finances. I want to see the forensic accounting. Excuse me. Erin's saying she's 99% sure the checks came from Mario's property company. Kathy says supplies could have been concrete for hiding. All right, William. That's not a command, but I like it. Exclamation point, driving home. Yeah, Brad, it's like Robert Tellis, if you guys don't know him, out of Las Vegas. We covered that trial. It's like Tellis, if your phone is unusually static during the entire window in question, it's not a good look. Especially because you're using it constantly or a lot, and then all of a sudden, radio silent, and then all of a sudden picks up afterwards, then you know something is up. Debbie, thank you. You keep on gifting the. Oh wait, what's this? Aaron found it. All right, good job, Aaron. Thank you for that. Aaron is fantastic at this. All right, let's see. These hitmen need to get paid up front. Tell the husband and wives requesting hitmen services to take out a second mortgage or borrow it from their parents, but full payment up front. All right, here, check this out. Thank you for finding this. All right. So First Choice Rentals, LLC. Oh, wait a minute. Is that okay? So there's a $5,000 check. This is the Kickstarter. All All right, so there's Mario. That's the Kickstarter. Good luck. That's the one for 5,000. So that's April 4th, 4/4/2022. All right, so First Choice Home Rentals LLC is an active Florida limited liability company filed on March 29th, 2019. State corporate records list Mario Fernandez and Guillermo Fernandez as authorized personnel tied to an Orlando address. The entity has surfaced in public records and investigation. See, I don't know if I can, let me see if I can, let's see here. I can at least take a screenshot, but let me try this. See if I can zip around in this. All right, so here's his he and his brothers. I can't trying to, let me see. Reject all. I can't browse. I can't browse around, but this is their rentals. Pretty nice houses. Right? I mean, these are pretty nice houses. So this is what I assume his brother now is running, because this is what they used to. This is what Mario. Condo rentals, $200 a night. I mean, it's a lot of, I can't scroll unfortunately, but pet-friendly rentals. I mean, these are pretty nice houses. So just make sure they're not coming back. So these are St. Augustine vacation rentals. So it's basically just St. Augustine. Even though they're based out of Orlando. All right, looks like they're coming back.
Thanks, Riley. Defense is ready, Your Honor. Just prior to the jury coming in, as we mentioned, there were some additional materials we received earlier this week, and by agreement of the parties, we will have a one-page AFTE General Rifling Characteristics database document marked as Defense 60.
No objection. Okay. It'll be so honored. Anything else?
That's all.
Okay. Let's bring in the jury. It's freezing in here, isn't it?
It's going to.
I'm finally freezing. I'm finally cold, Melanie. They did it. I'm like shaking. Warm it up a little bit.
What's called?
Mike.
Yes.
Get a hold of Eve, like bump it up. It's freezing in here. Cold? Yeah. I'm like, they finally did it. I'm cold. Maybe.
Your Honor, the accused are entering the courtroom.
Thank you. Welcome back in, members of the jury. Everyone may be seated. Mr. Mizrahi, call the next witness, please.
Daniel Hausdorff.
Daniel Hausdorff. Good afternoon. If you please raise your right hand to be sworn in.
Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, this way, please. Watch your step.
Thank you. Good afternoon.
Good afternoon. You may proceed.
Please, the court. Please introduce yourself to the jury.
My name is Daniel Hausdorff. My last name is spelled Hausdorf.
What do you do for a living, sir?
I am a crime laboratory analyst in the firearms section at the Florida Department of Law Enforcement.
How long have you been so employed?
About 13 years.
Explain to the jury briefly about your educational background and training experience that allows you to perform those duties.
Yes, sir. I have a bachelor's degree in biomedical science from the University of South Florida. I was hired at FDLE as a forensic technologist in the firearms section, and I completed the 6-month training program for that position, and then was at an FT for about 3.5 years. I was then promoted to analyst and completed the training program in August of 2018, and I've been an analyst since.
And has that educational background and training experience allowed you to come into courts and give your opinion as to your expertise in your field?
Yes, sir.
At this time, I would turn to the witness for voir dire as an expert in firearms identification.
Any questions?
No, Your Honor.
Okay, thank you. You may proceed.
So let's give the jury a little bit of an education of what you kind of do every single day about firearms and how you're able to compare components of a cartridge to each other and then to potentially guns.
Sure. So a basic day of what I do is I compare cartridge cases and bullets microscopically to determine if they were or were not fired from a particular firearm. I also perform firearm function testing, serial number restoration, and imaging cartridge cases into our database. The way that I would compare bullets or cartridge cases to each other is I would use my comparison microscope. It's 2 microscopes joined by an optical bridge that allows me to view 2 objects at the same time under the same magnification. So what I'm doing is I'm putting one cartridge case on one side, another cartridge case on the other side. I'm comparing those 2, overlaying those images on top of each other, and I'm looking for a repeating pattern that's coming from the firearm during the firing process. I use the exact same procedure for looking at bullets. If they have the same pattern, I would determine they were fired from the same firearm. If they don't, that's when I can eliminate from the same gun.
Explain to the jury how a firearm manufactured by the same firearms manufacturer at the same period of time, can those individual firearms be distinguished from each other?
So when a firearm is being manufactured, the way that those unique characteristics are imparted to the firearm are during the manufacturing process. If you think about the barrel itself, it's going to have to be drilled, it's going to have to be reamed, it's going to have to be rifled. All of those tools are creating an immense amount of pressure within the barrel, and they're forming what's called chip formations as it's removing or displacing the metal. Those chip formations are creating unique microscopic imperfections within the barrel and various other parts of the firearm itself. And those unique surface imperfections are being imparted to the bullet or the cartridge case during the firing process. The barrel or other various parts of the firearm are harder than the metal is used for cartridge cases and bullets. So those unique imperfections or scratches are going to be transferred over to those components. And I'm looking at those on the scope to determine if they have the same pattern as test fires that I would create or multiple pieces of evidence that I would compare to each other.
So is this scientifically accepted in the community?
Yes, it is.
Make these kind of comparisons?
Yes, sir.
For how long has various laboratories been doing this kind of work?
Over 100 years.
Is it replicatable or replicable? In other words, other labs could do the same work and go behind you and compare what you've done?
Yes, sir.
Okay. So let's turn directly to your work, and you have your file up there with you?
Yes, sir.
FDLE number 2026-1946. You've reviewed that?
Yeah, 2026-040-1946. Yes.
040 is just to go to the, okay. You did not get a firearm in this case.
No, sir.
All right, let's go through what you did. And you briefly mentioned this. Explain to the jury how cartridge cases, how they come to be in a particular scene, and then how they're different from projectiles.
So a cartridge case and a bullet are two parts of a cartridge. A cartridge is a single unit of ammunition. The cartridge case is the body of the cartridge. There's the projectile, which is propelled down and out the barrel of the firearm by the explosion caused by the firing pin hitting the primer, which is the third component, creating a spark to ignite the gunpowder, which is the fourth component in the cartridge. When a gun is fired, that cartridge case is typically, in a semi-automatic firearm, automatically extracted and ejected out of the firearm. The bullet is propelled down the barrel and out the barrel of the firearm.
When a cartridge case is expelled from the firearm, do they typically go in a pattern that is similar?
Not typically, no.
So they go out of the firearm and they can kind of bounce around and go anywhere?
And depends on how you're holding the firearm and where you're shooting from, a lot of different variables, yes.
And I know the jury's probably seen this from movies and things, but when the cases get expelled from the firearms, are they going hundreds of yards on their own?
No.
So they're going to be in the general vicinity, but you just don't know exactly where.
Correct.
So then once you can compare those cartridge cases to each other to see if they're fired from the same firearm, how about the projectiles? Can you compare those projectiles to the actual casings?
No, sir.
Explain why not.
So when the cartridge case expels the bullet from the firearm, any markings that would be left behind from the bullet being removed from the cartridge case are going to be overwritten by the markings that are left behind from the barrel. So there's nothing for me to compare it to.
Okay. So there's kind of two different components when you have a case where you have projectiles and casings. Is that fair?
They're basically a separate entity when I don't have a firearm to compare it to.
Okay, and in this case you did.
Correct.
So let's go first with the casings. Were you able to perform any analysis on the 4 10-millimeter casings that were provided to you?
Yes.
How do you know they're 10 millimeters?
They have 10 millimeter written right on the head stamp.
Is that a clue?
It's a very good clue.
Did you also notice other things that made it indicate it was a 10-millimeter shell casing?
The size, the diameter, and everything that goes along with the 10-millimeter cartridge case, yes.
Were you able to microscopically compare each one of those 4 casings to determine whether or not they were fired from the same firearm?
That's correct, yes.
And were they?
Yes.
They approached the witness.
Yes.
I'm showing you what's been entered into evidence is State's Exhibit 88A, B, C, and D. And I just want you to look at those and make sure that those are, of course I mixed it up. There's 88D, 88C, 88A, and 88B.
Okay.
Are those the 4 cartridge cases, 10-millimeter cartridge cases that you compared to each other?
Yes, sir.
And that they all matched?
Yes, sir.
And may I publish those in actual display form here? Right?
Yes.
So I think you can remain there, Mr. Hallstorf. But when we talk about the shell casings, we're talking about the pristine cylindrical cartridge cases.
Yes, the 4 on the left there.
Pointing to it here. We see other things that are more damaged. Is that going to be the projectiles?
In this case, yes.
Okay. Is it common to have your projectiles be somewhat damaged and have your cartridge cases be pristine?
Yes.
And I guess that's obvious. Why is that?
Do you want to use that table over there?
No, I think the jury can see it from here, if that's okay. I'll move it before Mr. Dresser gets up. They can all see it from there. If that's okay with Your Honor?
Yes.
We'll do these two. I forgot what my question was. Why? Why do they get damaged?
Typically on what they hit, obviously it's going to be something harder than what the projectile is. If it hits a person, car, wall, it's going to create damage to that projectile.
In identifying those 4 cartridge cases, were you also able to make an opinion as to the class characteristics of those cartridge cases?
Yes, they are typically fired in a Glock firearm based off the type of class characteristics that are left behind on that cartridge case.
So can you say 100% it's a Glock?
No, sir.
Okay. But it's just
Consistent with. Yes.
So all four of those, they're all 10 millimeters 100% though?
100%, yes.
And it matches or is consistent with a Glock?
Yes, sir.
Now, did some of the projectiles that you were given, were they too damaged for any type of evaluation?
Yes, they were.
And describe, is that common?
It is common depending on the evidence that I receive. Sometimes there can be a fragment of the projectile that breaks off. It might not even be a part of the projectile that was even in contact with the barrel. It could be something inside the core of the bullet itself. It could be too damaged to have any of the markings from the firearm still be on that fragment or projectile. All of those things can inhibit my analysis to what I actually can see.
Okay, so I guess we'll start with the stuff that's inconclusive and then go to the conclusive things with regard to the projectiles.
Okay.
So I think there were three different things that were, I guess, either inconclusive or had no value for microscopic comparison. And the no value for microscopic comparison was items 7B and 8.
That's correct, yes.
And then the items that were inconclusive were items 5 and 7A.
That's correct.
Let's just have a look at those so the jury can see what you're doing. First of all, the ones that just had no value are going to be State's Exhibit 93A. Is that accurate?
As far as 7B on this one, yes, sir.
A. So it kind of just looks like a hunk of metal. Is that fair?
Yes, sir.
And then States 93B and 89A were those the ones that were not, they were inconclusive.
Number 5 was inconclusive and number 8 was no value.
Thank you, sir.
Thank you.
So you were able to take two projectiles and actually match them to each other.
Yes, sir.
And what were those two numbers?
Those were items 6 and 9.
And I'm showing you what's been entered into evidence as State's Exhibit 89B, which corresponds to number 6, and State's 93C, which corresponds to 9. Am I accurate in that?
Yes, sir.
So let's show the jury in 93C. It actually looks a little beat up. Is that fair?
Depends on what you're talking about, but yes.
So, but microscopically, it had information.
Yes, sir.
So you were able to compare 93C and match it to 89B. Which is going to be at the bottom. And what determination were you able to make about those two projectiles?
That they were identified to each other, which means that they were fired in the same firearm.
Were you able to make any determination based on class characteristics and rifling characteristics about the type of firearm?
Yes, they are also consistent with a Glock type firearm.
Are you able to conclusively say that those projectiles are 10 millimeters?
No, sir.
Why not?
Based off of the weight and the characteristics, they're not indicative of a 10 millimeter because they're going to have the same base diameter. Or sorry, they're not going to be indicative of an exclusive 10 millimeter because the base diameter is the same as a 40 Smith & Wesson, and the weight wasn't high enough to eliminate from a 40 Smith & Wesson.
But they absolutely could be Glock 10 millimeters.
Yes, sir.
And you did not receive any Smith & Wesson 40 caliber shell casings in this case at all?
No, sir.
So if the projectiles are consistent with a 10 millimeter and all the casings are 10 millimeters, is it consistent that this was a Glock 10 millimeter firearm?
Based off the cartridge cases, yes, and the projectiles by themselves are 40/10 millimeter, but it does have a potential for having a Glock 10 millimeter firearm, yes.
Well, he doesn't know that. Anything else? That's all the questions, Your Honor.
Thank you. Cross-examination.
Briefly. Good afternoon.
Good afternoon.
The report that was referenced from July 30th, 2026, did you author that report?
Yes, sir.
Who provides the information to you as far as case information, meaning what it's related to?
It's provided by the submitting agency.
And who is the submitting agency in this particular instance?
It was Jacksonville Beach Police Department.
And I see you referencing something. Are you referencing that report?
Yes, sir.
Okay. And can you tell us, it says attention. Who is that attention to?
Chris Johns.
Okay. And do you know who that individual is?
No, sir.
Your understanding is he may be affiliated with the Jacksonville Beach Police Department?
Yes, sir.
Okay. And then under victims, can you read who's listed there?
It's Jared Bridegan.
And I'll represent to you that it's pronounced Bridegan.
Right. Okay. Yes, sir.
And then under subjects, can you read the names listed there?
Henry Arthur Tenon, Shannon Lee Gardner, Mario Enrique Fernandez Saldana, Jimmy Clay Jones.
Okay. And those are not names that you came up with, correct?
No, sir.
Those were names submitted to you by the Jacksonville Beach Police Department?
Yes, sir.
Okay. Now, you didn't do any DNA testing or anything in this case, correct?
No, sir.
Just simply, you tested the projectiles and the casings that Mr. Mizrahi went over with you?
That's correct.
Okay. And if I understood your testimony, because of the absence of a firearm for you to evaluate, you can't make any solid determination of which model of Glock actually discharged those projectiles and ejected those casings.
That's correct. I cannot determine that, no.
But your closest determination based upon the characteristics from the projectiles and the fact that the casings are 10 millimeters, you would believe it's consistent with a Glock manufactured firearm.
Yes, sir. That's correct.
And is it your understanding there are 3 different models of 10 millimeter Glocks?
Yes, there is.
Okay, there's a Glock 20, and I believe that's considered like the original flagship 10 millimeter.
That's their full size, yes.
And that's been in production since 1991.
I'm not sure the exact year, but that sounds approximately right.
Okay. And then there's also a Glock 29.
Yes.
Okay. And I believe that's been in production since 1997. Does that sound about right?
Sounds about right, and that's the subcompact.
Okay. And then a firearm that has been referenced in this case is a Glock 40 Gen 4. Is that also a 10 millimeter you're familiar with?
Yes, it is.
And I believe that's been in production since 2015. Does that sound about right?
I'm not sure the exact year again, but it sounds about right.
And in 2022, or specifically February 16th of 2022, would you anticipate all 3 of those models were still in circulation?
Yes, that's correct.
And I understand that there are subsequent generations of firearms, like a Gen 5 or a Gen 6. But these 3 that I just recited to you, you would understand those would have been available February 16th of 2022.
Yes, sir.
Okay. And I understand that from your testimony, you can make no opinion as to which model of those Glocks we just talked about would have discharged those particular projectiles.
That's correct. I cannot do that.
And you weren't asked to provide any type of determination of who would have discharged those projectiles?
No, sir.
And you certainly weren't asked to draw any conclusion of who would have been responsible for this particular offense?
No, sir.
This seems like a somewhat of a common sense question, but being that those 3 particular models of Glock have been in production, 2 of which in the 90s, 1 in the 2000s, would it be fair that Glock is one of the most popular gun manufacturers in the country?
It is one of the most popular, yes, sir.
Utilized by many different law enforcement agencies?
Yes, sir.
And not necessarily the 10 millimeter, but that manufacturer is a for-profit business.
That manufacturer is one of the most popular firearms, yes.
Something that you see a lot of?
Yes.
Fair to say that there are thousands, if not tens of thousands, of those particular models of firearm?
That's fair to say, yes.
May I have just a moment, Your Honor?
Yes.
No further questions, Your Honor.
Any follow-up?
Yes, Your Honor. I know defense counsel was clear about the fact that Glock makes lots of other firearms in addition to a 10 millimeter.
That's correct.
What are their most popular calibers?
Most popular, in my opinion, would be 9mm Luger or 40 Smith & Wesson.
The 10 millimeter is less popular than that.
Correct.
Okay. I want to talk a little bit about the timing of everything, and we've kind of glossed over that. When you do your work, does it take time?
Yes, it does take time.
Do you have a lot of work to do?
Yes, sir.
When the jurors may be familiar with TV programs where you get ballistics reports in about 10 minutes during a commercial break. Is that real life?
It's not like real life, no, sir.
And in this particular case, you got the submission to you to analyze this in April of 2026?
I believe so. Let me double check.
Yeah, check that.
Yes, sir.
And your report's dated July 30th of 2026?
That's correct.
Is that kind of a typical turnaround, or is that a little quick?
That's about the same time. Depending if it's a rush case or not, we might prioritize the case sooner. In this case, it was given to me just before July, actually. I think right around about that time.
And so is that kind of time frame true throughout FDLE? In other words, it takes you all time to do your work?
Yes, sir.
That's all the questions I have here.
All right.
Nothing further.
Okay. May this witness be excused?
He is excused, Your Honor.
All right. Thank you so much.
Thank you, Your Honor.
We're good for the 8:30.
Okay. Members of the jury, we're going to conclude the evidence for today. I want to, again, thank you for your time and your attention in this trial. This is our first kind of longer break since the evidence has been started in the case, and I feel that it's important that I remind you, I know that you've been very vigilant about following the rules. It's important that you follow the rules over the weekend's recess. We're going to return back again on Monday to keep taking evidence. So if you leave your notepads on your chair, we are going to get you out of here early so you don't get caught up in Jaguar traffic, hopefully. Thank you again for your time, and I'll see you on Monday.
Cool. So they were an hour late yesterday, hour early today. So it sounds like the Jacksonville Jaguars have a game tonight.
Great. Please let the record reflect the jury's left the courtroom. Everyone may be seated. Officer Lim, juror number 4 has her pad turned up and with the notes open. Can you turn it over? Any others like that? Okay, thank you. All right. My understanding is that we were going to do a proffer. Is that correct? Do you need a second to get situated?
I'm ready. We're just waiting on the witness.
All right. So we'll just be in holding pattern.
I was supposed to let Woody know with enough time, and
okay.
I got busy doing a witness.
All right. No problem.
Look at this. The parties are just getting along here.
You're getting along?
Getting along soon.
I love when y'all get along.
We do too, Jet Skype. We love when the parties get along. All right, so they're going to proffer. They're going to have a proffer of a witness. Oh, they're playing the Steelers tonight?
What?
Let's see.
Your Honor, state calls Javel Pond.
Wait. Let's come over here.
I get sworn in.
Right.
Javel Ponder, Your Honor.
Mr. Ponder, if you'll raise your right hand best you can and take the oath.
Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
All right. Sir, come over here and make yourself comfortable, okay? Can I see the lawyers at sidebar just momentarily before we start?
who is this? Yeah, who is this? Who is this interesting looking individual and his inmate, Sarah Boone inmate? He is dressed in his Sarah Boone inmate. He's got his inmate. Yeah, who is this? Who is this? Pond, I think they said it. I gotta catch his name again. Some kind of what's his name here?
From the testimony.
Right.
I get sworn in.
Wait. Yes.
Your Honor, state calls Javel Pond.
Wait.
Javel Pond. Javel Pond. Javel Pond? Well, hopefully he'll spell his name. Javel Pond. Who is Javel Pond? Yeah, jury went home. Jury's gone. They've been sent home for the weekend. And this is a proffer by an inmate. So he's been convicted already. This isn't somebody waiting jail. This is somebody who's been convicted.
May it please the court?
Yes.
Mr. Ponder, are you able to pull your mask down for us?
Like all the way down?
All the way down so we can hear you good. The jury's not here, so you can kind of be at ease, but I need to ask you a few questions, okay?
Yes, sir.
So obviously, I'm going to kind of lead you through some of the background stuff so we can get to the meat of it. You're in jail, correct?
Yes, sir.
And you are an 8-time convicted felon, and you have 2 crimes of making a false statement.
Yes, sir.
And you have pending a number of different charges, including trafficking in MDMA, aggravated fleeing, tampering, another fleeing, and 6 counts of child abuse.
Mr. Mizrahi, why is that important? And just get to it.
Mr. Dresser and I discussed that. We put some of that on the record, so he didn't have to cross on those things.
Why would you for this one?
Those are the.
Can we please get to it?
That was the extent of my questions, Your Honor.
All right.
I did that, so I did. I want to talk to you. Do you know who Mario Fernandez is?
Yes.
You see him here in court?
Yes.
Say where he is?
Yes.
Where?
Oh, over there.
The record.
Voice up so I can hear you, please.
Keep your voice up. Sit up straight. You can face up.
I was trying to put the thing closer to me. They said no.
Okay. Well, pull your body.
I can't. That's why I was trying to put it.
Officer Combs, help.
Thank you, Mr. Ponder. So I want to turn your attention to the summer of 2024. Were you in the Duval County Jail with Mario Fernandez?
Yes, sir.
Explain to the court how you went about meeting.
Came to jail. They put me in 4 East. Put me in the dorm with them. 4 4.
Okay. And you were were you in the same cell?
No.
Were you in the same dorm?
Yes.
How did you become to talk or know or converse with the defendant?
I think I brought commissary from my first week. That was my first few days though.
How can you describe for the court your position, for lack of a better word, in the jail? Are you a man of some consequence within the jail?
Yes.
Explain that.
The best.
You can explain it. There's no jury here. You can explain any way you want to explain it.
It's just zero tolerance. I don't see gang members, Christians, Muslims. Anybody can.
All right, let me ask you something more direct. Do you know how to fight?
Yes, sir.
Are you considered relatively a tough guy in jail?
Yes, sir.
Do people listen to what you have to say?
Yes, sir.
And that's your own opinion. Is that fair? Or do other people tell you that?
Other people tell me that.
Okay. So describe for the court when the defendant first started talking about his own case.
Well, I can't remember the specific date. I'd be lying to say that. I could just say the first time, I guess something went in favor in court. And he said, yeah, y'all beat.
Say that again so she can understand you.
He's very hard to hear. Mr. Ponder, please. Okay. So we don't have to keep doing this. Yeah, I think you're okay. Just
hold it like this, right? Up straight. So can you ask the question?
What's the first thing the defendant said about his case?
Oh, he had y'all beat.
Then what did he say?
All right after that.
Just tell us everything you remember about what he said about the case.
Like, cause we gotta be. People talk a lot, so we talking about in general, or we just talking about one time only, like everything throughout the whole entire time with me knowing Mr. Mario.
Everything that came out of his mouth that's relevant to this case into your ears.
Oh.
Not through hearsay, not through other people, his mouth to your ears about his involvement in the murder of Jared Bridegan.
All right, so boom, one day we were all playing poker at the table. That's when the paper dope was kind of popular in the county jail. I don't know. I got to explain what paper dope is?
No.
Okay, so boom, a spider was trying to get some coffee for him to make the smoking paper. They put the coffee in the brown napkin and they smoked. So they was all in the room talking. I come in the room. So they say from what I hear, and then from when they involved.
His mouth to your ears about what the defendant said about his case.
See, that's what I'm trying to ask. Do I say what he told another individual while in the room?
If you heard it, yes.
That's what I'm asking. Okay. Okay, so he was telling Spider about his case. The first thing he said was, wait. Oh, okay, I ain't know if I would. First thing he said was, it was Shannon wanted to put a rape case on the dad. I don't know the dad name.
Okay.
So, boom, he said that shit ain't gonna work. It's only gonna be temporarily. Blase squaze. Then I'm sitting down on the bed. He said, I wish I knew some niggas like him.
Like who?
Me. So I said, man, what you mean by that? I said, what you mean by that? He said, nah, all I'm saying is, if I don't know you on the street, I know this shit would have got did the right way.
Okay.
So.
Did you take it? So what else did he say?
So after that.
Did he say who he had hired?
Oh yeah, I was finna get to it.
Okay, just go.
All right. Y'all be asking highly educated, simple questions.
All right. This is on you, Mr. Ponder. Keep going.
All right. So, boom, after that, he was saying he never wanted Mr. Heron to do it. He was too old. Mr. Heron supposed to have nephew. My bad. Y'all told him to go. So.
We're down.
Okay.
You said Mr. Henry?
Yeah.
Okay. Keep going.
What? Okay.
He was saying he didn't want Mr. Heron to do it. Mr. Heron's nephew was supposed to do it. Mr. Heron's too old, but Mr. Heron played. His nephew never came through, so Mr. Heron ended up doing it and fucked it all up. That's how he in jail.
Did he say anything about that his wife did not want the kids caught in the crossfire?
Oh, yes, sir.
What did he say?
Oh, see, that's why we're trying to make sure. When he said that part, he was saying that she didn't have a problem with, I don't know his name.
Her ex.
Her ex getting killed. She just didn't want her kids caught in the middle.
And did Mr. Fernandez tell you why this was done?
Why it was done?
Why his wife wanted the victim killed?
See, he never told me why they wanted them killed. All I know is she didn't want the kids around him. She didn't want the kids with the dad.
Is that what the defendant told you?
Yes.
That Shanna, meaning his wife, didn't want the kids around their dad?
Yes.
Later, did you, and this is back in 2024?
Yes, sir.
That's all the questions.
Okay. Could I clarify? It didn't come up on the transcript. To me, I think that might have been important. Did he say something about Shanna wanted to put a rape case?
Yes, repeat that again if we missed it.
Yes, she wanted to put a rape case against the dad.
Against the dad?
Yes.
Okay, that's what I missed.
That was her idea.
And what did Mr. Fernandez say about his wife's idea to put a rape case on the dad?
He said that shit won't work. It would be only temporarily.
So whose idea was it to kill the victim?
Oh, Mario.
Okay. All right. Cross. No, so just the admissibility issue, his credibility, I don't weigh. As a judge, I don't weigh his credibility.
How is anything he said different than what Mr. Mizrahi proffered to you, and you've already made a ruling? That's what Mr. Mizrahi told you, in effect, he would say. And you've already ruled on this issue.
So my understanding...
I don't disagree with that, but I couldn't, in theory, I would not be able to cross appeal based on my proffers to the court. This is the way you have to preserve an issue on appeal. Now, certainly the court...
Okay, let me have him step. Are you crossing on... So what I left open was the time, date, manner in which the statements were made, the actual statements. I don't think I had any particular statements.
Correct. And
so
I'm sorry.
You did.
I read the order for the open-endedness had to do more with AB and whether or not there was a ability.
Let me pull up the order. Let me have him step in the back. I don't make credibility findings on witnesses.
In that, but you've already ruled that it's not that this case was not about. I would really ask that the order be reviewed. I mean,
I'm doing that now, Mr. Dreiser.
I know.
Wow. So boom. This witness is going to be the boom. So boom. Wow. So judge isn't going to put much weight on his credibility. She just wants to know the time, date, and manner of the statements. So if you go off of that, Mario came in talking about Shanna wanted to put a assault case on Jared. Mario said that's only going to be temporary. So basically, he said Henry was too old and he messed it up. They wanted to get the nephew. They wanted to get the nephew to. Let me close this. They wanted to get the nephew to do it. Is what I got from that. He wanted to get the nephew to do it. Henry was too old and he effed it up. Big Bill, kaboom. Did he say kaboom or did he say so boom? Kaboom. He's the kaboom. Did he say kaboom or saboom? I thought he was saying so boom. Wow. So she's reading her ruling right now. She already made a ruling on this. And she's reading her ruling on it. Yeah, wanted Henry's nephew to do it because he's too old and he effed it up. That's basically it. So boom, yeah, I heard so boom. So boom. So boom. Now we need a boom. We need a boom emoji. Isn't that like a firework? Isn't that like a
All
firework?
right, so the order that was filed that was titled Order Granting Defendant's First Motion in Limine to Prevent the Introduction of Hearsay and Impermissible Testimony, docket line 622, references the statements made to Kim Jensen. And then I pulled up the other one, relates to AB. I don't think that I covered Ponder. And like what I was isolating was Jensen, which were statements that were communicated, and Ponder, I don't believe I covered, and I'm prepared to make a ruling if y'all want.
And I think we've gotten wayward here.
You go in, Alga.
Mr. Ponder could be called if the state chose, and he could say what he just said. I agree with that. I'll say for the record that no human being on planet Earth would believe him, but he could come into this courtroom and say that if he wanted to. What Mr. Mizrahi is doing, and where we're circling back to the orders, is that he is trying to attempt to use what Mr. Ponder said in court today to get you to reverse your ruling about what Kim Jensen can say. That's the purpose of the proffer, that now all of a sudden they've broken the privilege between Mario and Shanna Gardner. That's the purpose. And I'm saying I don't expect that your ruling is going to change. You made a very clear order that that privilege applies and that there is no abrogation of child abuse in this particular case under these particular circumstances with the abuse of their own, not their own children, the children of Shanna Gardner, meaning AB and LB. Does that make more sense?
Yes.
I'm sorry.
Okay.
That wasn't clear.
We're in agreement. I don't think Mr. Dresser needs to cross. I want to preserve for the record that we have evidence directly from this defendant that states that the purpose of the killing was to stop the victim's child custody over the children.
Okay.
Our theory goes to child abuse from Jensen.
Mr. Mizrahi, that could have been asking like 3 questions instead of all that. Like, I thought you were asking about his entire statement.
In fairness, okay, I mean, my fault.
Okay. All right.
So
my ruling stands.
Yeah.
Okay.
I would like, the state is planning on calling this Jensen tomorrow as well. I mean,
Monday for the proffer? For the proffer.
Yes. At 8:30. And I will not ask any preliminary questions.
Thank you. Right there. That's what a proffer is. Okay. Thank you. Court's adjourned.
All right, that's it. Wow, they cut that off immediately. Hold on a second. Let me see if I can rewind that just a bit.
I'm calling this Jensen tomorrow as well. I mean,
Monday for the proffer? For the proffer.
Yes. At 8:30. And I will not ask any preliminary questions. I'll go right to it.
That's what a proffer is. Okay. Thank you. Court's adjourned.
Wow, she is way different than she was this morning. Judge Kite is 100%. That's like a 180 degrees. This morning she came in with her hair and she looked all flustered. Look at that face. Look at that smile. My goodness. We got to rewind that. I got to rewind that.
Okay. All right. My ruling stands.
So Kim Jenkins is coming in.
The state is planning on calling this Jensen
Monday.
Tomorrow as well.
Wow.
I mean,
Monday.
That's going to be good. That's going to be
good.
For
the proffer.
Yes. At 8:30. And I will not ask any preliminary questions. I'll go right to it.
That's what a proffer is. Okay. Thank you.
Come on, look at that smile.
Court's adjourned.
Yeah, 180 degree difference from when she came in this morning. Aw, go have yourself a nice adult beverage, Judge. You earned it. You earned yourself a nice adult beverage. What a day. What a day. Wow. So boom. What a day. All right. So Mr. Ponder there came in and basically said Mario told him that Shanna was going to put an assault case on him. And then Henry was too old and he messed it up. They were going to ask the nephew. So she's smiling. I dare you ask another question. Yeah, beautiful smile. Let's rewatch her laughing at the witness again. Oh, I know. Some. I took some pictures of that. She was just like, what? She was just like, she's just like, dude, just come on. All right. So Kim Jenkins, that's the friend of Shanna, and I don't know if you guys have seen it, but there's an interview with law enforcement out there, and she. And there's even text messages of her and Shanna like kind of talking about deleting Jared well before Mario came on the scene. So yeah, Kim Jenkins, right? Is that how? Yeah, Jenkins. She's still a player in this. I don't know where she's going to fit into all of this, but she I don't think she's a fan of Jared. If you know, we wanted to show that. We wanted to show that so bad. And we asked the creator who has their hands on that, and they said no. But we're hoping we can get. If we can't see it, just go out and look. Just Google like Kim Jenkins video. Yeah, she kind of tells the history, and she's not too flattering of the Bridigans. So is it Jensen? Okay, Jensen. Yeah, Jensen, not Jenkins. Jensen. Thank you, Jensen. So Kim Jensen is going to have a proffer. Hopefully they'll show that. Ooh, I hope they show that. We will be ready. We'll be ready at 8:30. We'll be ready. Yeah, back in time for it to end. Yes. Yeah, horse welfare. This truly. All right. We're going to wrap it up here. I have a redirect for day 2 afternoon for Keefe D. So if you guys have not watched that, definitely come and check that out. I have that. I'll set that for. I'll do it for 45. I'll do it for 5 o'clock. I'll probably go on a little bit earlier, but I have a redirect set up already. So. All right. Thank you guys for joining us. What an amazing day. Wow. Aaron made a short of what happened and a video of what happened today with Kirsten and Shanna. So if you haven't watched that, if you want to see that, go check that out. And Monday, again, this trial it's developing more and more and more. And that's what happens with trials. In this trial, you know, it's had its slow moments, but I would say by and large, it's had its like wow moments. You know, it's only going to get spicier as it gets closer to the to deliberation. Shanna's trial, as we know, is definitely going to be something to watch. I will be in the court there next week, maybe Wednesday or Thursday, depending on when closing statements are. I'm sorry, closing arguments. So I will be there and hopefully catch a verdict for you guys. But wow. So anyway, all right. We're going to go watch the Dwayne Davis Keefe D trial. Super Bowl's over there being all relaxed, so I'm not going to disturb her. Although this little peanut here, look at him. Little dude, man. So my little Rafa over there. So all right, I'm going to take a little break, get set up back here, and we will be back to watch the afternoon session of day 2 of afternoon for Mr. Davis. So with all that being said, thank you guys for joining us. Really appreciate it. Thank you for all the super chats and the memberships and just watching with us. You got us to 335 likes, so really appreciate that. Thank you. And we will see you, if not over at the Keefe D stream, then have a great weekend, and we will see you Monday. I'm going to be here at 8:30. We'll be here at 8:30 just in case they show that proffer. Because I definitely want to check that out. So with all that being said, have a fantastic rest of your weekend. Oh, what am I saying? We will be streaming over the weekend. Oh, and Florida PI Sam has a stream 6:15, I think, tonight. I'm sorry, Saturday. When is her? She's 6 o'clock. 6:15. So Saturday, 6:15 stream with Florida PI Sam. She's just going to be talking about herself, what it is to be a private investigator in Florida. She has been on the defense team for Davion Murphy, Charles Jones, also Sonny Bell. And so come and join us, 6:15. We will be there. And then Saturday, we will be streaming. I might stream Saturday too, but maybe for just a couple hours, if I can squeeze in a couple hour stream, just to kind of get caught up on Keefe D. So those are some programming notes. So if we don't see you here, we don't see you at PI Sam over the weekend, please join us then on Monday. All right, you guys, have a great one. Take care. We'll see you. Bye.